Which were? It's not our roster.
Adjournments.
We are not holding the roster.
Sorry. Adjournments. List number 1.
2 days ಅಲ್ಲಿ ಇನ್ನೊಂದ್ ಸ್ವಲ್ಪ confusion ಆಗುತ್ತೆ.
Page 1, seal number 1 to 3. Page 2, seal number 4 to 7.
Serial number 5, for number 1.
Respond.
Admission, my lord, we are ready.
Respond.
We have not received the copies.
Correct, it's only for admission. You can consider it, then you can. Yes, next.
Page 3, seal number 8 to 13.
Lord, serial number 8, my lord. Request for week's time, Lord. I have not received the paper book.
There are
Hello.
4 matters.
400 ನಂದೇ ಎರಡು appeals ಅವ್ರದ್ದು announcement ಹಾಕೊಂಡು. Next week ಅಲ್ಲಿ ಮಾಡ್ತೀನಿ. Paper book is not received so.
2017. ಈಗ ನೀವು ಮಾಡ್ತೀರಿ ಅಂತ ನಿಮ್ದು ಒಂದು ಓದ್ಕೊಂಡು ಬಂದಿರ್ತೀರ.
Sorry, my lord, the paper book is not there.
Generally, he will be ready, Mr. Pradeep.
Pradeep ready. Serial number 12.
Next week, my lord.
Requested by response sponsor list on
8.
8.
Serial number 12.
8-4.
Appearing for the state, my
In
lord.
this case, my lord.
My lord, needs in this case,
ಅದು ನಿನ್ನೆ ನೀವು ಶಾರ್ಟ್ ಮ್ಯಾಟರ್ ಮುಗಿಸ್ಬಿಡಿ ಅಂತ ಹೇಳಿಲ್ಲ.
just the days the accommodation
You are for whom?
for the state.
State.
Serial number 12.
Respondent to contesting.
2018.
Yes, my lord. Matter might be taken up on Wednesday.
ನಿಮ್ ಪರವಾಗಿನೂ ಅವರೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡ್ತಾರೆ ಬಿಡಿ.
My lord, need to, in the evidence, my lord, the victim has stated that she is married to the accused, my lord. Need to ascertain whether she is really married.
Right, we have to decide what was the position as and the victim, he represents victim. Yes.
Page 4, seal number 14 and 15.
Yeah.
List number 2.
ಮಾಡ್ಬಿಟ್ಟ ನೋಟ್ಸ್ ಮಾಡಿದ್ದೀನಿ.
Respond. ನಾನು ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರುತ್ತೆ ಬಿಡಿ, ಅದೇ ನಾವು ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ನೋಡು ಇದೆಲ್ಲ ರೀಚ್ ಆದ್ರೆ ಇವತ್ತು ಇರೋದು ಹಾಫ್ ಡೇ ಲಿಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಮ್ಯಾಟರ್ ಲೆಟ್ ದೆಮ್ ಬಿ ದೇರ್. ಇಫ್ ಯು ಆರ್ ನಾಟ್ ದೇರ್ ವಿಲ್ ಟೇಕ್ ಅಪ್ ಸಮ್ ಅದರ್ ಮ್ಯಾಟರ್. ಟುಡೇ ವಿಲ್ ನಾಟ್ ಟೇಕ್ ಅಪ್ ಯುವರ್ ಮ್ಯಾಟರ್. ಆಲ್ ರೈಟ್.
Serial number 14, my lord.
ಯಾವ್ದು ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಲಿಸ್ಟ್ ಅಲ್ಲಿ ಇರ್ಲಿ. ನೆಕ್ಸ್ಟ್ ಅದು ವಾರ್ನಿಂಗ್ ಲಿಸ್ಟ್ ಅಷ್ಟೇನೆ. ಅದು
ಫಸ್ಟ್ ಲಿಸ್ಟ್ ಬರೋವರೆಗೂ ವೇಟ್ ಮಾಡಿ ರೆಡಿ ಆಗಿ.
List number 1, frauders.
that those will be taken up.
Seal number 1, SPP. Ranjan Kumar.
My lord, I appear for the appellant in 1.2, my lord. My lord, the first appeal is filed by the
What was that police report called for? ಎಷ್ಟದು ಕೊಡಿ ಅದನ್ನ 736 ಅದ್ರ ಮೇಲೆ. What was that police report summoned?
2 or 3 notices.
At request of others, its time is likely to be 18. Yes, HCP ಏನದು police report? Private company office exception. What is that police report? Some
Notice to R2 and R3.
ಹೋಗಿದೆ ನೋಡಿ. Issue notice to respondent on IA 1 of 2018 and in the main appeal. Notice issued to respondent through SP Chamaraj Nagar. Chamaraj Nagar ತಾನೆ.
2 and 3, my lord. Chamaraj Nagar, my lord.
ಅವರೆಲ್ಲ ಮೈಸೂರು ಡಿಸ್ಟಿಕ್ ಮಾಡಿಟ್ಟಿದ್ದಾರೆ, ಚಾಮರಾಜನಗರ ಡಿಸ್ಟಿಕ್ ಆಗುತ್ತೆ.
ಇಲ್ಲೇನೋ ತಿದ್ದಿದ್ದಾರೆ.
ಅದು
ಇಲ್ಲೇನು ಬರ್ದಿಲ್ಲ ಆದ್ರೆ ಇಶ್ಯೂ ನೋಟಿಸ್ ಥ್ರೂ SP ಅಂತ ಏನೋ ಆರ್ಡರ್ ಆಗಿಲ್ಲ. Why they have written it like this?
Police report awaited in respect of service of
No.
notice.
Who had called for the police report?
Lord, the notice has been issued for the respondents, my lord, in this, I think.
Court has not issued notice to SP or commissioner like that. Just notice is issued. Why do they write that police report is awaited? What
Well, the address is the same as the accused number 1. Address is in the same address, my lord.
ಮೈಸೂರು ತಪ್ಪಿದೆ SP
ಅಲ್ಲ, ಬರ್ದಿದ್ನಲ್ಲ, ಯಾವ್ದು ಇದ್ರಲ್ಲಿತ್ತಾ? ಯಾವ case ಅಲ್ಲಿ?
736
ಇಲ್ಲಿ ಬರ್ದಿದೆ, issue notice to response both in main appeal and IA. In the meantime, file lower court records, ಇಲ್ಲಿ SP ಅಂತ ಬರ್ದಿಲ್ವಲ್ಲ? They have to send it, that's all. ಯಾರಿಗಾದ್ರೆ 736 ಅಲ್ಲಿ ಹೋಗಿದ್ದ. 736, you are appearing for madam? 736 file ಕೊಡಿ ಇಲ್ಲಿ.
ಹೌದು 736 ಇಲ್ಲ ಇದೆ.
Gita, she is for the appellant, claimant, victim ಇರ್ಬೇಕು. Complainant, correct.
Complainant I appear for my lord.
Notice was somebody. R1 is, R1 ಗೆ appear ಆಗಿದ್ದಾರೆ, R1 2.
R1 is appear, my lord.
Preferred appeal with respect to R1, my lordship.
Correct, see, notice was not ordered through SPR commissioner, etc. Our registry has made this mistake, but notice is not yet returned, their notice. ಇನ್ನೊಂದ್ಸರಿ ಆರ್ಡರ್ ಮಾಡ್ತೀವಿ,
Time-
ನೀವು
time
ಅದ್ಕೆ
change.
ಬರ್ಕೊಳ್ಳಿ ಅಷ್ಟೇ. The record show that notice.
ಇಲ್ಲಿ ಅಪೀಲ್ ಮೆಮೋನಲ್ಲಿ ಅಮೆಂಡ್ಮೆಂಟ್ ಮಾಡ್ಕೋಬೇಕು ನೀವು ಗೀತಾದೇವಿ ಮೇಡಮ್.
Please, my lord.
ಕೊಳ್ಳೇಗಾಲ ಇರೋದು ಚಾಮರಾಜನಗರ ಡಿಸ್ಟಿಕ್ ಅಲ್ಲಿ, ನಾಟ್ ಇನ್ ಮೈಸೂರು ಡಿಸ್ಟಿಕ್. ನಿಮ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್ ಸ್ಪೀಕ್ಸ್ ಆಫ್
ಇಲ್ಲ, ಚಾಮರಾಜನಗರ ಅಂತಾನೆ.
ಮೈಸೂರು ಡಿಸ್ಟಿಕ್.
ಅಂದ್ರೆ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅವನು ಹೀಸ್ ರಿಸೈಡ್ ಕೊಳ್ಳೇಗಾಲ ಟೌನ್ ಮೈಸೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ಕೊಳ್ಳೇಗಾಲ ಚಾಮರಾಜನಗರ.
ಇದನ್ನ 2014ರಲ್ಲಿ ಆಗಿತ್ತಲ್ವಾ ಚಾಮರಾಜನಗರ ಡಿಸ್ಟ್ರಿಕ್ಟ್, 2008ರಲ್ಲೇನೆ. ಇವರು ಪೊಲೀಸರ ಆ ರೀತಿ ಹಾಕಿರ್ತಾರೆ ಚಾರ್ಜ್ ಶೀಟ್ ನೋಡಿ, ಹಾಗೆ ಇದೆ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ. ಇಲ್ಲಿ ಮಾಡಿದ್ರೆ ನಮ್ಮ ಆಫೀಸರ್ ಅಬ್ಜೆಕ್ಷನ್ ರೇಸ್ ಮಾಡ್ತಾರೆ ಅಂತ ಅವ್ರದ್ದು.
ಇವ್ರು ಮೈಸೂರು ಡಿಸ್ಟಿಕ್ ಕಾಸ್ಟ್ ಟೈಟ್ಲ್
ಇಲ್ಲಿ ಇದೆ ಕೊಳ್ಳೇಗಾಲ ಟೌನ್.
ಕೊಳ್ಳೇಗಾಲ ಟೌನ್ ಅಷ್ಟೇ, ಮೈಸೂರು ಡಿಸ್ಟಿಕ್ ಇಲ್ಲ.
ಹೌದು ಮೇಡಮ್, ಯು ಹ್ಯಾವ್ ಮೇಡ್ ಅ ಮಿಸ್ಟೇಕ್ ದೇರ್.
Please, my lord.
ಅದಿಬ್ಬರದು ಮೈಸೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್.
ಚಾಮರಾಜನಗರ ಡಿಸ್ಟಿಕ್ ಆಗ್ಬೇಕು ನೋಡಿ.
Still,
Your lordship may kindly permit me to amend this, my lord, is Chamarajanagar district, my lord. I'll come there and amend, my lord.
Not issued through any, not issued through the superintendent of any district. It is found that in the appeal memo, it is 736 ಅಲ್ಲಿ ಬರ್ತಾರೆ ಸರ್. In the appeal memo, ಬೇರೆದ್ರಲ್ಲಿ ನೋಡಿ ಹೇಗ್ ಮಾಡಿದ್ದಾರೆ ಸರ್, ಅದರ್ appeal memos. Appeal memo.
In the first appeal, only R1 has made party, my lordship. Your challenge the order against.
Fully observed. R1 A1 ಮಾತ್ರ ಮಾಡಿದ್ರು.
ಕೊಳ್ಳೇಗಾಲ
Correct ಇದೆ.
is shown to be in Mysore district, which is incorrect. Appellant's counsel
ಇದ್ರೊಳಗೆ ಚಾಮರಾಜನಗರ ಅಂತ ಇದೆ.
ಅದ್ರಲ್ಲಿ ಸರಿ ಇದೆಯಾ? Appellant's counsel shall amend, shall correct the said mistake. The name of ಯಾವ್ದದು ಚಾಮರಾಜನಗರ.
ಚಾಮರಾಜನಗರ ಡಿಸ್ಟಿಕ್ ಇನ್ ಪ್ಲೇಸ್ ಆಫ್.
And doing the needful, registry shall issue notice to respondents 2 and 3. 2 and 3 ಮಾತ್ರ appear ಆಗಿಲ್ಲಲ್ಲ? For service through ಯಾವ police station ಅದು?
ಕೊಳ್ಳೇಗಾಲ town.
ಕೊಳ್ಳೇಗಾಲ police station, my lord.
Police inspector of ಕೊಳ್ಳೇಗಾಲ town police station. Furnish the copy of this order to the Lord SCP for coordination. List on 50 days.
22-4.
Obligation.
Seal number 2, yes, Shivanna.
I appear for the petitioners in the matter. I seek a week's time to comply with the office objections.
Third time
I will,
ಎಲ್ಲ ಇದೆ. Appeal is by whom? Respondent number 1 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. RFA. So what is the judgment you have challenged here?
Lords, it was an RFA,
ರಿವ್ಯೂ ಹಾಕೊಂಡಿದ್ದಾರೆ.
Correct.
PD ಮೇಡಮ್.
RFA for a suit of partition.
ಮಾಡ್ಬೇಕಲ್ಲ if you-
Within this week, I'll comply with the office objection. Timing.
It was finally 1 week time is granted, failing which the petition shall stand dismissed. Yes.
Please, wait.
Seal number 3, Mahesh, yes. KB Monish. Kindly pass over, my lordship. AGA will.
My request tomorrow. Report ಕೊಡ್ಬೇಕು, ADS.
Yes, AGA ಬಂದು ಕೊಟ್ರ ರಿಪೋರ್ಟ್. ನಾನ್ furnishing of reports of ADLR by AGA. Reports copies are not furnished. ಅಲ್ಲ ಇಲ್ಲಿ ಕೊಟ್ಟಿಲ್ಲ ಕೋರ್ಟಿಗೆ.
I find it in my objections.
You said that last week Every time we are asking, madam, ಏನಾದ್ರು ಒಂದ್ ನೆಪ ಹೇಳ್ತಾರೆ. We also told you last time, if the one furnished to him is the same, he can file a memo to that effect. Why he seeks passover?
AGA has to appear. I didn't.
AGA is in Karnataka High Court only. Fast ಆಗ್ತೀವಿ. ಪ್ರತಿ ಸರಿ ಇದೇ ಆಗ್ತದೆ. But ಎಲ್ಲಾನೇ ರಿಸಿಪಿ. ಏನು ಕೊಟ್ಟಾದ್ರೂ ಕೊಡ್ಲಿ ಬಿಡಿ, ಅವ್ರು ಮಧ್ಯಾಹ್ನದವರೆಗೂ. ನಿಮ್ ಕೊಲೆಗೆ ಇದ್ರೆ ಇರ್ಲಿ, ಅವ್ರು ಕೊಟ್ಟಾದ್ರೂ ಕೊಡ್ಲಿ, ಬಂದ್ ಏನ್ ಹೇಳ್ತಾರೆ ನೋಡೋಣ. We do not appreciate this. Every time ಬರ್ತಾ ಇಲ್ಲ ಅವ್ರು. ಇಬ್ರು ಅವ್ರಿಬ್ರು they are fighting. ಕರೆಕ್ಟ್. ಅವ್ರು ಒಂದು ಅದನ್ನೇ ಹೇಳ್ಬಿಡ್ಬೋದಲ್ಲ, ಅವ್ರ ಹತ್ರ ಇರೋದೇ ದಟ್ ಇಸ್ ಅಂತ. ಇಲ್ಲ ಕೋರ್ಟಿಗೆ ಕೊಟ್ಟಾರ ಕೊಡ್ಬೇಕು. We'll pass it or let your colleague be here. All right, we'll have it. Yes.
Passed over. Hearing on a yes, seal number 4.
Notice for the appellant.
Ashok P. Patil.
Lords, this was a defendant's appeal, my lords, in a money decree suit. Lords, suit was decreed, my lords, and I have preferred an RFA and the RFA was allowed. Lords, after the allowance of the RFA, my lords, I have filed an IA for release of amount that I have deposited, my lords, it's 5.5 lakhs. Lords, to that, my lords, they filed objections saying that we have filed a review petition over the RFA. So that review petition, my lords, needs to be decided.
Right, he has taken the copy, has served the copy. And
Yes, my lords, copy has been received.
you are ready.
I'm ready, my lords.
Lakshmi, kindly take the review petition papers.
Yes.
The judgment under review, you will find at page number 40.
Yes.
It's at page number 43. But in the judgment, the issues not framed by the trial court are extracted.
Hmm.
With regard to the payment, then Lord, when the RFA was taken up for hearing, the contentions lots on the appellant side are noticed lots at page number 45.
Yes.
Basically, because there is no privity of contract. That was the argument addressed between plaintiff and defendant. Suit is bad for non-joint or necessary party. Then plaintiff has not given any purchase order to the defendant nor paid any money. The learned trial judge has mainly placed reliance on Exhibit P5, a communication between Tricon and the defendant. Plaintiff's managing partner has admitted in cross-examination that Tricon is their agent and plaintiff had no direct contracts with the defendant. The trial court has heard in declaring the suit without there being any contract between the plaintiff and the defendant. Then lots the respondent plaintiff's arguments are noticed lots at page 46. Tricon has placed order with the defendant on plaintiff's behalf. And plaintiff has paid money directly to the defendant. Defendant has failed to supply the coffee as agreed, causing huge loss to the plaintiff. Defendant has signed a copy of Exhibit P5 and the learned trial judge has rightly placed reliance on the said document. But these are the points. Then, my lord, this honorable court framed the points while rendering the judgment at para 13. Whether there is a privity of contract between plaintiff and defendant, whether suit is bad for non-joint or necessary party. Based on these 2 points, but by rendering a finding, the judgment is reversed. But my responsible submission is, there are no findings on the points urged by the appellant, other points urged by the appellant, and the points raised by the respondent plaintiff on this. Then what, because kindly come to page 46. Plaintiff has paid money directly to defendant, that's our contention. And Their contention is plaintiff has not paid any money. As per page 45.2 and page 46.2. The evidence by demand drafts directly purchased by the plaintiff in the name of the defendant, forwarded to him, which he has encashed. The trial court has considered all that evidence. Basically, the demand drafts which were sent by the plaintiff in the name of the exhibit P6 to P9, account statement, and exhibit P6 at page, they're all part of the paper book. And what ledger account of the respondent, which is maintained not in the ordinary course of business. Then what this is the evidence, which what is not considered by the appellate judgment. Then what exhibit P5 is extracted at page 48. Of the judgment itself.
Judgment.
It's part of the judgment as well as it's part of the paper.
Oh, P5.
At page 48.
Page 9 and
Because it is in the letterhead of, it is available at page 131 of the paper book.
Hmm.
It is available in the letterhead of Tricon Agencies Private Limited, my agent,
Exhibit P5.
exhibit P,
Page number is
131 in the paper book.
ಇದು ಅಂದ್ರೆ ಒರಿಜಿನಲ್ ರೆಕಾರ್ಡ್ಸ್
ಇಲ್ಲ paper. ಇದು paper book type LCR ಇದೆಯಾ ನೋಡಿ.
Yes, all. You agree that this is a correct typed copy, no? Timber paper.
ಹೌದು, ಅದು original
It is in their letter, yes.
There you also may kindly see, it is under the letterhead of my agent Tricon Agencies Private Limited. Kindly see, it is addressed to the defendant. Coffee for Ratnagiri International. So this is sale of goods transaction.
Hmm.
Coffee for Ratnagiri International itself indicates that Tricon Agencies was acting as my agent. But I am a coffee exporter. I have employed an agent to procure coffee, and Tricon Agency Private Limited introduces me to the supplier in this fashion, and the freight export of the coffee is also taken by another company of the same agent. They deliver it not waste at the destination abroad. That is the contract. Then you can kindly see, this is 22/2/2002. And coffee has got its own specifications, different grades, different varieties and different rates. And it's a very highly competitive business globally. Therefore, supply of the coffee of the right quantity and the right grade at the right time is very crucial. And if I fail to supply to my overseas buyer, then I am mulched with certain cost as washout charges. So it's a chain where my agent places the orders and the supplier supplies, and I pay the supplier. In some cases, I paid in advance.
Correct, you have to show the error apparent on the face.
Error is, Honorable Supreme Court has said, regular first appeal to be considered in a manner where the entire evidence on record has to be noted. Here, as you lordships have seen, my contentions and appellant's contentions are noticed, but it is decided only on these 2 points, where saying that there is a privity of contract. Otherwise, a lot of evidence is available.
Correct, where is that judgment? You have the judgment which says that. You have the judgment which says that in first appeal,
Yes,
uh,
in fact,
all issues shall be considered,
exactly.
even if it is found
Exactly.
on the one
Exactly.
issue. negative
In fact,
representation.
I have extracted those rulings in my
There.
grounds also.
There is a.
I have extracted that the part of the rulings not in my grounds also.
Citation ಕೊಡು.
ಅದು ಇದೆ, ಅದು ಕೊಡ್ತಾ ಇದೆ. The first ruling is reported in 2001, VACC page 179.
Yeah, what is it?
I request your lordships to kindly go to para 14 at page 187.
Page?
Para
187.
14 at page 187
Hmm.
of the first one.
Yes. Yes.
The point of law which admits of no two opinions may be a proposition of law, but cannot be substantial question of law. To be substantial, a question of law must be debatable, not previously settled by law, the land, or a binding precedent. And must have a material.
Correct. This is about substantial question.
Then
We were asking.
para 15. Para
It's
15.
a proposal.
Yes, yes.
Yes.
Straight away, para 15. A perusal of the judgment of the trial court shows that it has extensively dealt with the oral and documentary evidence adduced by the parties for deciding the issue on which the parties went to trial. It also found that in support of his plea of adverse possession on the disputed land, the defendant did not produce any documentary evidence, while the oral evidence adduced by the defendant was conflicting in nature and hence unworthy of reliance. The first appellate court has in a very cryptic manner reversed the finding on question of possession and dispossession of alleged by the plaintiff, as also on the question of question of adverse possession as pleaded by the defendant. The appellate court has jurisdiction to reverse or affirm the findings of the trial court. First appeal is a valuable right of the parties, and unless restricted by law, the whole case is therein open for rehearing both on questions of fact and law. The judgment of the appellate court must therefore reflect its conscious application of mind and record findings supported by reasons on all the issues arising along with the contentions put forth and pressed by the parties for decision of the appellate court. The task of an appellate court affirming and findings the trial court is an easier one. The appellate court, agreeing with the view of the trial court, need to restate the effect of the evidence or reiterate the reasons given by the trial court. Expression of general agreement to reasons given by the court, decision of which is under appeal, would ordinarily suffice. We would, however, like to sound a note of caution. Expression of general agreement with the findings recorded in the judgment under appeal should not be a device or camouflage adopted by the appellate court for shirking the duty cast on it. While writing a judgment of reversal, the appellate court must remain conscious of two principles. So this is what is stated. Firstly, the findings of fact based on conflicting evidence arrived at by the trial court must weigh with the appellate court. More so when the findings are based on oral evidence recorded by the same presiding judge who authors the judgment. This certainly does not mean that when an appeal lies on facts, the appellate court is not competent to reverse a finding of fact arrived at by the trial judge. A matter of law, as a matter of law, if the appraisal of the evidence by the trial court suffers from a material irregularity or is based on inadmissible evidence or on conjunctures and surmises, the appellate court is entitled to interfere with the finding of fact. The rule is, and is nothing more than a rule of practice, that when there is conflict of oral evidence, the parties on any matter issue and the decision hinges upon the credibility of the witnesses, then unless there is some special feature about the evidence of a particular witness which has escaped the trial judge's notice, or there is sufficient balance of improbability to displace his opinion as to where the credibility lies, the appellate court should not interfere with the finding of the trial judge on a question of fact. Secondly, while reversing a finding of fact, the appellate court must come into close quarters with the reasoning assigned by the trial court and then assign its own reasons for arriving at a different finding. This would satisfy the court hearing a further appeal that the first appellate court had discharged the duty expected of it. We need only to remind the first appellate courts of the additional obligation cast on them to the scheme of section 100. Not that's on the point of factor. So therefore, the submission is the 2 points raised by this honorable court were never the issue before the trial. And on the issues which were framed by the trial court, evidence was little, both oral and documentary. One of the points stated is, Tricon agency is not a party in the suit. I had examined the managing director of that company, SPW2,
Tricon.
That's my agent.
Yeah. No, you examined the manager of
And
Tricon.
the agent, my agent,
Examine the manager of Tricon.
managing agent, managing director
Of which company?
of my agent company. Tricon Agency Private Limited.
Yes.
Because that is the one, my order is routed through him, through that agency. And it clearly says that coffee is meant for me.
All right, this is one judgment.
And-
Now,
Yes.
we cannot go on the question of
Lords.
facts. Error apparent on the face of the
Now,
record.
error apparent is
You are submitting that all issues have,
correct.
all issues have to be
Addressed.
addressed. Adri mere judgment.
In the judgment under review, your lordships have seen the,
Right, idu bit bere judgment ಯಾವ್ದು ಇದೆ?
next judgment is. ಇಲ್ಲಿ 2017,
Please, you know,
sorry, I'm sorry. 2002 5 SCC,
reason order.
para 9.
Error?
Para 9 at page 18. This is scope of consideration of RFA, then I'll come to the judgment of the review also.
You are referring to this 2017-15 or
2002. I'm sorry.
2001 ಆಯ್ತಲ್ಲ?
ಅಲ್ಲ, 2001 ಆಯ್ತು, 2002,
Oh, well,
volume 5 SCC, that's the second ruling, the compilation. Page 15.
ನಮ್ಮದ್ರಲ್ಲಿ ಪೇಜ್ ನಂಬರ್ ಹಾಕಿಲ್ಲ, ರನ್ನಿಂಗ್ ಪೇಜ್ ನಂಬರ್.
ಅಲ್ಲ, ಇದು judgment page number. ಒಳಗೆ internal page number 15, ruling page.
ಕರೆಕ್ಟ್. ನಿಮ್ಮವ್ರು ರನ್ನಿಂಗ್ ಪೇಜ್ ಹಾಕೊಟ್ರೆ ನಮ್ಗೆ ಇನ್ನೂ ಅನುಕೂಲ
I understand.
ಆಗುತ್ತೆ.
ಇಲ್ಲಿ para 9.
ಹ್ಮ್.
Para 9 and we have perused the impugned judgment of the High Court. As noted earlier, the High Court formulated and in our view, rightly 2 questions for determination in the case. Thereafter, the High Court proceeded to discuss at length certain principles of law enunciated in different decisions rendered by this court, the Calcutta High Court and other high courts. From the judgment, it appears that lengthy discussions have been made with reference to certain observations made in the decisions rendered thereunder. But the High Court does not appear to have considered in depth the evidence on record.
ಒಂದ್ ಸೆಕೆಂಡ್,
I'm sorry.
ನೀವು ಅದಕ್ಕೆ ಹಾಕೊಡ್ಲಿ ಇಲ್ಲಿ ಎರಡನೇ
I'm sorry.
ನನಗೆ ಒಂದಕ್ಕೆ ಮುಗಿಯುತ್ತೆ. ಇದು ಥರ್ಡ್, ಸರಿ. ಇದರಲ್ಲಿ ಒಂದು ಪೇಜ್ ಅಲ್ಲೇ ಮುಗಿಯುತ್ತೆ. ಅದನ್ನ ಕೇಳೋಣ.
I'm sorry, I think,
Yes. ಹಾಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ Yes.
Lords, it is the judgment number 2 in the compilation reported in 2002, volume 5 SCC, page 15. I request your lordships to kindly go over to page number 18, para 9.
Yes.
We have perused the impugned judgment of the High Court. As noted earlier, the High Court formulated and in our view rightly 2 questions for determination in the case. Thereafter, the High Court proceeded to discuss at length certain principles of law enunciated in different decisions rendered by this court, the Calcutta High Court and other high courts. From the judgment, it appears that lengthy discussions have been made with reference to certain observations made in the decisions rendered thereunder. But the High Court does not appear to have considered in depth the evidence on record. The High Court has also not recorded any specific findings on the validity or otherwise of the notice of determination of the lease said to have been given under the letters dated so and so on the facts of that case. It is clear from the discussion in the judgment of the High Court, having answered the question whether the said letter was received by the landlord against the landlord in favor of a tenant, assumed that there was a valid determination of the lease. The further finding of the High Court that after determination of the lease, a fresh tenancy in respect of premises had been created in favor of so and so is not based on any discussion of the evidence on record, but on the mere observation, that is, the court is required to consider the cumulative effect of all the materials, and there cannot be any doubt whatsoever that keeping in view the fact that the plaintiffs had manufactured rent receipts and also sought to put a date in Hindi so and so, so the appellant clearly goes to show that so and so before the tenant of the appellant in his, on the facts of that, I will not come in trouble lots of that. This finding in our view, then you lost me kindly. is begging the question. The point to be determined by the court was whether the tenancy in favor of the company determined by the court was whether the tenancy in favor of the company had been validly terminated, etc. Now, therefore, only observation is entire evidence will have to be considered in depth. First appeal, in first appeal proceeding, which is not lots have happened in the instant.
Correct.
One point on it.
There is one judgment, if you remember correctly, which says, suppose question of limitation, question of jurisdiction ಇದೆಲ್ಲ ಇರುತ್ತೆ. ಅವಾಗ court has to return findings on all the issues. Even if the issues goes against a particular party, even after answering those issues, the court has to answer all the issues ಅಂತ ಇದೆ. ಅದಿದ್ರೆ ತೋರಿಸಿ. Because here.
No, I am only on the point that what is the role or the scope of the first appeal?
Yeah, that's what first appellate court ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತ ಹೇಳೋವಾಗ್ಲೇ ಈ this
ಎಲ್ಲ ಬರ್ತಾ ಇದೆ.
trial court as well as first appellate court.
ಅದನ್ನ para 15 of the first ruling ಅಲ್ಲಿ ಹೇಳ್ಬಿಟ್ಟಿದ್ದಾರೆ. Cryptic judgment ಅಲ್ಲಿ you can't reverse it, you have to go into the in depth and if you are particularly
If you say like that, it becomes a ground for appeal. You say it is ground for review, you should show that answer should have been given.
Kindly appreciate. When the Honorable Supreme Court has laid down the law as to how.
ಇದು ಯಾವ್ದು ನೋಡಿ ಅದನ್ನ ನಾನು ಅದಕ್ಕೆ ಕಲ್ಕೊಂಡೆ. Next 2017 Supreme Court ಅದ್ರಲ್ಲಿ ಏನ್ ಹೇಳಿದ್ರೆ.
ಅಲ್ಲಿ 17 Supreme Court ಅಲ್ಲಿ may point out not the two paragraphs. Para 8 at page number 312.
Para 8.
Again, they have relied upon the Santosh Hazaria's case, the first ruling. And the jurisdiction, para 15 has been reproduced. Then kindly come to para 9, the next page. The aforesaid passage has to be appositely understood. While reversing the finding and conclusions of the trial court, the duty of the first appellate court is different than while affirming the judgment. Be it stated, the court has also held that it is a final court of law, in the sense that its decision on a question of law, even if erroneous, may not be vulnerable before the High Court in second appeal. Not another question of that. Because the jurisdiction of the High Court has now ceased to be available to correct the errors of law or the erroneous findings of the first appellate court, even on questions of law, unless such questions of law are substantial one, the scope of second appeal. Right? Then para 15 you are again reproduced. In Santosh Hazaria's case, while reversing a finding of fact, the appellate court must come into close quarters with the reasoning assigned to the trial court and then assign its own reasons for arriving at a different finding. This would satisfy the court hearing a further appeal that the appellate court had discharged the duty expected of it. We need only to remind the first appellate court of the additional obligation, that's regarding second appeal. Then kindly come to para 11. Referring to another ruling of the Honorable Supreme Court, para 11, the first appeal has to be decided on facts as well as on law. In the first appeal, parties have the right to be heard both on questions of law as also on questions, and the first appellate court is required to address itself to all issues and decide the case by giving reasons. Unfortunately, the High Court in the present case has not recorded any finding either on facts or on law. Sitting as the first appellate court, it was the duty of the High Court to deal with all the issues and the evidence led by the parties before recording the finding regarding title. The order of the High Court is cryptic and the same is without assigning any reason. Now, let me go back to the judgment and the review.
You have this 2005 also. 2005 10 SCC. 2005 10 SCC 243.
Then may I take you to the next ruling? I'll make submissions on the ruling which is suggested by the court.
You have it in this, that 2005 also in your compilation?
2005 ಇಲ್ಲ ನಮ್ಮ ಈ compilation ಅಲ್ಲಿ.
Because it appears it is from our High Court ಅಂತ ಕಾಣಿಸ್ತಾ ಇದೆ ಅದಕ್ಕೆ.
So, ತಾವು ಇದರಲ್ಲಿ ರೆಫರ್ ಮಾಡಿದ್ದಾರೆ.
Yes, next.
Next ruling, the fourth ruling, reported in 2022 8 SCC, page 261.
Yes.
I request the lordships to kindly go to page 268, paras 26 and 28.
State in the ನೋಡಿ. This is also what state on the coast?
May I please also?
This is also from Karnataka, it seems. Yes,
Yes, yes,
Para?
yes. Para 26 at page number 268.
Yes.
Correct, at the foot of page. The High Court in a very cursory and cryptic manner partly allowed the first appeal. It did not consider the evidence considered by the trial court. Neither did it deal with the statements or the other documentary evidence on record, and only on a bald statement of the respondent, which according to it was mentioned in the order of the land tribunal, that the respondent was jointly cultivating their said land along with his father, and that it became a joint family estate, and accordingly reduced the share of the appellate. Then note para 28. Section 96 provides for filing an appeal from original decree. Further, Order 41/31 provides for the contents of the judgment of the first appellate. According to it, the judgment of the appellate court shall be in writing and would include the points for determination, the decision thereon, the reasons for the decision, and whether the decree is reversed or varied, the relief to which the appellant is entitled to. But the provision is extra. Then what's the other paragraphs here is para 30. The next page.
Yes.
It has been a matter of debate, para 30, not at page 270.
Yes.
It's a matter of debate in a category of decisions as to what would be the scope, power, and duty of the first appellate court in deciding an appeal under section 96, read with order 41/31 CPC. We briefly deal with the law on the point. Para 31. The learned judge V.R. Krishna J, as then was the judge of the Kerala High Court in 1969, by deciding the case between so and so, dealing with a similar judgment of the first appellate court, which had been disposed of by a brief order, observed as follows. An appellate court is the final court of fact. Ordinarily, and therefore, a litigant is entitled to a full and fair and independent consideration of the evidence at the appellate stage. Anything less than that is unjust to him. And I have no doubt that in the present case, the learned subordinate judge has fallen far short of what is expected of him as an appellate court. Then notes 32.1, Santosh Hazaria has been reiterated, and notes in 32.2. Then H.K. Swami's case, then 32.3, in 2015, this court, again in so and so, considering the previous judgment, recorded its view in paragraph 18 and 19. In our considered opinion, the High Court did not deal with any of the submissions urged by the appellant and or the respondent. Nor it took note of the grounds taken by the appellant in the grounds of appeal, nor made any attempt to appreciate the evidence adduced by the parties in the light of the settled legal principles and decided the case law applicable to the issues arising in the case, the view to find out as to whether the judgment of the trial court can be sustained or not, and if so, how, and if not, why. Then 19, being the first appellate court, it has the duty of the High Court to have decided the first appeal, keeping in view the scope and powers conferred on it under section 96, read with order 41, rule 31 CPC mentioned above. It was unfortunately not done, thereby resulting in causing prejudice to the appellant, whose valuable right to prosecute the first appeal on facts and law was adversely affected, which in turn deprived him of a hearing an appeal in accordance with law. It is for this reason we are unable to uphold the interim judgment. Then you will ask me kindly go over to the next page. Again, reiterating Santosh Hazaria. Thus, the appellate court has at page number 272 of the same review. Thus, the appellate court has the jurisdiction to reverse or affirm the findings of the trial court. The settled law that an appeal is a continuation of the original proceedings. The appellate court's jurisdiction involves a re-hearing of appeal on questions of law as well as fact. The first appeal is a valuable right, and at that stage, all questions of fact and law decided by the trial court are open for reconsideration. The judgment of the appellate court must, therefore, reflect conscious application of mind and must record the court's findings supported by reasons for its decision in respect of all the issues along with the contentions put forth and pressed by the parties. Needless to say, the First Appellate Court is required to comply with the requirements of Order 41 to 31 CPC, and non-observance of these requirements lead to infirmity in the judgment. From the above settled legal principles on the duty, scope, and powers of the First Appellate Court, we are of the firm view and fully convinced that the High Court committed a serious error in neither forming the points for determination nor considering the evidence on record, in particular, which had been relied upon by the trial court. The impugned judgment of the High Court is thus unsustainable in law and liable to success. One submission with regard to the judgment under review. 2 points which were raised with this honorable court and answered against the respondent. They were not issued before the trial court. First thing. And while dealing with the contentions,
There was no defense about privity of contract.
Madam,
Written statement, there was no contention in written statement regarding.
My lords, there was, my lords.
privity of contract ಬಗ್ಗೆ, when money is paid by me directly to him and he has received in his account, and he has issued gate passes from his
No, not on the analysis of the evidence
Lords, there clearly was, my lord. There is a finding. I'll show, my lord.
finding.
There is a finding.
and the issues which are raised by the trial court are answered in favor of the plaintiff. Because I had paid certain monies in advance for a particular quantity, which there was a short supply. There is a finding on that. So I have sought for refund of that. And because of,
See, in review, we cannot reanalyze the evidence. You said 2 points. One is that only this finding on privity of contract is also against the record. That's why error apparent on the face of the record. Secondly, you said that there were some documents which showed the remittance of the money, and that was a point raised in the judgment also. Judgment is,
that was argued, because they argued I have not received any.
that is not answered on the.
How to answer, how correct, that's right.
because
Another submission is,
other way, so now if a point was raised, if it is not answered, whether that amounts to error apparent on the face of the record requiring review.
Correct.
So
And
we
another-
cannot at this stage.
no, I'm only making a submission. The other question is, whether Tricon agents were the necessary party. Adike, now the judgment and the review, let me point out how Lord Dishonorable Court has dealt with that. May I request you also to kindly take the ruling itself. Where, Lords? My
Where
evidence in
privity of
cross-examination.
contract is bad for non-joint or personal party, whether judgment and decree pass by the. Yes.
May I request you also to kindly go to page 47 of the review papers. While considering the point regarding the first point with regard to privity, my one sentence from my cross-examination has been filled out, has been noticed.
Hmm.
In para 17 of the cross-examination.
You are reading in.
I'm reading page 47 of the review papers.
Para 14.
Para 14 only.
Hmm.
Kindly see, it is
Para
a word in
15.
para 3 of the plain. And let me read it. That in normal course of business, plaintiff engages the service of Tricon for procuring and transporting coffee. In para 5 of the plain, it is a word that on plaintiff's behalf, Tricon had placed orders with the defendant for supply of coffee. In para 15 of the cross-examination PW1, Rohit Patre, it is stated that Tricon is plaintiff's agent, and there is a document to that effect. But the said document has not been produced in the court. He has admitted that plaintiff had no direct contact with the defendant for supply of coffee seeds, but plaintiff had made contact with the defendant through Tricon. That's my evidence. In para 17 of the cross-examination, PW1 has admitted that contact as per exhibit P5 is between Tricon and the defendant. In fact, one more sentence following that has been not noticed by the Honorable Court, which is available at page 48 of the paper.
Yes. 48 of the paper book in the appeal.
ಹೌದು, ಇದು ಪೇಪರ್ ಬುಕ್ ಅಲ್ಲಿ ಅದು ನಾನು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದ್ದೇನೆ ನನ್ನ ಇದರಲ್ಲಿ ರಿವ್ಯೂ ಪಿಟಿಷನ್, ಬಟ್ Let me show, my lord, the. Para 17 at page 48. It is true that the contract-wide exhibit P5 is between Tricon agencies and the defendant, but I voluntarily state that this contract was on our behalf by the said Tricon agency. I'm glad the exhibit P5 nallane ide. Copy is for my company, my concern. That is a document which is signed by the defendant. If you want to kindly see the original of exhibit P5, there is no doubt that the defendant was meant to supply this coffee for me only, and he has received money from me directly. And the gate passes which have come out of his factory, they're all addressed to me. They're all marked in evidence, which has been not noticed.
Yes.
So therefore, my submission to lordship is that if you lordship kindly see the provision of review.
This PW1 was not, you said Tricon. He was not the employee of Tricon.
He
He was
is
the employee of
my partner.
Ratnagiri International.
Rohit, but sorry.
This Rohit, PW1 was the employee of Ratnagiri International.
PW1 is a partner of
Partner, but he is not the staff employee or any person from this, what is that concern, Tricon.
no. He's on behalf of PW1. He's the partner of the plaintiff firm. And
I am the managing partner.
And PW3 is also one of the partners who has given evidence. PW2 is the managing director of Tricon.
Correct. See, it appears, avag now repeatedly we asked you whether his PW1 was Tricon's employee or partner, something concerned to that.
The plaintiff's
You can say
plaintiff's partner. Ratnagiri International.
This,
And PW3 is also plaintiff's partner. And PW2 is my managing director of the agent, Tricon Agency Private Limited.
PW2,
So,
is that page number?
page 54. Mr. Subhash Menon. Page
Is
54.
representative of Tricon Agency.
Yes. That's the agent, my agent. And his another company is Tide Water Shipping Private Limited, which is the freight company, which transports the product from the
Plaintiff engaged the service, para 4 plaintiff engaged the services of Tricon
yes.
for the purpose of procuring transportation and transporting profit.
Different Tricon and the Ratnagiri International. Even one would direct contact.
ಅವ್ರ ಕೇಸನ್ನು ಅದೇ ಅಲ್ಲ, ಅವ್ರ ಕೇಸನ್ನು ಮುಗಿಯೋದಿಲ್ಲ, ಅದ್ರಲ್ಲಿ ಒಂದೇ ರಿವ್ಯೂ ಮಾಡಬೇಕಂತ ಒಂದೇ ಇಶ್ಯೂ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಾ, ಎಲ್ಲ ಇಶ್ಯೂ ಕನ್ಸಿಡರ್ ಮಾಡ್ಬೇಕಿತ್ತು ಅಂತ ಹೇಳಿ. ಅಂದ್ರೆ ಅವ್ರು ಹೇಳ್ತಿರೋದು ಒಂದು ವೇಳೆ ಇವ್ರು ಅನ್ಕೊಂಡ್ರೆ ಚೆಕ್ ನನ್ನಿಂದ ಬಂದಿದೆ, ಅದು ಆ ಇಶ್ಯೂನ ಆನ್ಸರ್ ಮಾಡ್ಬೇಕಿತ್ತು, ಅದನ್ನ ಆನ್ಸರ್ ಮಾಡಿದ್ವಿ. ಸೊ ಅದು ಒಂದೇ ಕಾರಣ. Whether it is to be reviewed or not.
May I
Because
request,
other things it amounts to hearing the appeal. Yes.
may I request also to kindly see exhibit P5, the original, let's start with it.
ಅಲ್ಲ ಅವ್ರು ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡೋದಿಲ್ಲ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ದಟ್ ಈಸ್ ಇನ್ ಆನ್ ಯುವರ್ ಲೆಟರ್ ಹೆಡ್ ಅಂಡ್ ಆನ್ ಟ್ರೈಕಾನ್.
ಒಂದು telltale evidence ಇರುವಾಗ, when the trial court has gone in detail about all the documented evidence.
ಇಶ್ಯೂ correct. What was elicited in the cross examination about this exhibit P5?
Now, he has admitted his signature that Robin Mandappa is the defendant. And that was, out mainly jurisdiction ittu.
Lords, in effect, my lords, my learned senior friend, my lords, is virtually re-arguing the whole case, my lords,
No,
as if
what
it's
I'm
in
saying-
appeal.
Counsel, leave my with the understanding. We also told him that we cannot go into the merits if unless it is reopened or reviewed.
Correct.
Review is allowed.
Correct.
Now, it appears his arguments are, and I think there are judgments also that all issues shall be answered by the first appellate court.
Lords,
He was only trying to say, apart from this privity of contract issue, checks were issued by them and that was realized, this
Demand.
given by the plaintiff to the defendant, they have realized it. That issue also should have been considered.
lords, if the issue of privity of contract, my lords, was dealt with by the trial court, my lords, and the appellate court,
Correct?
lords,
Now-
there is no question of, my lords, the judge going further than that issue, my lords.
This court held that since privity of contract itself is not proved, the other
So
questions.
he does not have the right to file a suit is what,
ಹಾಗ್ ಮಾಡಕ್ ಬರುತ್ತೆ. Like suppose there is a question of limitation and jurisdiction.
lords, this is,
First appellate court, despite answering them in. the
lords, on a
negative
question
or
of law,
against-
my lords,
Okay.
on a question of
Whether
law,
it's
my lords,
not-
it's correct, but it's on a question of fact, my lords, there is also a finding.
Here as first, we are asking you some other analogous matters. Suppose there is a question of limitation, jurisdiction and other, obligation of the parties.
Hmm.
Suppose the court answers the question of jurisdiction and the limitation against the plaintiff,
Hmm.
whether court is bound to answer the next issues or not. First appellate court.
Lords, that
What?
is not the issue here, my lords.
Maybe only to that extent, Mr. Patil.
Not the submission is, you also have seen the rulings of the Honorable Supreme Court. You have to address all the issues, whether
Correct, ಅದ್ರ ಮೇಲೆ.
what view you take, we don't know, but you have to address, and we have argued. Another has argued, I have also argued, points are, called
So
out.
we cannot now reread the evidence, only this will be limited to,
No, I understand, that's fine.
whatever.
Now, this, in mind, so therefore, because of this,
ಅದು ನೆಕ್ಸ್ಟ್ ಕರ್ನಾಟಕ ಹೈಕೋರ್ಟ್ ಇಂದಾನೆ ಹೋಗಿದ್ದದು, ಇನ್ನೊಂದು ಯಾವ್ದೋ citation.
Lords, irrespective of, my lords, whether the issues are raised or not, my lords, if a finding is given saying there is no privity of contract,
Privity of contract, all right, thereafter, whether you had received the money or not, whether
lords,
that
that is
issue
immaterial,
should
my
have
lords,
been
because,
decided or not, anta.
lords, if there is no privity of contract between the plaintiff and the defendant, my lords, there is no question.
Not a writ petition.
Lords, correct, my lords.
Order for 96, section 96 and order 41 rule 30.
No,
Number court in the Justice N. Kumar ಅವ್ರದ್ದು ಒಂದು judgment ಇದೆ.
Lords, and all the judgments that they have relied on, my lords,
Once you will coordinate bench under it.
Latest Nagaratna madam ಅವರು
ಇಲ್ಲೇ ಕೊಟ್ರಲ್ಲ ಇನ್ನೊಂದು 2022 Justice Nazir sir.
but at least the questions which are posed and noted have to be answered by the individual.
ನೀವು ಸ್ವಲ್ಪ ಸರ್ಚ್ ಮಾಡಿ. I think this is answered like the way we are giving the examples. Brother was telling ಇನ್ನೊಂದು ಯಾವ್ದೋ Justice Nagaratna madamದು ಬಂದಿದೆ ಅಂತ. I think these issues were dealt with. Suppose there's a question of limitation, jurisdiction and other question of facts, disputed question of facts. If the court answers this first earlier preliminary issues against the
Maintainability of the suit.
plaintiff, against the plaintiff, whether it's required to answer other issues or not, decide other issues or not.
That question may be relevant not in the original proceeding.
Not original, first appellate court no, whether first having formulated the points.
Yes.
Suppose limitation, jurisdiction, etc. Thereafter, the question of liability. And answering the questions on the ground of limitation or this thing, whether the first appellate court is bound to answer the issue on the liability or not on the unknown.
I understand the court's some inquiry that in a case given. case-
Directly on this point ಇದಾವೆ judgment. ನೀವೀಗ summary ತೋರಿಸಿದ್ರಿ ನೀವು.
ಗೊತ್ತಾಯ್ತು. ಇಲ್ಲಿ ಇನ್ಫ್ಯಾಕ್ಟ್ ಇದೊಂದು
Fact that is Santosh Hazari versus ಇದು that is a very celebrated judgment.
yes,
Justice Lahoti ಅವ್ರದ್ದು.
that has been followed in all the judgment.
But ಅಲ್ಲಿ summary ಒಳಗೆ ಹೇಳಿದ್ರು the very same issues involved ಇದ್ದದ್ದು ಇದೆ.
In this 2022
Santosh
judgment,
Hazari versus Purushottam Tiwari.
ಈ 2022 judgment ಅಲ್ಲಿ on page
2022
that is the fourth judgment in the compilation.
is court judgment. Para 2830 ಅಂತ.
ಇಲ್ಲಿ may I request page number 272.
We have already marked.
That's the, but ಓದ್ದೆ ನಾನು, but I
We
didn't.
settle that the appeal is continuation of earlier jurisdiction involving
Hearing of
re-hearing
appeal on
appeals of
questions of law.
question of law as well as fact.
Must therefore reflect conscious application of mind and must record the court's findings supported by reasons for its decision in respect of all the issues, along with the contentions put forth. Issues are the trial court, along with contentions put forth and pressed by the parties. That is before the appellate court. Needless to say, the first appellate court is required to comply with the requirements of Order 41 to 31, and non-observance of these requirements lead to infirmity.
Points for determination, decision thereon, reasons for the decision, and whether the decree
I think
applicable is reversed or varied. The reasons which the appellant is entitled.
ಇಲ್ಲಿ ಅವ್ರು all the issues contentions ಎರಡು ಹೇಳ್ತಾರೆ.
Yes, that's all.
Privity of contract ಅನ್ನೋದಕ್ಕೆ now he's an agent.
No, ಆ point ಇಂದು ನಾವು we cannot reassess that because your remedy is, if that finding is according to perverse or contrary to the material on record, that may give rise to an appeal.
I'm only making the submission. Before the trial court, that was not an issue. Whether there is a privity of contract ಅನ್ನೂ ಇಲ್ಲ ಮತ್ತು ನಾನು ಟ್ರೈಕಾನ್ ನೆಸೆಸರಿ ಪಾರ್ಟಿ ಅಂತ ಹೋಲ್ಡ್ ಮಾಡಿದ್ದಾರೆ.
ನೀವು ರಿವ್ಯೂ ಮೇಲಿನ ಜಡ್ಮೆಂಟ್ಸ್ ಕೊಡ್ತಾ ಇಲ್ವಲ್ಲ, ರಿವ್ಯೂ ನಲ್ಲಿ whether we can go into these questions.
Lords, one submission, Lords.
Kindly
Lords,
see.
there was,
Mr. Counsel, why are you so
Lords,
patient?
ಅಲ್ಲ ಒಂದು ಎರಡ್ ಸಲ ಹೇಳಿದ್ದಾರೆ ಅಲ್ಲ ಅವ್ರು.
We are going to give you, you also understood what is in the mind of the court.
Lords, my learned friend is saying there is no finding on the privity of contract issue. Lords, there are findings. Lords,
He didn't say like that. He said the appreciation was incorrect. That is one thing that we are not able to, we are not convinced because that we cannot do. We cannot sit in appeal before against our own judgment and order. His next question was that there were some other issues, they were not answered. Issues are point for consideration,
Your Lordship may see the issues, Lords, of the trial court.
not trial court issues. Here point.
ಅಲ್ಲ
they
trial
raised
court
the-
issues ನೋಡಿ RFA issues, Lords, they're virtually, Lords, one and the same.
RFA
Lordship may
is
see
a
those
point
issues.
for consideration ಮಾಡಿದ್ದಾರೆ, RFA ನಲ್ಲಿ issue ಅಲ್ಲ. Issues ನ extract
point
ಮಾಡಿ
of
ಆಮೇಲೆ
consideration
point for
ಮಾಡಿದ್ದಾರೆ.
consideration ಮಾಡಿದ್ದಾರೆ.
ಹಾ.
There, ಎಷ್ಟದು page number 40 ಅಲ್ಲೆಲ್ಲ ಇರ್ತಲ್ಲ.
47.
And this
Yeah, whether privity of contract between the plaintiff and appellant, whether suit is brought for non-joint of necessity, whether the judgment and decree passed by the trial court requires any interference ಅಂತ ಇದೆ. ಅವ್ರು ಹೇಳೋದು ಇಲ್ಲಿ liability ಬಗ್ಗೆನೂ ಒಂದು ಪಾಯಿಂಟ್ ಕನ್ಸಿಡರ್ ಮಾಡಿ. Because check was issued and it was realized.
Statement ಆಗಿದೆ.
Plaintiff had issued the check, ಅದಕ್ಕೆ whether the defendant has received the money from the plaintiff or not ಅನ್ನೋದನ್ನು ಒಂದು ಕನ್ಸಿಡರ್ ಮಾಡಬೇಕಿತ್ತು ಅವ್ರು ಹೇಳೋದು. Issue. Plaintiff has not given it. Point, trial court issues in it. Does plaintiff prove that it had placed the order? That is about privity. Did defendant supply so and so? Was there an excess payment? Contract.
ರೈತಾನ್ ಅವ್ರನ್ನ ಇವರು ಪಾರ್ಟಿ ಮಾಡಿ ರೈತಾನ್ ರತ್ನಗಿರಿ ಅವ್ರಿಗಿರೋದು ಅಗ್ರಿಮೆಂಟ್ ಥರ್ಡ್ ಪಾರ್ಟಿ ನಲ್ಲಿ ಸೂಟ್ ಹಾಕಿದ್ದಾರೆ ಬೇಸ್ಡ್ ಆನ್
ಅವರು, he was only
ಏಜೆಂಟ್ ಆಫ್ ಟ್ರೈಕಾನ್.
Tricon was agent of between both.
Defendant is the agent of TRICAN. The agreement is between
Defendant
Ratnagiri
ಅಲ್ಲ.
and
ಅವ್ರು ಹೇಳೋದು Tricon was the agent of plaintiff. To him they have placed the orders and all. They have-
No, my Lords, Tricon was the agent of the plaintiff.
That's what the brother was telling,
But
he was
here-
the defendant ಅಂತ ಅಲ್ಲ. Their case is Tricon was the agent of the plaintiff.
defendant is the agent of TRICAN.
ಅಲ್ಲ ಹಾಗಂದಂಗಿಲ್ಲ.
ಅಲ್ಲ,
Is it your
Lords,
case that
Tricon, my Lords, is the agent of the plaintiff. He is employed Tricon.
The defendant ಗೂ TRICAN ಗೆ ಏನ್ರಿ relationship?
Lords, Tricon is the one who issued orders and we've supplied. But our agreement, my Lords, is with Tricon.
Not that. Did you plead that Tricon was your agent also?
No, my
No.
Lords, no.
Yes, ಇಲ್ಲ. Yes,
he is a supplier.
correct. ಈಗ ನೀವು ರಿವ್ಯೂ ಮೇಲಿಂದ ಜಡ್ಮೆಂಟ್ಸ್
Already ನಾನು compilation ಕೊಟ್ಟಿದ್ದೆ. Now, before I go to the rulings, may I take you also to the provision of
ಯಾವ್ದು ಆರ್ಡರ್ 41 ರೂಲ್ 31
ಹೌದು, ಹೌದು.
ಅಲ್ಲೇ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರಲ್ಲ ಅದು
ಅಲ್ಲ ನಾನು
subsequent.
ಓದ್ಬಿಟ್ಟಿದ್ದು so that from the text.
ಅಲ್ಲ ಅವ್ರು ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ ಮಾಡಿದಾರೆ ಇದು ಆರ್ಡರ್ 41 ರೂಲ್ 31 ನೀವು ಓದಿದ ಜಡ್ಮೆಂಟ್ ಅಲ್ಲಿ
Order
ಜಸ್ಟ್
47, rule 1.
47 ರಿವ್ಯೂ
47.
ಮೂರಿದೆ. ಒಂದು ಎರರ್ ಅಪಿಯರೆಂಟ್
ಸ್ವಲ್ಪ ಅದ್ರಲ್ಲೊಂದು ನೈಸಿಟಿ ಇದೆ ನಾನು
ಆರ್ ಸಫಿಶಿಯಂಟ್ ಎನಿ ಸಫಿಶಿಯಂಟ್ ರೀಸನ್.
ಇಲ್ಲ ನಾನು ಹೇಳ್ತೀನಿ.
ಒಂದು ಎವಿಡೆನ್ಸ್ ವಾಸ್ ರಿಜೆಕ್ಟೆಡ್. ಎರಡನೇದು
Any person considering himself aggrieved
Hmm.
by a decree or order from which an appeal is allowed, but from which no appeal has been preferred, by a decree or order from which no appeal is allowed, or by a decision on a reference from a court of small causes, and who from the discovery of new and important matter or evidence which after the exercise of
Due
due
diligence.
diligence was not within his knowledge, that's not applicable, or could not be produced by him at the time when the decree was passed. That is also not there. Or order made, then, or on account of some mistake. Let us stop at it.
Please, sir.
Some mistake. My responsible submission is, having regard to the well-established principles of considering a first appeal, the judgment under review, but there is an error, mistake. It's a
But
mistake.
you are on the point of error, apparent on the face of the record.
I will analyze that also. This is a mistake where you consider the contentions we are urged before the appellate court on behalf of the appellant and also the respondent. But don't answer it. That's a mistake.
Yes,
Therefore, and while reversing the judgment, I've shown how the Honorable Supreme Court has dealt with what is the application to be made by the appellate court after examining everything on record. Then if you think that the judgment under appeal has suffered certain errors which cannot be endorsed by the appellate court in law, then there is a case for reversal. Not in this manner is myself. So it's a mistake. Then because there's next is or again. Or error apparent on the face of the record. Now, mistake on the face of the record ಹೇಳಿಲ್ಲ. Error, there is a difference between a mistake and error.
yes.
Therefore, they're compartmentalized. Or for any other sufficient reason. It's an omnibus. Now, we are a division bench of the High Court arguing an RFA. And when the judgment, arguments are heard and the judgment is reserved, it is our legitimate expectation that it will be considered according to the provisions of order. After the Milord, we argue and it's kept down for a pronouncement. We have no, control unless we file some IA to bring in something else. We only wait for the judgment. And when we, wait for the judgment, not this particular
And
judgment.
right, according to
And-
some
and-
point was not considered that it was error apparent on the face of the record.
ಅಲ್ಲ, ಅದು mistake ಸಹ.
All
Overall principles of disposal of RFA
mistake and error apparent. of
ಅಂತ
course.
ನಮ್ದು contention ಇದೆ.
ಹ್ಮ್.
Then and sufficient reason ತಾವು ನೋಡ್ಬೋದು.
Correct, ಅದಕ್ಕೆ ನಾವೀಗ ಹೇಳಿದ್ವಿ shows the judgment which
Yes.
amounts to error apparent on
Yes.
face of record ಅನ್ನೋದನ್ನ. We are relying on
Yes.
some judgment.
The fifth judgment on record, which I produced in the compilation, is report 2000 volume 6 SCC page 24. I request your lordships to kindly go over to page number 247. Judgment page number 247. Para 52. At the foot of page number 247, para 52.
Yes,
The dictionary meaning of the word review is the act of looking over something again with a view to correction or improvement. It cannot be denied that the review is the creation of a statute. This court in so and so held that power of review is not an inherent power. It must be conferred by law, either specifically or by necessary implication. The review is also not an appeal in disguise. It cannot be denied that justice is a virtue which transcends all barriers, and the rules of procedures or technicalities of law cannot stand in the way of administration of justice. Law has to bend before justice. Court finds that the error pointed out in the review petition was under a mistake, and the earlier judgment would not have been passed but for erroneous assumption, which in fact did not exist, and its perpetration shall result in miscarriage of justice. Nothing would preclude the court from rectifying the error. Then one ruling is extracted. Review literally and even judicially means re-examination or reconsideration. Basic philosophy inherent in it is the universal acceptance of human fallibility. Yet in the realm of law, the courts and even the statutes lean strongly in favor of finality of decision, legally and properly made. Exceptions, both statutorily and judicially, have been carved out to correct accidental mistakes or miscarriage of justice. Even when there was no statutory provision and no rules were framed by the highest court, indicating the circumstances in which it could rectify its order, the courts culled out such power to avoid abuse of process or miscarriage of justice. In so and so, the court observed that even though no rules had been framed permitting the highest court to review its order, yet it was available on the limited and narrow ground developed by the Privy Council and the House of Lords. The court approved the principles laid down by the Privy Council in so and so. That is, nevertheless, if by misprecision in embodying the judgments, errors have been introduced, these courts possess by common law the same power which the courts of record and statute have of rectifying the mistakes which have crept in. The House of Lords exercises a similar power of rectifying mistakes made in drawing up its own judgments, and this court must possess the same authority. The Lords have, however, gone a step further.
They are also not disputing court has the power of review another bit. But whether it is a case for review.
I am
that is
coming
the
to,
issue.
now ಏನಾಗುತ್ತೆ principles of review ನಾವು ನೋಡ್ಬೇಕಾಗುತ್ತೆ. Because there can't be a
So principles of review are good. One is
ಇಲ್ಲಿ ನಾನು ತೋರಿಸಿದ್ದೀನಿ ನಾನು ಏನಿದೆ ನಮ್ಮ ಕಂಟೆನ್ಷನ್ಸ್ ಅಂತ where the judgment is contrary to order 41 rule 31 and the settled principles laid down by the honorable Supreme Court. So that is the one point where Lords, this is a case for review. Only last three sentences in that same page 248. Rectification of an order thus stems from the fundamental principle that justice is above all. It is exercised to remove the error and not for disturbing finality. When the Constitution was framed, the substantive power to rectify or recall the order passed by this court was specifically provided in Article 137 of the Constitution. Our Constitution makers who had the practical wisdom to visualize the efficacy of such provision expressly conferred the substantive power to review any judgment or order by Article 137 of the Constitution, and Clause C of so and so permitted this court to frame rules as to the conditions subject to which any judgment or order may be reviewed. In exercise of power under Order 40 had been framed empowering this court to review an order in civil proceedings on the grounds analogous to Order 47 Rule 1 of the Civil Procedure Code. The expression for any other sufficient reason in the clause has been given an expanded meaning, and a decree or order passed under misapprehension of a true state of circumstances has been held to be sufficient ground to exercise the power. Apart from Order 40 Rule 1 of the Supreme Court rules, this court has the inherent power to make such orders as may be necessary in the interest of justice or to prevent the abuse of process of court. The court is thus not precluded from recalling or reviewing its own order if it is satisfied that it is necessary to do so for the sake of justice. Then I request kindly see one more paragraph, paragraph 56 at page 251.
yes.
It follows, therefore, that the power of review can be exercised for correction of a mistake, but not to substitute a view. Such powers can be exercised within the limits of the statute dealing with the exercise of power. Exercise power. The review cannot be treated as an appeal in disguise. The mere possibility of two views on the subject is not a ground for review. Once the review petition is dismissed, no further petition for review can be entertained. The rule of law of following the practice of the binding nature of the larger benches and not taking different views by the benches of coordinated court of in exercise of the powers under Article 136 or Article 32 of the Constitution, and upon satisfaction that the early judgments have resulted in deprivation of fundamental rights of a citizen or rights created under any other statute, can take a different view, notwithstanding the early judgment. But now, in any number of cases where Lord's law is laid down a few decades earlier, and again it needs to be reconsidered in the present circumstances, Supreme Court has taken a call and addressed as to whether that earlier ruling has to be reconsidered or not. And in a case where there have been a precedence for decades together, but
No, we are not. on
no,
that
therefore,
page.
then kindly come to the
No,
para 58 on the same rule, page 252. Otherwise also no ground as envisaged under 40 of the Supreme Court rules read with order 47 of the Code of Civil Procedure has been pleaded in the review petition on the facts of that case. Now, they have dealt with, I will not trouble you lordships with that. Then kindly come to the next ruling. That's a item 5 or 6. Reported in 1997, 10 SEC. Page 592. One paragraph from that. Yes,
That's the one.
Right. May I request your lordship to kindly take 1997 10 SEC, Mr. Kaivu. Page 592, one paragraph at page 597, para 7. In the light of these directions, your lordship's got
Yes.
it is obvious that the government of India had prepared the seniority list, the contention of the promotees, which was found acceptable to the tribunal, that preceding the date of amendment, the government was devoid of power to carry forward all unfilled vacancies to the effect recruits, and that all these vacancies are meant to be thrown open to the promotees. It is- So, and this court had suggested,
Misinterpretation of the rules ಆಗಿದೆ ಅಂತ ಹೇಳಿರ್ತಾರೆ.
ಹೇಳಿದ್ದಾರೆ.
And the tribunal had said that the such, when review was sought, that has to be corrected by the Supreme Court ಅಂತ
ಅದು
ಹೇಳಿದ್ದಾರೆ.
the Supreme Court has said that that is not the way the matter has to be
They
dealt with.
take out a particular part, they say that this amounts to misinterpretation of the rules. Error apparent on face of the record ಅಂತ ಹೇಳ್ತಾರೆ.
ಅದು ಹಂಗಿರುವಾಗ you exercise your power of review, but don't say let the Supreme Court deal with that matter. But that is what is the, purpose of this ruling. Then one more ruling which I have, relied upon is reported in 1971, volume 2 SEC, page 200. One paragraph at page number 203, para 13. This was a case where on para 13, on November 27, 1962, when the matter was heard by the High Court, this amendment did not come into the statute book. That is why the judgment debtor made an application to bring to the notice of the High Court that the law was that the words charged under decree were always deemed to have been deleted. And this law was effective from the date of coming into force of the 1952 Act on May 25, 1953. The High Court, by a majority opinion, was of the view that the judgment debtors should be given relief under Order 47 of the Code of Civil Procedure. The principles of review are defined by the Code, and the words any other sufficient reason in Order 47 of the Code would mean a reason sufficient on grounds analogous to those specified immediately previous to that order. The grounds for review are the discovery of new matters or evidence which, after the exercise of due diligence, was not within the knowledge, could not be produced by him at the time when the decree was passed or order made, or the review is asked for on account of some mistake or error apparent on the face of the record. In so and so of the report, the section does not authorize the review of a decree, which was right when it was for the appellant. It was made on the ground of the happening of some subsequent event. Counsel for the appellant submitted that when the High Court decided the matter, the High Court applied the law as it stood, and a subsequent change of law could not be a ground for review. The appellant's contention is not acceptable in the present case for two principal reasons. First, it is not a subsequent law. It is a law which all along was there from 1952. The deeming provision is fully effective and operative from May 25, 1953, when the 1952 Act came into force. The result is that the court is to apply the legal provision as it always stood. It would therefore be error on the face of the record. The error would be that the law that was applied was not the law which was applicable. Secondly, Section 4 of the 52 Act confers power on the court to apply the law, notwithstanding any provision contained in the Code of Civil Procedure. Therefore, the application, though instituted an application for review, was not so. The substance and not the form of the application will be decisive. There was a mistake in applying the provision of law as on the date of the judgment by ignoring the law which was already there in force. May I request the next ruling reported in 2000 volume 1 SEC page 666. Two paragraphs. Para 14 at page 672. A broader principle has been stated by the Honorable Supreme Court with regard to the review. At para 14 at the foot of page 672. The High Court is a court of record, as envisaged in Article 215 of the Constitution, must have inherent powers to correct the records. A court of record envelops all such powers whose acts and proceedings are to be.
Review ಬಗ್ಗೆ there is no dispute. Whether there is an error apparent, you are on the
Correct.
point of error apparent on the face of the.
That's what I pointed out, that there is a mistake in not following Order 41, Rule 31, having Milords made the points for consideration. And all the points for consideration are not addressed and no findings are returned on those points. And on the points which the judgment is, reversed. There is no reasoning how the trial court is wrong. Kindly appreciate, merely the first appellate court coming to the conclusion by reading a small truncated portion of the evidence and coming to the conclusion without dealing with the reasoning adopted by the trial court, without giving rendering a finding that the trial court, yes, was wrong in giving this finding. ಯಾಕಂದ್ರೆ issues ಏನು ಫ್ರೇಮ್ ಆಗಿದೆ ಅದರ ಮೇಲೆ findings ಬಂದಿದೆ in favor of the plaintiff. Now, whole hog on these two, points. One, the non-joinder of tricon and privity of contract. And in a contract of agency which is apparent on the face of the record, there need not be any direct contract, but that can be proved by there is other evidence available where I have made the payment directly to him. He has shipped part of the material to me. The gate passes which have come out from me, these are all things to be considered by the appellate court to come to the conclusion with regard to the privity of contract. Now, that consideration is not there. That is the error and that is the mistake. And my lord, the Supreme Court has dealt with the provisions of Order 41 in such a manner that it is as good as a continuation of the proceedings. It is for some purpose, because at the first court, appreciation of evidence, appreciation of facts, appreciation of law, they're all domain of the first appellate court, which is, clearly wanting in this judgment.
It's firstly, Milords, my learned senior friend Milords have virtually re-argued the whole case, Milords, like he's on appeal. Milords, the scope of review, Milords, is only to see, Milords, whether there is an error apparent on the face of the record. Milords, now to say that issues are not considered by the appellate court, Milords, your lordship may see just Order 41, Rule 33, Milords, power of an appellate court. Order 41, Rule 33, Milords.
Even 31 or 33?
Order 41, Rule 33.
33 is.
Milords, to say that a finding has to be given by the appellate court. Milords, that is not the issue, Milords. I'll only show 33.
Yes.
Thus, the appellate court shall have power to pass any decree and make order which ought to have been passed or made, and to pass or make such further or other decree or order as the case may require. And this power may be exercised by the court, notwithstanding that the appeal is as part only of the decree, and may be exercised in favor of all or any of the respondents or parties, although such respondents or parties may not have filed an appeal or objection, and may, where there have been decrees and cross suits, or where two or more decrees are passed in one suit, be exercised in respect of all or any of the decrees, although an appeal may have not been filed against such decrees. Lord, your lordship may see the first two lines, Milords. The appellate court shall have power to pass any decree and make any order which ought to have been passed. Look, my learned friend's contention, my lords, is that every issue has to be dealt with both by the lower court and the appellate court. My lords, here, my lords, an issue has arisen wherein, my lords, privity of contract has been raised. My lords, if that is raised, the privity of contract, my lords, once that issue is dealt with, and if the court holds that there is no privity of contract between the plaintiff and the defendant, my lords, there is no point in going further and considering other
He's
aspects.
saying you jump to order 41 rule 23, almost it is to dispense with order 41 rule 22, or what is the scope of that? You are saying under order 41 rule 31, appellate court is required to raise the points for determination and decide all of them.
My lords, that is not the issue at all, my lords. If the judge
Is
has
the
to,
issue raised by him,
my lords, but if your lordship
Not
sees
there.
33,
not in the appeal. Here, the point he is raising is that all the issues which ought to have been answered are not answered.
my lords, that is not the mandate of what 33 says, my lords. 33,
Preliminary issue, there is no privity of contract and that's what he submitted.
my lords, if there, my lords, one issue, my lords, if there is no contract between the plaintiff and the defendant, my lords, there is no point in seeing whether I've received consideration or whether I've not received consideration. The necessary party, my lords, is Tricon.
According to him, this order 41 rule 31, I mean, he has imposed an obligation on the first appellate court to decide all issues. You cannot say no.
My lords,
point.
that is why, my lords, if there is an obligation cast, my lords, power of appellate court should also be seen. My lords, if the appellate court, my lords, thinks fit that it does not need to decide issues on the issue of limitation or jurisdiction,
Shall anta ಇದೆ ಇದ್ರಲ್ಲಿ order 41 rule 31 shall ಇದೆ. I mean, shall state. Appellate court shall have power to pass.
it can pass any order is what my submission is.
ಇದು ಮಾಡ್ಬೋದು ಅದಕ್ಕಿಂತ ಎಕ್ಸ್ಪೆನ್ಸಿವ್ ಪವರ್ ಮೇಕ್ ಸರ್ಚ್ ಫರ್ದರ್ ಆರ್ಡರ್ ಮಾಡ್ಬೋದು ಫರ್ದರ್ ಡಿಗ್ರಿ ಆರ್ಡರ್ as the case may require it order 707 and this power will be exercised by the court notwithstanding that the appeal is
Lord, suppose, my lords, the learned trial court, my lords, frames about 10 issues and the appellate court, my lords, only raises points for consideration for 2 issues. My lords, the appellate court has power to only confine itself to 2 issues. It need not,
Any judgment on that?
my lords, I'll
point?
produce judgments, my lord, but the mandate of 33, my lords, is,
No, use
I'll produce
See.
judgments, my lord, but
41 rule 31 says one thing. You say you are trying to interpret order 41 rule 33. If some answers are sufficient to close the case, then court need not proceed or, I mean, traverse or
my
answer.
lords, that
other
is my
issues.
submission, my lords.
Correct. Have you got any
My
judgment?
lords, I'll
on the
produce
point?
judgments, my lords. But, my lords, prima facie, my lords, on the face of the judgment, my lords, there is no error, my lords, for him to say that the appeal should be reviewed, my lords.
ನಿಮಗಿರೋದು ಒಂದೇ ಡೌಟ್ ಈಗ ವೆದರ್ ಕೋರ್ಟ್ ಶುಡ್ ಹ್ಯಾವ್ ಆನ್ಸರ್ಡ್ ಆಲ್ ದ ಇಶ್ಯೂಸ್ ವಿಚ್ ವರ್ ರೇಸ್ಡ್ ಬೈ ದ
Lords, if the
ವಿಚ್ ವರ್ ರೇಸ್ಡ್ ಹಿಯರ್ ಫಾರ್ determination.
Lords,
He is saying that the check was issued by the plaintiff to the defendant. Even assuming that there was no privity of contract, whether he had received the money from him or not, that is the question.
Irrespective of whether I've received money or not, my lords, Tricon should have made a party. If Tricon were made a party, my lords, the liability would be on him. He would have been made liable for the amounts.
If you receive the money from A to B, suppose B receives money from A and A files a suit, whether he is bound to again prove that I had routed the
Lords,
money.
he is engaged the services of Tricon.
Is also party and suit cannot be dismissed for non-joiner of necessary party. Then we have to give them the direction. If they do fail to, implead them, then it has to be dismissed. Is that the law or not?
No, that was not, I examined the,
Is it
ಇಲ್ಲ
the law or not?
ಇಲ್ಲ ಆ ಸಿಚುವೇಶನ್ ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಆ ಸಿಚುವೇಶನ್ ಇರ್ಲಿಲ್ಲ.
Cannot be. Order 1 rule 10 ಅಲ್ಲೆಲ್ಲೋ ಬರುತ್ತೆ.
ಹೌದು ಬರುತ್ತೆ.
Cannot be dismissed. Direction has to be issued to the party to implead him. Despite that direction, if he fails to implead, then it has
Lords,
to be
non-joinder of parties was not an issue before the lower court. That issue, my lords, was raised by the learned by the learned division bench in the appeal.
That's
No.
what he was also trying. It was not before the trial.
Lords,
court
that is
also.
not the issue at all, my lords. My issue is only with regard to privity of
Correct,
contract.
that ಅವರು ಅದನ್ನೇ ಹೇಳ್ತಿದ್ದು. That was not the issue. This point was not raised ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ. ಅದು appellate.
ಅಲ್ಲಿ ಫಸ್ಟ್ ಅಪರ್ಚುನಿಟಿ ಮಾಡಬೇಕು ಅಂತ ಇದೆ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಸಹ ಡಿಫೆಂಡೆಂಟ್ ಕ್ಯಾನ್ ರೇಸ್ ದಟ್ ಇಶ್ಯೂ. ನೆಸರಿ ಪಾರ್ಟಿ, ಪ್ರಾಪರ್ ಪಾರ್ಟೀಸ್. ಅಗೇನ್ ಇಟ್ ಹ್ಯಾಸ್ ಟು ಬಿ ಅನಲೈಸ್ಡ್.
Appellate stage ಅಲ್ಲೇನು suit cannot be dismissed on that ground ಅಂತಾನು judgment ಇದೆ.
ಹಾ, correct.
First has to be directed to implead
Yes,
them ಅಂತ ನೋಡೋಣ. ಏನ್ citation ಕೊಡ್ತೀರಾ ಕೊಡಿ ಹಾಗಿದ್ರೆ. Any other point? ಬೇರೆ ಇನ್ನೇನಾದ್ರು?
Lords, apart from that, my lords, it's decided on merits, my lords.
Yeah, he says that this is the error apparent on record.
my lords, even if there is a error, my lords,
Not consider the merits of the other issue. We have told that to him.
my lords, in effect, my lords, he's virtually re-argued the case, my lords, like he's an appeal. My lords, this is a fit case, my lords, that should have been.
We told him, this point we cannot consider reappreciation of the evidence. Still, they are repeating whether this amounts to only this point.
ಯಾಕಂದ್ರೆ the first time the matter is coming before this combination, then I had to give some basis, my lords, for the
ಯಾವತ್ತು ಕೊಡ್ತೀರಾ? When are you going?
My lords, day after, my lords.
Next week ಎಲ್ಲ ಬರೀ holidays ಏ.
eighth Monday, next Monday, subject to the court's calendar. Monday is a working day.
Leave ಹಾಕಿದ್ರೆ ಮಾಡಿ. ನೀವು ಹೋಗ್ತೀರಾ? ಒಂದು ಎರಡು ದಿವಸ ಈಗ ಇದೇ ವಾರದಲ್ಲೇ ಹಾಕಿಲ್ಲ. Fourth.
Sorry.
Third in part, as requested by 11 council correspondent, this from fourth.
Grateful.
ಈ date, madam?
4-4.
Very good.
ಆ ಸೈಟೇಷನ್ ಅವ್ರು ಹೊಳ್ಕೊಡಿ, ಸರಿಯಾಗಿ ಇಂಡೆಕ್ಸ್ ಮಾಡಿ ಪೇಜ್ ಇನಿಷಿಯೇಷನ್ ರನ್ನಿಂಗ್ ಪೇಜ್ ಹಾಕೊಡು ಅಂತ ಹೇಳಿ.
Yes, I'll do that.
For admission, seal number 5, SPP, Sunil Narayan Naik.
Respond number 1.
ಅದೊಂದು ಸಬ್ಮಿಷನ್ ಮೇಲೆ ಮಾಡ್ಬಿಡ್ತಾ ಇದ್ದೀನಿ ಅದೊಂದು ಓವರ್ ಡಿಫ್ರೆಂಟ್
ಅದು ಒಂದು NCF ಗೆ ಅದಕ್ಕೆ ಡೈರೆಕ್ಷನ್ ಕೊಟ್ಟಿದ್ದಾರೆ. This, what is this?
My lord,
25.
this is, my lord, for the offense punishable under section 376 subclause 2, small I and 506 of IPC section 4, 5, small l.
Supported ಅಲ್ವಾ?
No, my lord, in this matter, my lord, in 164 statement, my lord, which came to be marked as exhibit P1, my lord, wherein she supports the case of the prosecution. Whereas in the cross examination, my lord,
ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಜಡ್ಜ್ಮೆಂಟ್ ಓದಿದೀವಿ ನಾವು. ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್
chief ಅಲ್ಲಿ support ಮಾಡಿದಾರೆ, cross
ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಇಟ್ ವಾಸ್ ಅನ್ ಅಫೇರ್ ಅಂತ
affair, love affair ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಸಪೋರ್ಟ್ ಮಾಡಿದ್ದಾರೆ. ಮೆಡಿಕಲ್ ಎವಿಡೆನ್ಸ್ ಇದೆ.
Medical evidence is completely supporting, my lord.
ರೆಕಾರ್ಡ್ಸ್ ಬಂದಿದೆ. ಬಂದಿದೆ.
Medical report is against to victim complaint.
Pardon?
Medical examination are against to.
But 164 statement was given
Yes, ma'am.
and other official witnesses supported.
Support.
Mother is also examined and
Mother is examined, my lord. She has supported the,
support.
she is the complainant in this case. And for the age proof, my lord, on the date of incidence, he was 16 years of age, my lord. Age, date of birth certificate is also produced by the person.
Paperwork shall be prepared within 4 weeks. List after 4 weeks.
Please, ma'am.
Number 6, Deepak Bhaskar, Arun Ashok Gadak, SPP Farhan.
For appellants, my lord, the counsel on the matter is sick. A week's accommodation may be given.
Mother's appeal. She has supported in this case. This complaint has supported mother's appeal.
PW1.
Complainant is the mother.
This watchman case alva ena.
Yes, ma'am.
Will admit, Mr. Counsel. She has supported, will admit and
I will argue. Lord.
admission mela.
Admission.
Admission mela.
I
They have supported. Will mother has supported.
Let a date may be fixed, my lord, because there is an urine infection of the child.
Pardon?
Urine infection ಇದೆ ಮಗುಗೆ. ಅದನ್ನ ಅವರು sexual harassment ಅಂತ ಹೇಳ್ತಾರೆ. The doctor has not supported the case. It's a very clear cut case. Let the date may be fixed, my lord.
Please, correct, will admit the matter. We'll hear you in detail.
Please, sir, please.
You are advocate on record.
Yes.
She was seeking time.
Yes, I am not keeping
Had
it,
admit.
that's fine.
Had admit. Okay.
File the paperwork.
paper, you are going to file or register in a file?
Over there.
We will file, we'll do the.
ಎಲ್ಲ ಇದೆಯಾ? All copies you have?
We have records, we will file.
ಮತ್ತೆ ಅದು ಬಂದಿಲ್ಲ, ಇದು ಬಂದಿಲ್ಲ ಅಂತ ಹೇಳಿ ಮತ್ತೆ ಆಯ್ತು. ಅಪೆಲೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ undertakes to file the paperworks. She shall file the paperworks within 4 weeks, just after 4 weeks.
My lord, can be date may be fixed, my lord.
4 weeks of date.
Go to the court of Karnataka. 27/5.
27th, all right.
Very well.
Bill number 7, SPP, Shivshankarappa for R1 to R6.
Appear for appellant, my lordship.
I am affair for respondent 1 to 6.
This appeal is preferred challenging the order of acquittal under section 302, 201 and 120B of IPC, my lordship. The case is based on the circumstantial evidences, my lordship. Accused number 1 is the husband of the deceased, my lordship. He is the doctor. According to him, while coming from her native, picking up the disease and coming towards Hassan, my lordship, he stopped the car to attend the nature call of the deceased, my lordship. That time snake was bitten her. That time he went to Hebri police station and filed the complaint for the snake bite, my lordship. But in postmortem report, my lordship, there is no such injuries were found in the below the knee part of the body, my lordship. Only on the right shoulder, there were 2 puncture mark was found, my lordship. That 2 syringes were recovered and it was sent to the FSL report that venom poison was traced in that syringe, my lordship. And death is also due to injection of the, it is observed in the page number 15 of the judgment, my lordship. At the end, my lordship, first paragraph.
Injection of cobra snake venom.
The injection of cobra snake venom cannot be ruled out, my lordship. His final opinion was marked as exhibit P57. His final opinion dated so and so was marked as exhibit P59. So the prosecution has no conclusive opinion on homicidal death. Injection mark is there on the right shoulder, my lordship. Puncture mark clearly explained in the postmortem report also. Hence this intervention of this honorable court is very much required.
Will admit the matter.
The appreciation ಬೇಕು.
Hard admit. ಇದರಲ್ಲಿ ಇದು ಬಂದ್ಬಿಟ್ಟಿದೆಲ್ಲ ಪೇಪರ್ ಇದು TCS paper shall be prepared within 4 weeks. List after 4 weeks. List for final hearing after 4 weeks. Yes.
For final hearing, seal number 8 adjourned, seal number 9, BP, Satish Shargirji.
Appeal for appellant in this case. Case, complainant needs to be in a party, my lordship.
Complainant? SC/ST sir. No, SC/ST. Who is the
Filing the
complainant?
application, my lordship.
Who is the
Morning, other side advocate was present and addressing that they were going to settle the matter, something like that.
settle ಮಾಡ್ತಾರೆ?
Settle ಮಾಡ್ಕೊಂತೀವಿ ಅಂತ ಏನೋ ಹೇಳ್ತಾ ಇದ್ರು. ಗಿರ್ಜಿ ಸರ್ ಹೇಳ್ತಾ ಇದ್ರು.
ಅವ್ರು ಹೇಳ್ತಾರೆ. D07, P26. ಏನ್ ಸೆಟ್ಲ್ ಮಾಡಿದ್ರೆ 482 ಹಾಕ್ತಾರೆ ಅಥವಾ ಏನಾರು ಹಾಕ್ತಾರ? Submits application for impleading. He was PWS to Kiran.
PW1.
Is informant come a victim, huh?
Yes, my lordship. PW1, my lordship, victim, my lordship. Victim come and complainant.
Informant.
Yes, my lordship.
The informant slash PW1 as a respondent number. ಎಷ್ಟಾಗ್ತಾರೆ ಇಲ್ಲಿ? ಇದು ಬರ್ದಿಲ್ಲ. ನೋಡಿ. ಗಿದ್ದವ್ರು ಒಂದಾಗ್ತಾರೆ. ಅಪ್ಲಿಕೇಶನ್ ಹೇಳಿದಾರ ಇಲ್ಲಿ 1 ಅಂತ ಬರ್ದಿದ್ದಾರೆ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 12. Okay. The matter involves the offences under the SC/ST Act. In view of section 15.
Direct ಆಗಿ allow ಮಾಡ್ಬಿಡು.
ಅದನ್ನೇ ಎಲ್ಲ ಮಾಡಿ. 15 of the Act. Victim/informant is a necessary party and has a right of audience. Therefore, the application is allowed. The appellant shall implead the proposed, sorry, the informant slash PW1 as respond number 12. Also, comma, amend the appeal memo and furnish the copy of the amended appeal memo accordingly. I number, the application is disposed of accordingly. And doing the needful, ಈಗ ಅವ್ರಿಗೆ notice ಹೋಗ್ಬೇಕಲ್ಲ ಮತ್ತೆ. And doing, if the needful is done, issue notice to respond about 12. ಅವ್ರಿಗೊಂದು notice ಕೊಡೋಣ ಬಿಡಿ, ಅದು ಹೇಗಿದ್ರು ಏರ್ ಮಾಡಬೇಕು. ಅವ್ರಂತವ್ರನ್ನ ಐಡೆಂಟಿಟಿ ಯಾರು ಇದು ಮಾಡೋದು? ಎಲ್ಲಿ?
ವಕಾಲತ್ ಹಾಕ್ಸಿ ಅವ್ರ ಕಡೆಯಿಂದ.
ಕರೆಕ್ಟ್. ಈಗ ಹೇಗಿದ್ರು ಇಂಪ್ಲೀಡ್ ಮಾಡೋದು
Notice order ಆಗಿದೆ.
ವಕಾಲತ್ ಹಾಕಿಸ್ಬಿಡಿ, ಯಾರ್ದಾರ ಒಬ್ಬರ ಹತ್ರ ವಕಾಲತ್ ಹಾಕ್ಸಿ. ಈಸ್ ಇಂಪ್ಲೀಡೆಡ್ ನಾವು. ಆಯ್ತು, ಅದು ಆದ್ಮೇಲೆ ಅಲ್ವಾ ಅದು ಮಾಡೋದು, ಅಲ್ಲಿವರೆಗೂ ಬರೋದಿಲ್ವಲ್ಲ. ವಿತ್ಡ್ರಾವಲ್ಗೆ ಅದು ಬರುತ್ತಾ? ಕಂಪೌಂಡಿಂಗ್ ತಗೊಂಡಿದೆ 482 ನಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ ಸ್ಟೇಟ್ ಅಪೀಲ್. ಕರೆಕ್ಟ್. ಈ ಸ್ಟೇಟ್ನವ್ರು ಹೇಳ್ಬೇಕಲ್ಲ, ಈಗ ಇಫ್ ಹಿ ವಾಂಟ್ಸ್ ಟು ವಿತ್ಡ್ರಾ, ವಾಟ್ ಈಸ್ ಇಟ್? ಗೊತ್ತಾಯ್ತು ನೀವು ಹೇಳೋದು. ಯು ಫೈಲ್ ನೆಸೆಸರಿ.
ಅವ್ರ ತಗೊಂಡ್ ಏನ್ರಿ ಮಾಡೋದು? ವೈ ಯು ಆರ್ ಡೂಯಿಂಗ್ ದಿಸ್ ಥಿಂಗ್?
ಅಲ್ಲ, ಯು ಆಸ್ಕಿಂಗ್ ಟು ಫೈಲ್ ವಕಾಲತ್, ದೆನ್ ಇಫ್ ಯು ವಾಂಟ್ 482 ಏನೋ ಅಪ್ಲಿಕೇಶನ್ ಹಾಕೋಬೇಕಷ್ಟೇ ಅದ್ರಲ್ಲಿ. ಅಲ್ಲ, 482 ಪಾಶಿಂಗ್ ಅನ್ನತ್ತೆ, FIR ಪಾಸ್ ಆಗಬೇಕಲ್ಲ, ಅಕ್ವಿಟಲ್ ಡಿಸ್ಪೋಸ್ ಎಲ್ಲ ಆಗುತ್ತೆ. ಅಲ್ಲ,
ಡಿಸ್ಮಿಸ್ ಮಾಡ್ಬೋದು.
ಅದಕ್ಕೆ ಒಂದು ಸ್ಟೇಟ್ ಸ್ಟೇಟ್ಸ್ ಇಂಟ್ರೆಸ್ಟ್. ಅದಕ್ಕೆ ನಾನು ಆಯ್ತು, ಅವ್ರು ವಕಾಲತ್ ಹಾಕ್ಸಿ ಒಂದು ಏನಾರು ಬೇಕಂದ್ರೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಇದನ್ನ ನನಗೆ ಅಕ್ವಿಟಲ್ಗೆ ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಂತ ಅವ್ರು ಹಾಕ್ಸಿದ್ರೆ ಬೇಕಾದ್ರೆ ನೋಡಿ
ಮಾಡ್ಬೋದು.
ಆಯ್ತು. ಲಿಸ್ಟ್ ಆನ್ 4 weeks ಡೇಟ್ ಇದೆ. 4 weeks ಅಲ್ಲ, ಫಾರ್ ಮುಂದೆ ವರ್ಗ 2 weeks. ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ ಹಾಕೊಳ್ಳಿ, ಅಷ್ಟ್ರಲ್ಲಿ ಅವ್ರು ಮಾಡಿ. ಅಲ್ಲ, ಅವ್ರು ಮಾಡಿದ್ರೆ ಕ್ಲೋಸ್ ಆಗುತ್ತೆ, ಇಲ್ಲಾಂದ್ರೆ ಫ್ರೈಡೆ ಹಾಕೊಳ್ಳಿ.
2017
ಫ್ರೈಡೇನೆ ಹಾಕೊಳ್ಳೋಣ ಬಿಡಿ. ಫ್ರೈಡೆ ಬೈ ದಟ್ ಟೈಮ್ ಆಸ್ಕಿಂಗ್ ಟು ಫೈಲ್ ದ ವಕಾಲತ್. ಆಯ್ತು, ಲಿಸ್ಟ್ 5-4 ಅದು ಬೇಡ. ಅಲ್ಲ,
5-4 ಇರುತ್ತೆ ವಕಾಲತ್ ಇವತ್ತು.
at this stage, no counsel for the
Respondent 1 to 11.
ಅಲ್ಲ, is for the accused. Counsel for respondent 1 to 11 submits that the matter is settled. And it's settled. And proposed respondent is going to file necessary application. Necessary application / memo list on that.
5-4. Bill number 10, SPP, SG Rajendra Reddy, appeal for appellant state, your lordships.
ರಾಜೇಂದ್ರ ರೆಡ್ಡಿ ಅವರು ಯಾರಾದ್ರು ಸಂಪಂಗಿ ರಾಮಯ್ಯ ಅವ್ರದ್ದು ಇತ್ತಲ್ಲ, ಅದು ಯಾವ್ದು 12 ಅಲ್ಲ?
8 serial number 12, your lordships.
12-15 ಎರಡು ರೆಡಿ.
ಅಲ್ಲ, ಇದ್ರಲ್ಲಿ ಅದರ್ ಸೈಡ್ ಇಲ್ಲ, ಇದ್ದವ್ರು ತಗೊಳ್ಳೋಣ ಅಂತ.
Please.
ರಾಜೇಂದ್ರ ರೆಡ್ಡಿ ಇಸ್ ನಾಟ್ ದೇರ್, ಅದಕ್ಕೆ ಬೇಡ. ಕೆ ಚಂದ್ರಶೇಖರ್ ಇಸ್ ಆಲ್ಸೋ ನಾಟ್ ಸೀನ್. ಅವರು ಮೊನ್ನೆ ಹೇಳ್ತಾ ಇದ್ರು, ಅಂಡ್ ಹಿ ಇಸ್ ಫಾರ್ ದ ವಿಕ್ಟಿಮ್, ಹಿ ಆರ್ಗ್ಯೂಸ್. ಅವರೇನೋ ರೆಡಿ ಇಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದ್ರು ಸ್ಟೇಟ್ ಅವರು.
ರೆಡಿ ಮೇಡಮ್,
ರೆಡಿ ಇದೀರಿ ಈಗ. ಇದ್ರಲ್ಲಿ ಅವ್ರು ಯಾರು? ದೇಶಪಾಂಡೆ ಹೇಳಿದ್ರ? ಒಂದು ಫೋನ್ ಮಾಡಿ ಹೇಳಿ ಅವ್ರಿಗೆ ಅಷ್ಟೇ.
Number 12.
Yes.
appearing for the appellant statement. In the case, the accused is charged, my lord, for 376 clause 2N 506 of IPC, my lord, and 5 small things, clause 2 and 5 clause 1 of POCSO, my lord. The date of birth of the victim is 17/7/1997, my lord.
What is the document for that?
My lord, for date of birth, my lord, it is exhibit P8 which is the certificate, my lord. Birth certificate issued from the admission registrar of the school, my lord.
Birth certificate ಆಗೋದಿಲ್ಲ.
Admission registrar, not birth,
Text ಆಗ್ತದೆ.
PW2 was issued. ಜನ್ಮ ದಿನಾಂಕ ದೃಢೀಕರಣ ಪತ್ರ, which is exhibit P8, my lord. Which is issued by PW2, my lord. Who is a ಹಿರಿಯ ಸಹ ಶಿಕ್ಷಕರು. As per that, it is 17/7/1997, my lord.
Yes.
The date of incidence is on 31/2/2015, my lord.
31 to 2015.
15.
Okay, judgmentally, when there is 16, 4 months prior to 16/7/2015 ಅಂತ ಇದೆ.
That was the date when the incident was reported,
Report.
my lord. FIR was.
Then it 31 to 2000.
4 months before the filing of FIR, the incident has taken place, my lord.
31 to 2015.
Yes, my lord.
31 to 2015, date of offense. Time
11 PM. my lord.
11 PM or AM?
1 minute, my lord. 11 PM.
11 PM. Date of reporting is 16/7/2015.
16/7/2015, yes, my lord.
Yes.
In the instant case, my lord, victim is the complainant, my lord. Victim, the brief facts of the case, my lord, is on 31/2/2015, when the mother of the victim, who is PW4, had gone to her native place, my lord. Since as she heard the death of her father, my lord, the victim came to the house of the accused came to the house of the victim at around 11 PM, my lord, closed her mouth and forcibly raped her. And he also threatened her that he should not disclose it to anyone, my lord. And he would kill her if he discloses it to anyone, my lord. And this has come to light, my lord, after 4 months, when the aunt of the victim, when she asked the victim about why her menstruation cycle has not taken place. That time she revealed that the accused has committed forcible rape on the victim, my lord. PW. So the mom. PW3, my lord. When she goes to PW3 house and stays there for 15 to 20 days, this incident has come to light.
Accused was aged 28 years.
Huh?
Accused was aged 28 years.
Yes, my lord.
He was already married.
Yes, my lord. He states he's already married.
Married and having issues. Yes.
PW1, my lord, has fully supported the case of the prosecution in respect to the chief examination, my lord. And in the cross, she has been won over during cross-examination, my lord. There's a gap of 4 months, 2 days between the chief and the cross-examination, my lord. PW2, my lord, she is the senior teacher in the school. Since the principal was not there, she, based upon the admission register, my lord, has given the Janma Drudikarana Patra, which is exhibit P8, my lord. That is the certificate in which the date of birth is 17/7/1997, my lord. PW3 is the aunt of the victim, my lord. When the victim was staying in the aunt's house, she notices that her menstruation cycle of the victim has not taken place. On inquiry, the aunt, when she inquires the victim, she finds out that the victim states to her that there was alleged rape, forcible rape, which was done by the present accused, my lord. PW4, my lord, is the mother of the victim, my lord. PW4 has supported the case of the prosecution, my lord.
Weren't also supported, PW3?
PW
Partially.
partially supported,
Partially hostile.
hostile,
PW4 is also
partially hostile. PW5 is the uncle of the victim girl, my lord. He has supported the case of the prosecution, my lord. PW6 is the PDO, my lord. PW6 is the PDO. She has issued exhibit P9, which is Manaya Vasa Drudikarna Patra. That is the house extraction, my lord.
PW6.
6, my lord, is the PDO. PW7 is another aunt of the victim, my lord. She has come to know that the accused has committed the forcible rape on the victim girl. Here's a witness, ma'am. PW supported.
Yes.
PW8 is the Panchayat Dar, my lord. One Panchayat is convened in the village between the victim and the accused, parents of the victim, relatives and the accused, my lord. He is supported. And he is also a signatory to exhibit P3, which is the spot measure, my lord. PW9, my lord, is the doctor who first examined the victim in the Moodigere, my lord. Since there was no facilities to further examine, equipment was not there, he sent her to Chikmagalur District Government Hospital, my lord, for further examination. And based on the examination, exhibit P11 is the certificate, which is marked by PW9, my lord.
Exhibit is to?
Exhibit P11,
Yes.
which states that certificate states that victim was 16 weeks and 4 months pregnant.
Yes.
PW10 is, my lord, is the doctor who examined the accused, my lord. And he has given certificate to the effect that the accused is capable of committing sexual intercourse.
Yes. P is to?
Exhibit P14.
14, my lord, exhibit P14.
Yes.
PW11 is the doctor, my lord, who was examined the accused in Chikmagalur Government Hospital. According to her, my lord, the victim was aged about 17 years and she was pregnant for a period of 16 weeks. She has also issued a certificate, my lord, which is exhibit P17, P15, 16, 17. Exhibit P15, my lord.
Yes.
And even she has got marked exhibit P16, which is the MLC, my lord, and the P17, which is a hematology report. P12 is the WPC, my lord. She is the woman PC who has taken the victim to both the Moodigere Government Hospital for examination and the Chikmagalur Government Hospital for examination, my lord, along with the mother of the victim, who is PW4. Chikmagalur.
Yes.
PW13 is the IO to the case, my lord. He is the investigation officer, my lord.
Register, FIR register ಮಾಡಿದ್ದಾರೆ. Who registered the FIR?
The third sub-inspector,
CW 24, one Shivkumar, PSA.
He is not examining,
sub-inspector.
so he is only IO.
Only for the investigation. Okay, Shivkumar is the CW 24, sir.
CW 24 registered FIR,
Also. He was the PSI of Bantal Police Station.
164 state.
164 statement, my lord, is,
64 statement
is exhibit P6, my lord.
There she has supported.
She has supported, man, 164.
Yes,
My lord, the case in brief, my lord.
she was 17 plus,
17, she was 17 years, 8 months,
6 months.
5 months left.
5 months.
6 months.
17/7 1997, no,
And my lord,
another 5 months ಆಗಿದ್ರೆ 18 ಆಗ್ತದೆ.
Eight.
She delivered the baby on
24/12/15.
DNA ಮಾಡಿಸಿದಾರ?
DNA ಮಾಡ್ಸಿಲ್ಲ ಸ್ವಾಮಿ,
DNA ಮಾಡ್ಸಿ.
ಮಾಡ್ಸಿಲ್ಲ,
ಮಾಡಿಸಿ.
DNA ಮಾಡ್ಸಿಲ್ಲ.
ಡೆಲಿವರಿ ಎಷ್ಟು?
24/12/2015, live male baby, my lord,
The male baby is born.
born.
ಹ್ಮ್.
DNA ಮಾಡ್ಸಿಲ್ಲ.
Yes. Yes,
But the SPW one is the
Victim.
victim as well as complainant, sir.
Hmm.
She is fully supported the case of the prosecution in chief.
Hmm.
But in cross. But learned prosecutor has not treated as a, not treated as a hostile.
after cross examination she was treated as hostile or not? ಅವ್ರು ಮಾಡಿದಾಗ she became hostile when he was.
Hostile ಮಾಡಿಲ್ಲ sir.
ಅಲ್ಲ accused cross re-examination ಅಂತ ಮಾಡಿದ್ದಾರೆ.
Re-examination ನಲ್ಲಿ ಏನು ಹೇಳ್ಸಿ.
ಮರು ವಿಚಾರಣೆ ಮಾಡಿದ ಸ್ವಾಮಿ,
ಮಾಡಿದ್ದಾರೆ ಮರು
ಮಾಡಿದ್ದಾರೆ.
ನಾನು ಆರೋಪಿಯೊಂದಿಗೆ ರಾಜಿಯಾಗಿ
About 4 lines.
ಸುಳ್ಳು ಹೇಳುತ್ತಿದ್ದೇನೆ ಎಂದು
ಅಲ್ಲದೆ
ಹೇಳು ಸರಿಯಾಗಿ.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಮಾಡಿ 164 ಸ್ಟೇಟ್ಮೆಂಟ್ ಕನ್ಫ್ರಂಟ್ ಮಾಡ್ಲಿಲ್ಲ.
ಮಾಡಿಲ್ಲ. That is not.
ಏನ್ ಮಾಡೋದು ಹೇಳಿ? ಸ್ಪೆಷಲ್ ಪಬ್ಲಿಕ್ ಪ್ರಾಸಿಕ್ಯೂಟರ್ಸ್.
ಇದರಲ್ಲಿ ಒಂದೇ ಒಂದು ಪಾಯಿಂಟ್. ಇಲ್ಲಿ ಪೇಜ್ 45 ಆಫ್ ದಿ ಪೇಪರ್ ಬುಕ್ ಒಂದು ಸರ್ತಿ ನೋಡಿ. ಪೇಜ್ 45
ಎಸ್ ಓದಿ ಯಾವ ಪ್ಯಾರಾಗ್ರಾಫ್?
ಅಲ್ಲಿ ಪ್ಯಾರಾ 20 ನಲ್ಲಿ ಆರೋಪಿ ನನ್ನ ಇಚ್ಛೆಗೆ ವಿರುದ್ಧವಾಗಿ ನನ್ನ ಮೇಲೆ ದೈಹಿಕ ಸಂಪರ್ಕ ಹೊಂದಿದ ಎಂದು ನಾನು ವೈದ್ಯರ ಮುಂದೆ ಹೇಳಿಲ್ಲ. ನಾನು ಹಾಗೂ ಆರೋಪಿ ಈಗ ಮದುವೆಯಾಗಿ ನಮ್ಮ ಮಗುವಿನೊಂದಿಗೆ ಜೊತೆಯಲ್ಲಿ ವಾಸವಾಗಿದ್ದೇವೆ. This has to be ascertained, my lord. If it is ascertained and it is correct, then we. According to our information, my lord, this is false.
As per the
Yes.
as per the information
married and
by
he's
the
not.
state also, my lord.
Only a producer before the court.
My lord, I have filed-
ಲಾಸ್ಟ್ occasion ನಾನು ಅದನ್ನೇ ಹೇಳಿದೆ.
I have spoken to the jurisdictional police, my lord.
ಆಕೆ ಬಂದು ಕೋರ್ಟ್ ಮುಂದೆ ಮದುವೆ ಮಾಡ್ಕೊಂಡಿಲ್ಲ ಅಂದ್ರೆ then the entire case will be.
ಅಲ್ಲ ಬಟ್ ಮದುವೆ ಆದ್ರೂ ವಾಟ್ ಸ್ಟೇಟಸ್ ಶಿ ಗೆಟ್ಸ್? ಆಲ್ರೆಡಿ ಒಂದು ಮದುವೆ ಆಗಿ ಒಂದು ಮಗು ಇದ್ರೆ ನಾಳೆ ಪ್ರಾಪರ್ಟಿ ಇಶ್ಯೂ ಎಲ್ಲ.
ಎನ್ಕರೇಜ್ ಮಾಡಕ್
ಆಕೆಗೆ
ಮ್ಯಾರೇಜ್.
Yes, what is your information? What he is saying? I mean, she says that she has married you and she is living
they are living together
ಅಲ್ಲ.
as a husband and wife.
Hmm.
Because according to
So you are not ready to admit marriage also because ಮುಂದೆ ಏನೇನಾದ್ರೂ ಬರುತ್ತೆ.
our evidence before the court, my lord.
ಕರೆಕ್ಟ್. ಕ್ಲೈಂಟ್ ಏನ್ ಹೇಳ್ತಾರೆ?
My client
And he was already married and was having a child.
subsequently panchayat.
ನೀವು ಮದುವೆಯಾಗಿ ನಿಮ್ ಜೊತೆ ಇದ್ರೆ ಮಗನ್ ಜೊತೆ ನೀವು ಕರ್ಕೊಂಡ್ ನಿಮ್ತೆ ಕೋರ್ಟ್ ಮುಂದೆ.
ಮದುವೆ ಅವ್ರು ಹೇಳೋದು ಮದುವೆ ಆಗಿದ್ದೆಲ್ಲ ಒಪ್ಕೊಳಕ್ ಈಸ್ ನಾಟ್ ರೆಡಿ ಟು ಅಕ್ಸೆಪ್ಟ್ ದ ಮ್ಯಾರೇಜ್. ಜೊತೆಗಿದ್ದಾರೆ ಅನ್ನೋದನ್ನ ಒಪ್ಕೊಳ್ತಾರೆ.
ಅಷ್ಟೇ.
ಟೂ ಮಾಡರ್ನ್.
Because then it is, if I marry subsequently, my lord, 494 is bigamy.
ಅಲ್ಲ ಅವ್ರು ಹಾಕಿದ್ರೆ ವೈಫ್ ಹಾಕಿದ್ರೆ ಅದು ಲೋಕಲ್ ಸ್ಟ್ಯಾಂಡ್ ಇಲ್ಲ.
First child.
ಫಸ್ಟ್
ಫೈಲ್ ಮಾಡಿದ್ರೆ ಮಾತ್ರ ಅಷ್ಟೇ, ಅದರ್ವೈಸ್ ಅದೇ ಇಲ್ಲಿ ಬರಲ್ಲ.
Check ಮಾಡ್ಬೇಕು.
ಇವ್ರದ್ದು ವಾಲಂಟ್ರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇದೆಯಾ? ಮಾರ್ಕ್ ಆಗಿದೆ ಅಲ್ಲ ಏನಾರ?
164
ಅಲ್ಲ ಅದು
Even
ಇವನಿಗೆ ಎಷ್ಟು
my
ಮಕ್ಳು ಇದ್ದಾರೆ?
entire cross examination, kindly see the cross examination.
ಮಾತಾಡಿಲ್ಲ. Exhibit P 21, my lord. One is the voluntary statement of the accused.
ಅಲ್ಲಿ ಎಷ್ಟು ವಯಸ್ಸು ಎಷ್ಟು ಮಕ್ಕಳಿದ್ದಾರೆ ಏನೋ ಒಂದ್ ಸ್ವಲ್ಪ ಹೇಳ್ತಾರೆ ನಾಟ್ ದ ಎಂಟೈರ್ ಸ್ಟೇಟ್ಮೆಂಟ್ ಇಸ್ ನಾಟ್ ಅಡ್ಮಿಸಿಬಲ್. ಅದು ಯಾಕೆ ವರ್ಕ್ ಮಾಡಿದ್ರೆ ಗೊತ್ತಾಗ್ಲಿಲ್ವಲ್ಲ ಇದನ್ನು ಏನಾದ್ರು ರಿಕವರಿ ಇದೆಯಾ?
Okay, so
Page 117 last para on ನೋಡ್ಬಿಟ್ರೆ ಆಯ್ತು.
ಅಲ್ಲ ಅದು ಟಾಡಾ ಕೇಸಲ್ಲಿ ಅದೆಲ್ಲ ಆದ್ರೆ ದಟ್ ಇಸ್ ಅಡ್ಮಿಸಿಬಲ್. He is ಆಟೋ ಡ್ರೈವರ್.
ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಅಲ್ಲಿ ಮದುವೆ ಆಗಿರೋದು ಒಪ್ಕೋತಾನೆ. ನನ್ನ ಹೆಂಡತಿಯೊಂದಿಗೆ ವಾಸವಾಗಿರುತ್ತೇನೆ. ನನ್ನ ತಂದೆ ತಾಯಿ ನಾವು 4 ಜನ ಹೆಣ್ಣು ಮಕ್ಕಳು ನಾನಾಗಿರ್ತೇನೆ.
ನಾನು ನನ್ನೇ ತಂದೆ ತಾಯಿ ಅಲ್ಲ ಅದರಲ್ಲಿ
1 ತಿಂಗಳ ಹಿಂದೆ ನಾನು
ಅವರಿಗೆ ಎಷ್ಟು ಮಕ್ಕಳು ಅಂತ ಬಂದಿಲ್ಲ. ಜಸ್ಟ್ ಐ ವಾಂಟೆಡ್ ಟು ಸೀ.
ಅರೆಸ್ಟ್ ಆದಾಗ ಬರೀ ಮದುವೆ ಆಗ 1 ತಿಂಗಳಾಗಿದೆ. 1 ತಿಂಗಳ ಹಿಂದೆ ಪವಿತ್ರ ಎಂಬುವನು ಮದುವೆ ಆಗಿದೆ.
1 ತಿಂಗಳ ಮೊದಲು ಮದುವೆ ಮಾಡ್ಕೊಂಡು
ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟಾಗ
ಹೀಗೆ 1 ತಿಂಗಳ ಹಿಂದೆ
ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಟ್ಟ
both of them. Voluntary statement.
1 ತಿಂಗಳ ಹಿಂದೆ
ಹ್ಮ್.
ವಾಲಂಟರಿ ಸ್ಟೇಟ್ಮೆಂಟ್.
ಕೇಸ್ ಸ್ಟಾರ್ಟ್ ಆಗಿದ್ದೆ ಅಲ್ಲಿಂದ.
ಇದೀಗ
ಇವಳು ಬಿಟ್ಟು ಇನ್ನೊಬ್ಬಳು ಮದುವೆ ಆಡ್ಕೊಂಡಲ್ಲ.
ಅಲ್ಲ ಇವ್ರನ್ನ ಇದು 2015 ಅಲ್ಲಿ. But still if we keep on condoning these things, they try for the third one, fourth one.
ಕಂಟ್ರೋಲ್ ಮಾಡಿದ್ರೆ ಆಗೋದೇ ಇಲ್ಲ ಸ್ವಾಮಿ. ಪಾಪ ಅಮಾಯಕ ಹೆಣ್ಣು ಮಗಳಿಗೆ ಅನ್ಯಾಯ ಆಗಿದೆ.
Even if they are living together, we have our own doubt whether respectfully or in
ಅದು ಇಲ್ಲ ಸ್ವಾಮಿ.
treating ಅಂತ.
ಅಲ್ಲ ಅದು ಇಲ್ವಲ್ಲ.
You only ask the local police to produce her.
Already I have spoken, my lord. Today morning I informed the local jurisdiction police, my lord. They have told that 1 day time ಕೊಟ್ರೆ ಹೋಗಿ ಕರ್ಕೊಂಡ್ ಬಂದ್ಬಿಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ.
ನಾಳೆ 3ನೇ ತಾರೀಕಿಗೆ ಬುಧವಾರ ಹಾಕೊಂಡ್ಬಿಡಿ ಸ್ವಾಮಿ, ಬಂದ್ಬಿಟ್ರೆ ಮುಗಿದ ಹೋಗ್ಬಿಡು.
ಒಂದೇ ದಿನ 1.5 ದಿನ
ಆಯ್ತು.
ಬುಧವಾರಕ್ಕೆ ಹಾಕೊಂಡ್ರೆ
ಕೌನ್ಸಿಲ್ ಫಾರ್ ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1.
ಐ ಆಮ್ ಫಾರ್
ಸರಿ ಇಬ್ರು ಎಲ್ಲರೂ ಹೇಳಿ. ರೆಸ್ಪಾಂಡ್ ನಂಬರ್ 1 ಅಲ್ಲ ನಿಮ್ ಪ್ರಕಾರ ಮದುವೆ ಆಗಿದೆ ಅಂತ
ಆಗಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ ಸ್ವಾಮಿ.
ಕೌನ್ಸಿಲ್ ಫಾರ್ it is submitted. It is submitted that now appellant
ಎಲ್ಲ ಸ್ವಾಮಿ ಆಕೆ ಬಂದು ಹೌದು ಮದುವೆ ಮಾಡ್ಕೊಂಡಿದ್ದಾನೆ, ನನ್ನ ಮಗುನ್ ಚೆನ್ನಾಗಿ ನೋಡ್ಕೊಂಡಿದ್ದಾನೆ ಅಂದ್ರೆ
are living together. But as per the record, accused respondent was already married and married. HCP is requested keep
Victim present.
to direct the concerned police to keep the victim present. ಎಷ್ಟು PW ಎಷ್ಟಕ್ಕೆ?
One my lord.
PW1 present on the next hearing date. List on
ಥರ್ಡ್ ಮೇಡಮ್.
Fourth madam.
4th ಆಗಲ್ಲ ಸ್ವಾಮಿ, ನನಗೆ ಪರ್ಸನಲಿ
Third family.
ಅವ್ರು ಬರೀ ಅವ್ರನ್ನ ಕರ್ಕೊಂಡ್ ಬಂದ್ರೆ ನಾವು ವಿಚಾರಿಸ್ತೇವೆ ಅಷ್ಟೇ. ನೀವ್ ಹೇಳೋದನ್ನ
Argument ಮಾಡ್ತಾರೆ.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋದಕ್ಕ
5th.
ಆಯ್ತು 5th ಹಾಕಿ. 5th ಆಗ್ಬೋದಾ ಮಿಸ್ಟರ್ ಉಮೇಶ್? 5-4
Oblige.
ಎಷ್ಟು ಗಂಟೆಗೆ ಕರ್ಕೊಂಡ್ ಬರ್ತೀರಿ? 1 ಗಂಟೆಗೆ ಬರ್ತೀರಿ.
ಸ್ವಾಮಿ 4ಗೆ ಹಾಕೊಂಡ್ಬಿಡಿ 5th ಬೇಡ.
ಅವ್ರಿಗೇನೋ
4ಗೆ ಹಾಕೋದು 4 ಅವ್ರಿಗೂ ಆಗುತ್ತೆ.
ಆಯ್ತು 4th
1 ಗಂಟೆಗೆ 1 PM.
ಮುಗಿತಾ ಬಂದು
ನೀವೇ
4th. Seal number 13, ಕೆಂಪರಾಜು.
ಇನ್ನೊಬ್ರು ಯಾರು? ನೀವೇ ಇಲ್ಲ ನೀವು ಇನ್ನೊಂದ್ರಲ್ಲಿ
15
ಅದರಲ್ಲಿ 15
13 ಅಲ್ಲಿ ಯಾರಿದ್ದಾರೆ? ಇದಾರ
ಕುಮಾರ್ ಬಾಲಕೃಷ್ಣ.
Seal number 13, ಕೆಂಪರಾಜು.
ರಿಪೀಟ್ ಮಾಡಿದ್ವಿ ಎಲ್ಲ ಮಧ್ಯಾಹ್ನ. ಇವತ್ತು ಬೆಂಚ್ ಬೇರೆ 13 ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ನಾಳೆಗೆ ರಿಸೀಟ್ ಮಾಡ್ತೀರಾ? ಆಮೇಲೆ ಅದು ಇನ್ನೊಂದು ಯಾರು ಇನ್ನೊಬ್ರು
Seal number 10 ಮತ್ತೆ
10 and 11 ನೋ ರೆಪ್ರೆಸೆಂಟೇಷನ್ ಫಾರ್ ದ ರೆಸ್ಪಾನ್ಸ್ ಲಿಸ್ಟ್ ಮಾಡು. ನಿಮ್ದು
Seal number 14.
My lordship,
MR ಬಾಲಕೃಷ್ಣ.
complainant has to be made party, my lordship, in this case.
ಇದರಲ್ಲಿ ಏನಿದೆಯಾ?
Is the complainant or father of the victim, my lordship.
ನಾವೇ ಡೈರೆಕ್ಟ್ ಹೇಳ್ಬಿಡ್ತೀವಿ ನಿಮ್ಮನ್ನ, ನಿಮ್ಮ ಅಪ್ಲಿಕೇಶನ್ ಬೇಡ ಬಿಡಿ. You do that. ಆ ಟೈಪ್
No.
ಮಾಡ್ಕೊಂಡು ಬರೋದ್ರ ಬದಲು ನಮ್ದು ಇಮಿಡಿಯೇಟ್ಲಿ ಅಪೀಲ್ ಮೆಮೊ ಅಮೆಂಡ್ ಮಾಡಿ ಪ್ರೊಸೆಸ್ ಕೊಡಿ.
Please, ma'am, in the,
Here.
we have kept it ready, my lordship, for more than 21 matters.
So 21 ಕೇಸ್ ಅಲ್ಲಿ ರೆಡಿ ಇಟ್ಟಿದಾರಂತೆ. Will value their labor. CP submits application.
ಅದು other side ಗೆ serve ಮಾಡ್ತಾರೆ.
ಅರೆನ ಇಂಪ್ಲೀಡ್ ಮಾಡೋದಕ್ಕೆ
In the previous lot,
ಲಿಸ್ಟ್ ಆಫ್ 21 ಕೇಸು ಕೊಡಿ ಮೇಡಮ್, ಪೋಸ್ಟ್ ಮಾಡ್ತೀವಲ್ಲ.
please,
ನಾವು ಹಿಂದೆ ಹೇಳಿದ್ವಲ್ಲ
ಮೊನ್ನೆ ಹೇಳಿದ್ವಲ್ಲ.
ಅದು ನೀವು ಕೊಟ್ಬಿಡಿ.
ನೋಡಿ,
ಅದು ಎಷ್ಟು
21
21 ಕೇಸ್ ಯಾವ್ದಿದೆ ಅಂತ ಕೊಡಿ, ಯಾಕಂದ್ರೆ ಅದು ಆಲ್ರೆಡಿ ಆಗೋಗಿರೋದಿದೆ ಏನು ಅಂತ.
in that nearly 10 cases already this court has taken issued notice also. In remaining, we will provide it.
Direct to list them on single day. Whom do you want to include now?
PW1. PW1, my lordship, complainant.
Informant, Allah?
Yes, my lordship.
The informant. PW1 as correspondent. The matter involves the offences under the POCSO Act. The victim slash informant has the right of audience in the matter. Therefore, the appellant is permitted to implead PW1 slash informant as respond number 2 now. Respond number 2. Respond number 2, comma, amend the appeal memo and furnish the copy of the amended appeal memo accordingly. If needful is done, issue notice to respond number 2, list on
23-4.
23.
Bill number 15, SPP, Vivo Chandrasekhar, NS Sampangi Ramaya.
Appear for complainant now, as custody.
Chandrasekhar case is clear. Chandrasekhar, where? You are Vivo Chandrasekhar. Yes.
Status prefer the appeal against the acquittal order under section 366, 506, 376 of IPC and section 5A and read with section 6 of POCSO Act, my lordship.
Yes.
Victim girl was aged about 17 years on the date of incident, my lordship. That is on 3/3/2016.
Date of offense is 3/3/2016.
Date of incident is on 3/3/2016, my lordship.
3/3/2016.
As per the certificate issued by the school, date of birth is 19/7/1999, my lordship.
19/7/1999.
PW1, Ishwarama is the mother of the victim. She is the complainant.
Yes.
She supported the case, my lordship.
Yes.
PW2 is victim girl. Supported the case, my lordship. PW3 is Ravi Kumar, father of the victim. Supported the case, my lordship. PW4 is K. Shivakumar, manager of DK Deluxe Lodge at Madeshwara Betta, my lordship. He has he's been the witness for exhibit P5, 6 and 7. He has also supported the case, my lordship.
What are those cases?
Sorry, my lordship.
Exhibit P5 to 7 ಏನದು?
ಅದು lodge the
Receipts only.
receipt and ledger extract.
Lodge registers. Lodge manager ಅವರು?
Manager of DK Deluxe Lodge, Madeshwara Betta.
Yes. Support ಮಾಡಿದಾರಾ? Yes, supported.
Supported. PW5 is Amoga Katti. And he's a Mahajar witness to exhibit P3, my lordship. That is
ಏನ್ ಮಾಡ್ತಾರೆ?
where the girl was kidnapped.
From place where
Girl
from
was
where she
taken.
was.
Yes,
Seems it's a case of eloping, enticement.
it is as good as case of
As a kidnap.
It
He
is
was
kidnap,
returning
rape,
from
etc.
computer class.
Dinner ಅಂತಂದ್ರೆ ಇದು, but
ಹೌದು.
place of kidnap. Support ಮಾಡ್ತಾರ?
Support ಮಾಡ್ತಾರೆ Manosh. PW 6 is Dr. Malati, my lordship. She is a doctor who examined the victim girl, my lordship.
Yes.
Issued certificate as per exhibit P2.
P2.
P2 son.
Yes. PW7.
PW7 is
Seven.
in Rama.
Rama admission register extract ಕೊಡ್ತಾರೆ.
It is a headmaster.
Authority.
HM.
As per exhibit P8.
Admission register.
He has produced the admission extract as per exhibit P8.
Yes.
According to that, my lord, her date of birth is 19/7/1999.
PW8 is accused and examined ಮಾಡಿದವರ?
And he is a doctor who examined the victim, my lord.
Exhibit P9, my lordship.
Two persons have examined the.
No, no, no.
Accused.
P8 has examined the accused.
PW6 ಯಾರನ್ನ examine ಮಾಡಿದ್ದು?
Victim na, my lordship.
Victim. PW8 examines accused.
Accused, my lordship. As per exhibit P8.
PW9.
PW9
PC who arrested the accused, my lordship.
apprehended the accused. Arrest warrant.
PW10.
PW10 is a manager at Sharavati Guest House
In Dharmasthala.
in Dharmasthala, my lordship. He has been the witness for exhibit P11. PW11 is Renuka, my lordship, PSI, who received the complaint, my lordship, exhibit P1.
Registered the case,
Registered the case.
CC number.
FIR is exhibit.
Registered by PW11 only, my lordship.
P11. P11 is Panchanama. FIR is P15.
The 315
Please,
is affair.
Please, my lordship.
PW12 is IO, no?
PW12 is driver, my lordship. He has been a witness for exhibit P14, my lordship. Caesar Mahajan, witness.
Seizure of Tata S vehicle.
Yes.
They kidnap ಮಾಡಿದ vehicle.
Also,
Yes. PW13 is IO, my lordship, who submitted the charge sheet before the court.
conducted the investigation and filed charge sheet.
Yes. Yes.
Complaint over.
Yes.
May read with exhibit P1 complaint, my lordship. That is in page number 91 of the paper book.
Page number?
91, my lordship. ಈ ಮೂಲಕ ತಮ್ಮಲ್ಲಿ ಕೋರುವುದೇನೆಂದರೆ ನಾನು ಮೇಲೆ ತಿಳಿಸಿದ ವಿಳಾಸದಲ್ಲಿ ನನ್ನ ಗಂಡ ರವಿಕುಮಾರ್ ಹಾಗೂ ಮಕ್ಕಳಾದ ಕುಮಾರಿ ಗೌತಮಿ
ಅಲ್ಲ ಎಲ್ಲಾನು ಓದ್ತಾ ಹೋಗ್ಬೇಡಿ, ಮೆಟೀರಿಯಲ್ ರೆಲೆವೆಂಟ್ ಇರೋದು.
Substance ಅಷ್ಟೇ ಹೇಳ್ರಿ madam. Why are you reading?
in the mid of the second para, my lordship.
Minor ಇದೆಲ್ಲ.
They have all supported. On what ground the court has acquitted?
My lordship, in para number 34 of the judgment, my lordship,
ಅಷ್ಟು ಸುಮ್ಮನೆ ಜಡ್ಮೆಂಟ್ ಓದಿದೆ.
in page number 30 of paper book. Is observed that.
1 second.
After going through the 8th certificate exhibit,
ಒಂದ್ ನಿಮಿಷ. Page para 31.
Page 30,
page 30, para
para
34.
34.
ಏಜ್ ಪ್ರೂವ್ ಆಗಿಲ್ಲ ಅಂತ.
ಆಗಿದೆ, ಆಗಿದೆ.
ಎಸ್.
After going through the age certificate exhibit P8, it reveals that the victim is aged about more than 17 years and her.
ಪೇಪರ್ ಪೇಜ್ 30 ಓದ್ತಾ ಇದ್ದೀರಾ?
Please, my lordship.
ಜಜ್ಮೆಂಟ್ ಪೇಜ್
Judgment page number 23.
Internal page 23.
Internal page number 23.
ಎಸ್ ಎಸ್
Para number 34, my lordship.
Hmm.
After going through the age certificate exhibit P8, it reveals that the victim is aged about more than 17 years and her exact age is not proved before the court. Therefore, the evidence of victim, her mother and statements given to the police are perused. It is very clear that also presume the victim herself went with the accused voluntarily. Therefore, it can be said that she did not make any attempt to run away and accompanied him to different places. The circumstances elicited in the cross-examination of the victim establishes that though she had several opportunities to escape from the accused, she did not do so, and also not informed anybody either in the bus stand or in the railway station or in the different temples. Therefore, the evidence of victim when compared with her statement, certainly it gives scope for suspicion regarding the alleged kidnap and rape and aggravated penetrative sexual assault by the accused. However, another important aspect in medical report shows no injuries on the private part of the victim is the proof of kidnap and rape. The above discussed oral and documentary evidence of the prosecution, the important point made out in the victim, though aged about 17 years during her stay with accused in many places, never made any attempt to escape or to inform police or anybody. Therefore, taking into consideration of all the said aspects along with the observation made in the above rulings, I come to the conclusion that the prosecution has failed to prove that on 3/3/2016, the accused has kidnapped the minor and taken to Dharmasthala on 4/3/2016 and to Malai Mahadeshwara temple on 6/3/2016 and Tirupati forcibly committed rape and aggravated penetrative sexual assault by causing threat to her life. Hence, the answer point number 1 to 3 is the place.
They also, the trial court also says that she was aged 17. Age prove ಆಗಿಲ್ಲ ಅಂತ ಹೇಳೋದಿಲ್ಲ. Minority prove ಆಗಿಲ್ಲ ಅಂತ ಹೇಳೋದಿಲ್ಲ. If she is below 17, I mean 18, then even if she voluntarily goes, it amounts to kidnapping and sexual abuse only.
363
She is
clear up.
incapable of giving consent.
My lordship.
So this is the whole reasoning.
Yes, ma'am.
Yes, my lordship. My lordship, kindly see exhibit P2, my lordship, page number 95 of the paper book.
Page number 90. Ninety-three, no? Huh.
95 minutes.
One certificate. Examination report. Yes.
Opinion, my lordship. From physical and genital examination of Mrs. Ashwini, evidence of signs of recent.
Even assume to say, my lord.
Absent ಅಂತ ಕೊಟ್ಟಿದ್ದಾರೆ ಅವರು. ಅದನ್ನ highlight ಮಾಡಿದ್ರು absent ಅಂತ.
Even assume to say, my lord, kidnap is not true. Then also, as on the date on 4/3/2016 and 6/3/2016, she is a minor. There he committed a sexual intercourse. Then this POCSO will apply.
He is also driver.
Please, my lord. He is also.
Driver.
Driver.
Very. Yes. But in this case, at least he is 22. ಇನ್ನೊಂದು ಕೇಸಲ್ಲಿ ಮದುವೆ ಆಗಿ ಮಕ್ಕಳಿದ್ದಾರೆ. ಅದ್ರಲ್ಲಿ ಒಂದು 28. So what was his explanation in 313 statement?
ಮಾಮೂಲಿ ಸುಳ್ಳು.
ಅವರಲ್ಲಿ ಏನು ಡಾಕ್ಯುಮೆಂಟ್?
ಈಗ ನಿನ್ನ ತಂದೆ ತಾಯಿನ ಕೊಲೆ ಮಾಡ್ತೀನಿ ಅಂತ ಹೇಳಿ ಬೆದರಿಕೆ ಹಾಕಿ ಕರ್ಕೊಂಡು ಹೋಗ್ತಾರೆ.
ಅಲ್ಲ ಇದು 164. ಜನರಲ್ ಆರ್ಡರ್ಶಿಪ್ ಇಂದ ಇರ್ಬೇಕಲ್ಲ ಜಡ್ಜ್ಗಳು. ನಿಮ್ಮ ಹತ್ರ ಯಾರ ಹತ್ರ ಕಾಪಿ ಇಲ್ವಾ ಅದ್ರದ್ದು?
313 ಇದೆ.
ಇದೆಯಾ?
ಇದೆ.
ಏನ್ ಹೇಳಿದ್ದಾರೆ 313 ಅಲ್ಲಿ?
313 ಏನು ಹೇಳಿಲ್ಲ ಸುಮ್ಮನೆ ಎಲ್ಲ ಸುಳ್ಳು ಸುಳ್ಳು ನಿಮಿಷ ಹೇಳಿ ಕೊಡಿ.
ಆಯ್ತು. ವಾಟ್ ಈಸ್ ಯುವರ್ ಕೇಸ್ ಅಬೌಟ್ ಹರ್ ಏಜ್?
My, so far as age is concerned, please, my lord, sir. Age, as per this thing, school records, exhibit P8. It was indicated as 19/7/1999. 19 exhibit P8.
ಇದೆಲ್ಲ ಓಪನ್ ಆಗಿದೆ. Judgment 313 statement ಎಲ್ಲ ಇಲ್ಲ.
Full record. The basis for this entry is transfer certificate of 7th standard.
ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಡಿಸ್ಪ್ಯೂಟೆಡ್ ದ ಏಜ್ PW1 ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ
PW1 cross ಅಲ್ಲಿ ಏನು
ಡಿಸ್ಪ್ಯೂಟ್ ಮಾಡಿದೀರಾ ಏಜ್ ಅನ್ನ?
No, my lordship.
PW1 ಅವ್ರ
PW1
ಪೇರೆಂಟ್ಸ್
cross, PW1 is page 47.
PW ಎಲ್ಲದರಲ್ಲೂ ಸುಳ್ಳು ಸುಳ್ಳು ಅಂತ ಹೇಳಿದ್ರು.
District ಮಾಡಿದ್ರು.
ತರಗತಿಯಲ್ಲಿ ಆಕೆ ಮೈನರ್ ಇದ್ಲು ಅಂತ ಆಕೆ ತಾಯಿ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ಹೇಳಿಸಿದಾರ?
High evidence.
ಯಾಕೋ ಕಾಣ್ತಾ ಇಲ್ಲ. ಆಕೆ 10ನೇ ತರಗತಿ ಪಾಸ್ ಆಗಿದ್ಲು,
ತಾಯಿ evidence
ಫೇಲ್ ಆಗಿದ್ಲು, ಅದಕ್ಕೆ ಮನೇಲಿ ಇದ್ರು ಅಂತ.
ಹೌದು, ತಾಯಿ ಎವಿಡೆನ್ಸ್ PW1
ಅದೇ PW1
ಅಷ್ಟೇ ಏಜ್ ಬಗ್ಗೆ ಏನು ಹೇಳ್ಸಲ್ಲ.
ಏನು
ಫೇಲ್ ಆಗಿದ್ಲು, ಕಂಪ್ಯೂಟರ್ ಕ್ಲಾಸ್ ಹೋಗ್ತಾನೆ.
ಕರೆಕ್ಟ್. ಇವೆಲ್ಲ what is the basic for the POCSO cases? Date of birth ಹೇಳಿಸ್ಬೇಕಲ್ಲ. We see in many cases public prosecutors do not elicit nor the court, at least court ಆದ್ರೂ ಕೇಳ್ಬೇಕು ಅವಾಗ ಇದು most relevant factor ಅಂತ. She was examined on 10/4/2018 and as on that day she told her age as 19 years. ಆಕೆ ಎವಿಡೆನ್ಸ್ ಎಲ್ಲಾದ್ರೂ ಬಂದಿದೆಯಾ? ವಿಕ್ಟಿಮ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ 10ನೇ ತರಗತಿಯಲ್ಲಿ
ಆಕೆ
ಅನುತ್ತೀರ್ಣ
ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ ನನಗೆ 18 ವರ್ಷ ಆಗಿದೆ ಅಂತ ಹೇಳ್ತಾಳೆ.
ಇವಾಗ ಆಗಿದೆ.
ಅಲ್ಲ, ಚೀಫ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಹೇಳಿಸಿಲ್ಲ.
ನಮ್ಮ ಚೀಫ್ ಅಲ್ಲಿ ಇಲ್ಲ ಸರ್.
Equal 19 years ಅಂತ ಕೊಡ್ತಾರೆ.
ಅಲ್ಲ, ಅದು ಇದ್ರಲ್ಲಿ ಕೊಟ್ಟಿರೋದು ಪ್ರಾಸಿಕ್ಯೂಟರ್ಸ್ ಏನಾದ್ರು
ಎಕ್ಸಾಮಿನೇಷನ್
ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಆಸ್ ಇಟ್ ಈಸ್ ಏನು ಕಾಣ್ತಾ ಇಲ್ಲ.
ಅವಾಗ ವಯಸ್ಸು ಎಷ್ಟು ಅಂತ ಹೇಳ್ಸಿಲ್ಲ ಅವ್ರಿಗೆ.
ನನ್ನನ್ನು ಬಾಲಕಿಯ ಬಾಲ ಮಂದಿರಕ್ಕೆ ಕರೆದುಕೊಂಡು ಹೋದರು ಅಂತಷ್ಟೇ ಹೇಳ್ತಾರೆ. ಇವ್ರು ಹೇಳಿಸ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವರೇ ಕೇಳಕ್ ಹೋಗ್ತಾರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್. ವೈ ಡು ದೇ ಇನ್ವೈಟ್?
ಮೈನರ್ ಅಂತ ಹೇಳೇ ಇಲ್ಲ.
ಆಯ್ತು, ಫಾದರ್ ಎವಿಡೆನ್ಸ್ ಅಲ್ಲಿ
ಫಾದರ್ ಎವಿಡೆನ್ಸ್ ಹೇಳಿಲ್ಲ my lordship.
Page
ಎಲ್ಲರೂ
57.
10ನೇ ತರಗತಿ ಫೇಲ್ ಆಗಿದ್ಲು, ಮನೆಯಲ್ಲಿದ್ಲು ಅಂತ.
ಅಷ್ಟೇ.
Father 57 page.
ನೋಡ್ತಾ ಇದ್ದೀನಿ.
ಎಕ್ಸಾಮ್ ಕಟ್ಟಿದ್ದು ಬರೆಯಕ್ ಹೋಗ್ತಾರೆ.
ಬಾಲಕಿ ಅಂತ ಹೇಳ್ತಾರೆ ಅನ್ನೋದಕ್ಕಷ್ಟೇ. ತಿರುಪತಿಗೆ ಕರೆದುಕೊಂಡು ಹೋಗಿದ್ದಾನೆ ಎಕ್ಸೆಟ್ರಾ ಹೇಳ್ತಾರೆ. ಅವರು ಇಲ್ಲ. ಆಯ್ತು, ಈಗ ಡಾಕ್ಟರ್ ಇವ್ರು ಯಾರವರು? ಸ್ಕೂಲ್ಸ್ ಅಥಾರಿಟಿ PW.
Which one?
He is a Mahadev witness for exhibit P3 my lordship.
ಅಲ್ಲ, ಸ್ಕೂಲ್ ಅಥಾರಿಟಿ
School headmaster.
School headmaster is
PW7
PW7 my lordship.
ಅವ್ರ ಎವಿಡೆನ್ಸ್ ಏನ್ ಕೇಳಿದ್ದಾರೆ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ?
PW7 exhibit P8 page.
ಕರೆಕ್ಟ್. ಅವ್ರದ್ದು ಕ್ರಾಸ್
ಪೇಜ್ 70 ಸರ್. ಪೇಜ್ 70. ಅವ್ರದ್ದು ಏನು ಕ್ಲಾಸ್
9ನೇ
ಮಾಡಿದ್ರು.
ತರಗತಿಗಳನ್ನು ನಮ್ಮ ಶಾಲೆಯಲ್ಲಿ ಓದಿರುತ್ತಾಳೆ. ಶಾಲಾ ದಾಖಲೆಯಂತೆ ಆಕೆ ಜನ್ಮ ದಿನಾಂಕ 17/9/2000. ಈ ಬಗ್ಗೆ ನಾನು ನೀಡಿದ ಅಡ್ಮಿಷನ್ ರಿಜಿಸ್ಟರ್ ಎಕ್ಸ್ಟ್ರಾಕ್ಟ್ P8 P8 ಎಂದು ಗುರುತಿಸಲಾಯಿತು. ಕ್ಲಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್
ಕ್ಲಾಸಲ್ಲಿ ಏನು ಹೇಳ್ಸಲ್ಲ ಸರ್.
ಇಲ್ಲ ಬಂದಿತ್ತು.
ಬಾಲಕಿ 8ನೇ ತರಗತಿಗೆ ಸೇರುವಾಗ 7ನೇ ತರಗತಿ ವರ್ಗಾವಣೆ ಪತ್ರದಲ್ಲಿ ಇದ್ದಂತೆ ಜನ್ಮ ದಿನಾಂಕ
ತರಗತಿಗೆ ಸೇರುವ
ಅಷ್ಟೇ.
ಆಕೆಯ 7ನೇ ತರಗತಿಯ ವರ್ಗಾವಣೆ ಪತ್ರದಲ್ಲಿ ಇದ್ದಂತೆ ಜನ್ಮ ದಿನಾಂಕವನ್ನು ನಮ್ಮ ದಾಖಲೆಯಲ್ಲಿ ನಮೂದಿಸಿಕೊಂಡಿರುತ್ತೇವೆ. ಇದು ಸಾಕಾಗೋದಿಲ್ಲ ಅಂತ. ಯಾಕಂದ್ರೆ ಅದು
Two years.
ಜಡ್ಜ್ಮೆಂಟ್
Author of
Juvenile
has to be exam.
ಇತ್ತಲ್ಲ,
Adding of age.
No, there is a Supreme Court judgment that applies to the accused as well as victim ಅಂತ
Birth
ಹೇಳ್ತಾರೆ.
certificate,
ಒಂದು ಫಸ್ಟ್ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಡ್ಬೇಕು ಅಂತ ಅನ್ಸುತ್ತೆ.
This author has to be exempt.
ಹಾ ಆತರ ಒಂದು ಅಲ್ಲ ಯಾವ್ದು ಇನ್ ದ ಆಬ್ಸೆನ್ಸ್ ಆಫ್ ದಟ್ ದಿಸ್ ಡಾಕ್ಯುಮೆಂಟ್ ನೆಕ್ಸ್ಟ್ ಡಾಕ್ಯುಮೆಂಟ್ ಅಂತ ಹೇಳ್ತಾ ಹೋಗ್ತಾರೆ. ಐ ಥಿಂಕ್ ಒಂದು ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್
Certificate mandatory. ಅದಿಲ್ಲ ಅಂದ್ರೆ ಇದ್ದಾಗ
ಇಲ್ಲ ಅಂತಂದ್ರೆ
PC.
ಲಾಸ್ಟ್ ರಿಸಾರ್ಟ್ ಇದು ಟೆಸ್ಟ್
ಹೈಸ್ಕೂಲ್
Classification
ಸರ್ಟಿಫಿಕೇಟ್
test.
ಸ್ಕೂಲ್ ಸರ್ಟಿಫಿಕೇಟ್.
PC ಮಾರ್ಕ್ ಮಾಡಿ.
ಅಲ್ಲ ಅದು ಲೋಕಲ್ ಅಥಾರಿಟಿ ಕೊಟ್ಟಿದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ.
ಹೌದು.
ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಅಡ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಆಮೇಲೆ ಅದಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಐದರ್ ಆಫ್ ದಮ್ ಬಿಡಿ ಅದು ಇನ್ನೊಂದು
ಎರಡನ್ನು
ಅಥಾರಿಟಿ ಕೊಟ್ಟಿರೋದು ಇದು ಕೊಟ್ಟಿರ್ತಾರಲ್ಲ
ಹೈದರಾಬಾದ್.
ಇದೇನೋ statement. ಇದು ಅನ್ಸುತ್ತೆ. ಅಲ್ಲ ನಾವು ಒಂದು ಯಾವಾಗ್ಲೂ ರೆಫರ್ ಮಾಡ್ತಿದ್ವಲ್ಲ.
Section 12 of Juvenile,
ಹಾ ಮಹಾದೇವ್
Justice
ವರ್ಸಸ್
Act.
ಸ್ಟೇಟ್ ಕರೆಕ್ಟ್ ಇದೆ. ಮಹಾದೇವ್ ವರ್ಸಸ್ ಸ್ಟೇಟ್ ಆಫ್ ಮಹಾರಾಷ್ಟ್ರ.
ಅದೇ.
ಈ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಅವ್ರು ಹೇಳಿದ್ದಾರೆ
Opinion can be sought for based on the same certificate or the age of prosecutor below 18.
ಇಲ್ಲಿ ಅವರು ಸೆಕ್ಷನ್ 12 ರೆಫರ್ ಮಾಡಿ ಮೆಟ್ರಿಕ್ಯುಲೇಷನ್ ಸರ್ಟಿಫಿಕೇಟ್ ಕರೆಕ್ಟ್ ಮೆಟ್ರಿಕ್ಯುಲೇಷನ್ ಆರ್ ಇಕ್ವಲೆಂಟ್ ಸರ್ಟಿಫಿಕೇಟ್ ಇಫ್ ಅವೈಲೇಬಲ್ ಅದಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಡೇಟ್ ಆಫ್ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಫ್ರಮ್ ದ ಸ್ಕೂಲ್ ಅದರ್ ದನ್ ಎ ಪ್ಲೇ ಸ್ಕೂಲ್ ಫಸ್ಟ್ ಅಟೆಂಡೆಡ್ ಸ್ಕೂಲ್ ಅಂತ ಕೊಡ್ಬೇಕು ಅಂತ ಹೇಳಿ ಇನ್ ದ ಅಬ್ಸೆನ್ಸ್ ವೇರ್ ಆಫ್ ಬರ್ತ್ ಸರ್ಟಿಫಿಕೇಟ್ ಗಿವನ್ ಬೈ ದ ಕಾರ್ಪೊರೇಷನ್ ಇದು ಮೂರು ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮಾತ್ರ ಅಸಿಫಿಕೇಶನ್ ಟೆಸ್ಟ್ ಮಾಡಬೇಕು ಅಂತ ಹೇಳ್ತಾರೆ. ಈಗ ಫಸ್ಟ್ ಅಟೆಂಡೆಡ್ ಸ್ಕೂಲ್ ಇಂದ ನೀವು ಸರ್ಟಿಫಿಕೇಟ್ ತಗೊಂಡಿಲ್ಲ
ತಗೊಂಡಿದ್ದಾನೆ.
then ನಾವು ಏಜ್ ಪ್ರೂವ್ ಆಗೋದಿಲ್ಲಲ್ಲ ಮೈನಾರಿಟಿನೇ ಪ್ರೂವ್ ಆಗೋದಿಲ್ಲಲ್ಲ ಬಿಕಾಸ್ ಇನ್ ನನ್ ಆಫ್ ದ ವಿಟ್ನೆಸಸ್ PW 1 to 3 have elicited that she was minor ಅವಾಗಿದ್ರು ಅಂತ even this school authority whom you examine it was not the first school
First attended
attended by her. This was the high school.
Seventh TC
Standard ಗಳು.
ವಯಸ್ಸಿದ ಮೇಲೆ ನಾವ್ ಎಂಟ್ರಿ ಮಾಡಿದ್ವಿ ಅಂತ. Seventh TC ನು ಮಾರ್ಕ್ ಮಾಡಿ.
ಈ ಸುಪ್ರೀಂ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ಪ್ರಕಾರ ಅದನ್ನ ಕೊಡ್ಬೇಕು. ಈಗ ಕ್ರಾಸ್ ಎಕ್ಸಾಮಿನೇಷನ್ ಅಲ್ಲಿ ಹೋಸ್ಟೈಲ್ ಅದನ್ನ
ಇಲ್ಲಪ್ಪ.
ಇಲ್ಲ.
ಸವಾಲು ಇದೆ.
Cross examination not much elicited in that.
ಏನು ಇಲ್ಲ.
ಅಲ್ಲ
Page 71.
case
71 of the paper.
that girl's evidence
Girls evidence ಇದೆ.
PW 2 ಅಲ್ಲಿ
Page
51. Cross 59.
54. ದಯಾನಂದ
ಅದರಲ್ಲೂ ಎಲ್ಲೂ ಕೇಳಿಲ್ಲ ಸರ್.
ಇಲ್ಲಿ ಬೆಂಗಳೂರು
Case fully supported the case of prosecution.
ಅಲ್ಲಲ್ಲ ಮೈನಾರಿಟಿ ಬಗ್ಗೆ ಏನು ಅದ್ರಿಸ್ ಕರ್ಕೊಂಡೋದ್ರು ಅಂತ ಹೇಳಿದ್ರು ಶಿ ಸೇಸ್ ದೇ ವೆಂಟ್ ಟು ಮಲೆ ಮಹದೇಶ್ವರ ಧರ್ಮಸ್ಥಳ ತಿರುಪತಿ
ಫಸ್ಟ್ ಮಲೆಮಹದೇಶ್ವರನ್ ಬೆಟ್ಟ ಸ್ವಾಮಿ
10 days
ಇಲ್ಲಿಂದ
ಸುತ್ತಾಡಿದ್ದಾರೆ
ವಾಪಸ್ ಬೆಂಗಳೂರಿಗೆ ಬರ್ತಾರೆ.
finally.
ಆಮೇಲೆ ತಿರ್ಗಾ ಧರ್ಮಸ್ಥಳಕ್ಕೆ
ಮತ್ತೆ
ಹೋಗ್ತಾರೆ.
ಶಿ ಅಡ್ಮಿಟ್ಸ್ ರೈಲ್ವೆ ಸ್ಟೇಷನ್ ನಲ್ಲಿ
ಅಗೇನ್ ರೈಲು ಮುಖಾಂತರ
ಸಾಕಷ್ಟು
ತಿರುಪತಿ.
ಜನ ಇದ್ರು ಪೊಲೀಸರು ಇದ್ರು ಅಂದ್ರೆ ಸರಿ
ಅದ್ರಲ್ಲಿ ಕ್ಲಾರಿಫೈ ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಪೇಜ್ 55 ಅಲ್ಲಿ ಎರಡನೇ ಪಾರ ನೋಡಿ ಸ್ವಾಮಿ.
correct if she was minor if minority was proved then the accused was not having any case.
ಆ ಗ್ರೌಂಡ್ ಮೇಲೆ ಅಮಾಯಕ ಹೆಣ್ಮಗಳು ಸ್ವಾಮಿ ಅದಕ್ಕೋಸ್ಕರ
ಹಾ?
ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ ಆರೋಪಿ ನನ್ನ ಜೊತೆ ಇರುವಷ್ಟು ದಿವಸ ಚೆನ್ನಾಗಿ ನೋಡ್ಕೊಂಡು ಸರ್ ನಾನು ನನ್ನ ತಂದೆ ತಾಯಿಯವರ ಬಳಿ ಫೋನ್ ಇಲ್ಲದೆ ಇದ್ದಿದ್ರಿಂದ ನಾನು ಅವ್ರಿಗೆ ಯಾವುದೇ ವಿಷಯವನ್ನು ತಿಳಿಸಲಾಗಲಿಲ್ಲ. ನೀನೇನ ಮಾತಾಡ್ತಿದ್ರೆ ನಿನ್ನ ತಂದೆ ತಾಯಿ ಕೊಲೆ ಮಾಡ್ತೀನಿ ಅಂತ ಬೆದರಿಕೆ ಹಾಕಿ.
Two things one is it has to be proved that she was minor. Second thing it has to be proved that it was against her consent or I mean by force. ಈಗ ಕನ್ಸೆಂಟ್ ಇರ್ಲಿಲ್ಲ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾರೆ. ಕನ್ಸೆಂಟ್ ಇರ್ಲಿಲ್ಲ ಅಂದ್ರೆ then conduct of the parties have to be seen. They have moved together for 10 days. She has not tried to escape nor she has ಅದೇ ಹೇಳ್ತಾರೆ ಜನ ಇದ್ರು ಪಕ್ಕದಲ್ಲಿ ಇವರಿದ್ರು ಅಂತ ಹೇಳಿ. But how that has to be probability ಎರಡು accused in case of accused preponderant I mean he is entitled to more benefit.
PW 4.
ಈಗ ಮೈನಾರಿಟಿ ಪ್ರೂವ್ ಆಗಿದ್ರೆ 29-30 ಪ್ರಿಸಂಪ್ಷನ್ ಬರ್ತಿತ್ತು then burden was yes PW
4 page 63 cross examination is the manager of
ಎರಡು ಲಾಜ್ನವ್ರನ್ನೇ
ಕ್ಲಾಸ್ ಅಲ್ಲಿ ಹೇಳ್ತಾರೆ
63
ಕ್ರಾಸ್. ದಿನ ರೂಮ್ ನಂಬರ್ 16ರಲ್ಲಿ ಪೊಲೀಸರು ಮಾದರ್ ಮಾಡಲು ಬಂದಾಗ ರೂಮ್ ನಲ್ಲಿ ಆರೋಪಿ ನೊಂದ ಬಾಲಕಿ ಆಗಲೇ ಮದುವೆಯಾದ ದಂಪತಿಗಳ ರೀತಿಯಲ್ಲಿ ನೊಂದ ಬಾಲಕಿಯನ್ನು ಆರೋಪಿ ಬಲವಂತದಿಂದ ಅಪಹರಿಸಿಕೊಂಡು ಆಕೆಯ ಮುಖದಲ್ಲಿ ಕಂಡು ಬಂದಿದೆ. ನೊಂದ ಬಾಲಕಿ ಕತ್ತಿನಲ್ಲಿ ತಾಳಿಯನ್ನು ಹಾಕಿಕೊಂಡಿದ್ದಳು ಮತ್ತು ಅವರಿಬ್ಬರು ಆಗ ತಾನೇ ಮದುವೆಯಾಗಿರುವುದಾಗಿ ಹೇಳಿದ್ದಾರೆ. ಅವರಿಗೆ ಲಾಟದಲ್ಲಿ ರೂಮ್ ಕೊಡಲಾಗಿದೆ. ಆಕೆಯ ಮುಖದಲ್ಲಿ ಗಾಬರಿ ಇಲ್ಲದ ಅಸಹಾಯಕತೆ ಕಂಡು ಬಂತು.
ಇಬ್ಬರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಇನ್ನೊಬ್ಬರು ಧರ್ಮಸ್ಥಳದವ್ರನ್ನೊಬ್ಬರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿದ್ದಾರೆ ಅಂತ ಹೇಳಿದ್ರು. PW10 ಮ್ಯಾನೇಜರ್ ಆಫ್ ಶರಾವತಿ ಲಾಸ್ಟ್, PW10.
PW10 Sharavati, page 77. Fifth line chief clerk. ಸದರಿ ಕೃಷ್ಣ ಹಾಗೂ ಮತ್ತೊಂದು ಹುಡುಗಿ ತಾವು ಗಂಡ ಹೆಂಡತಿ ಎಂದು ರೂಮ್ ಪಡೆದುಕೊಂಡಿದ್ದಾರೆ ಎಂದು ನಂಬ ಮಾಹಿತಿ ನೀಡಿ ನನ್ನ ಸಹಿ ಮಾಡಿದ್ದೇನೆ.
How many days they stayed here and in the other place?
ಎಲ್ಲ ಕಡೆ ಒಂದೊಂದು ದಿವಸ ಸ್ವಾಮಿ.
18/3 ಮಾಡಿದ್ದೇನೆ, 4/3/2016 ಅಲ್ಲಿದ್ರು ಅಂತ. ಇನ್ನೊಬ್ರು ಹೇಳಿದ್ರಲ್ಲ, ಅವ್ರು ಎಲ್ಲಿಯವರು ತಿರುಪತಿನ ಮಲೆಮಹದೇಶ್ವರ.
ಫಸ್ಟ್ ಮಲೆಮಹದೇಶ್ವರನ ಬೆಟ್ಟ,
ಹ್ಮ್.
ಆಮೇಲಿಂದ ಧರ್ಮಸ್ಥಳ, ಆಮೇಲಿಂದ ತಿರುಪತಿ.
PW4 ಮ್ಯಾನೇಜರ್ ಅಟ್ ಮಲೆಮಹದೇಶ್ವರ ಬೆಟ್ಟ.
ಅವ್ರು ಎಷ್ಟು ದಿವಸ ಇದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ? ಒಂದೇ ದಿವಸನ?
ಒಂದೇ ದಿವಸ.
ತಿರುಪತಿಯವ್ರನ್ನ ಎಕ್ಸಾಮಿನ್ ಮಾಡಿಲ್ಲ.
ಇಲ್ಲ, ತಿರುಪತಿನ ಹೋಗ್ತಾರೆ,
ಪ್ಲೇಸ್ ಆಫ್ ಸ್ಟೇ
ಎಕ್ಸಾಮಿನ್ ಮಾಡಿ
ಫೋನ್ ಮಾಡಿ ಹೇಳ್ತಾರೆ ಇವ್ರ ಮನೆಯವರು, ಈ ತರ ನಿನ್ ಮೇಲೆ ಕಂಪ್ಲೇಂಟ್ ಕೊಟ್ಟಿದ್ದಾರೆ ಅಂತ. ಆಗ ಅಲ್ಲಿಂದ ಕರ್ಕೊಂಡು ಬಂದು ಮುಳುಬಾಗಿಲು
2 ದಿವಸ ಬಿಟ್ರೆ ಇನ್ನು ಉಳಿದ ದಿವಸದಲ್ಲಿ ಏನು ರೆಲೋಟ್ ಪ್ಲಾಟ್ಫಾರ್ಮ್. When she was traced,
11th please. 11th.
3.
Yes please.
2011 traced.
On the same day she was examined.
So ಅಂದ್ರೆ 8 ದಿವಸ ಇರ್ಲಿಲ್ಲ. 3rd to 11th 2 ದಿವಸದ ಮಾತ್ರ ರೆಕಾರ್ಡ್ ಇದೆ.
ಕೇಸ್ ಆಗಿತ್ತು PW 11 ಹೇಳ್ತಾರೆ.
ಅದನ್ನ ಡಿನೈ ಮಾಡಿದ್ರು.
11th
ಕರ್ಕೊಂಡು ಬರ್ತೀವಿ.
11/3.
3/3 to 11/3.
ಥರ್ಡ್ ಬಾಕ್ಸ್ ಸೈಡ್. ಆಮೇಲೆ ಈ ಕೇಸಲ್ಲಿ ಟೀನೇಜ್ ಅಡೋಲ್ಸೆಂಟ್. Now what is the present position of the victim?
ಮಗು ಇದೆ.
With this person only?
No, with some other. ಹುಡುಗ ಅಂತ.
ಇದನ್ನೊಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಇದೆ, ಜಡ್ಜ್ಮೆಂಟ್ juvenile justice that applies to the accused and victim both ಅಂತ ಬರ್ತಿದ್ದಾರೆ. Reasons to follow ಅಂತ ಮಾಡೋದು ಹೇಳ್ತೀವಿ. ಈಗ ನಾವು ಆರ್ಡರ್ ಮಾಡಿದ್ವಿ, ಪ್ರೀವಿಯಸ್ ಏನೇನಿದೆ ಎಲ್ಲಾನು ಕೊಡ್ಬೇಕಂತಂದ್ರೆ ಮಾಡಿದ್ರ? ಒಂದು ಆರ್ಡರ್ ಮಾಡಿದಾಗ ಹಿಂದೆ ಕೊಡ್ಬೇಕು ಅಂತ ಅಲ್ಲ, ಬೇರೆ ಕೇಸ್ಗಳಲ್ಲಿ wherever it is pending it should be done ಅಂತ ಹೇಳಿ
ಯಾವುದು ಬಂದಿಲ್ಲ.
we have passed that order
ಮಾಡಿದಿರಿ, ಬಟ್ ಇದ್ರಲ್ಲಿ ಲಾಸ್ಟ್ ಅಲ್ಲಿ ಮಾಡ್ಬಿಟ್ರೆ ದಟ್ ಈಸ್ ಈಸಿ.
ಮಾಡ್ತೀವಿ.
ಲಾಸ್ಟ್ ಟೈಮ್ ಮಾಡಿದಿರಿ ತಾವು?
ಇಲ್ಲ, ನಾವೇನೋ ನೋಟ್ ಕಳ್ಸಿದ್ವಾ, ಏನೋ ಮಾಡಿದ್ವಿ.
ನೋಟ್ ಕಳ್ಸಿದಿರಿ?
ನೋಟ್ ಕಳ್ಸಿದ್, ಬಟ್ ಪೆಂಡಿಂಗ್ ಕೇಸಸ್ ಕೊಟ್ಟಿಲ್ಲ ಅಂತ ಹೇಳ್ತಾ ಇದಾರೆ ಅಂತದಿದ್ರೆ ಅದನ್ನ ಯಾವ ಜಡ್ಜ್ಮೆಂಟ್ ನೋಡಿದೆ? ಯಾವ್ದೋ ಒಂದು ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಬರ್ದಿದೀವಿ ಅದನ್ನ. ಅಮಿಕಸ್ ಕ್ಯೂರಿಗೆ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ
ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ನಂಬರ್ 1700 ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ನಂಬರ್. ಅದ್ರಲ್ಲಿ ತಾವು ಆರ್ಡರ್ ಮಾಡಿ 15,000 in each cases ಅಂತ ಹೇಳ್ಬಿಟ್ಟು ಮಾಡಿದಿರಿ, ಬಟ್ ಇನ್ನು ಅದು ಬಂತು.
Appeal dismissed. Reasons to follow. Court places on record the valuable services rendered by she or his residence or Lord of the Skill. Registry shall release him. Registry shall release his remuneration of this 15,000. 15,000.
Much obliged.
ಸುಮ್ನೆ ಎಲ್ಲಾನು ಓದ್ತಾ ಹೋಗ್ಬಾರ್ದು, ಪಾಯಿಂಟ್ ಏನಿದೆ ಅದನ್ನ ಹುಡುಕೊಂಡು ಮತ್ತೆ ಯಾರಿಲ್ಲ? List number 2 ನಲ್ಲಿ ಯಾರು ಇದ್ದಂಗೆ ಕಾಣ್ತಿಲ್ಲ. Any others are ready? ಯಾರು ಇಲ್ಲ. ಅವ್ನು ರಿಪೀಟ್ ಮಾಡಿಬಿಡಿ ಉಳಿದಕ್ಕೆ ರಿಪೀಟ್ ಮಾಡ್ತೀನಿ. ಇದ್ರಾಗ ಒಂದು ಯಾವುದೋ ಇದೆ ಅಲ್ಲ ಇನ್ನೊಂದು ಚಂದ್ರಶೇಖರ್ ಮುಗಿತಲ್ಲ ದೇವ ಚಂದ್ರಶೇಖರ್ ಅದನ್ನ ತಕ್ಕೊಂಡು ನೋಡಿ ನಾವು ಏನಾದ್ರು ಮಾಡ್ಬೇಕಂತ ಮಾಡಿದೀವಿ ಅವ್ನು ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಒಂದ್ಸರಿ ಕೇಳೋಣ. ಅದು ಒಂದು ನೋಟಿಫಿಕೇಶನ್ ಇದೆ ನಿರ್ದೇಶನ ಒಂದು ಕೊಟ್ಟಿಲ್ವಂತೆ
ಇವರಿಗೆ ಅಂದ್ರೆ
ಒಂದು ಕೊಟ್ಟಿಲ್ವಂತೆ.
order ಇಲ್ಲ ಆದ್ರೆ
ಅಲ್ಲ ಕೋರ್ಟ್ ಆರ್ಡರ್ ನಾವೇನ್ ಮಾಡಿದ್ವಿ ಅಡ್ಮಿಸಿಬಲ್ ಅಂತ ಮಾಡಿದ್ವಿ. ಅಡ್ಮಿಸಿಬಲ್ ಅಂದ್ರೆ ಅವ್ರು ಹುಡುಕ್ಬೇಕು ಕೊಟ್ಟೇ ಇಲ್ಲ ಬಂತೆ. ಇವ್ರು ಹೇಳಿದ್ರು ಇವ್ರು ಹೇಳಿದ್ಮೇಲೆ ಗೊತ್ತಾಗೋದು. ಅಲ್ಲಿವರೆಗೂ ನಮ್ಗೆ ಗೊತ್ತಾಗಿರ್ಲಿಲ್ಲ. ಅಂಡ್ ವಿ ಪಾಸ್ಟ್ ಆರ್ಡರ್ ಇಲ್ಲಿವರೆಗೂ ಯಾವ್ದು ಪೆಂಡಿಂಗ್ ಇದೆ ಅದನ್ನು ಕೊಡ್ಬೇಕು ಅಂತ ಅದನ್ನ ಏನ್ ಮಾಡಿದ್ರು. ಅವ್ರಿಗೂ ಕೂಡ ಬುದಿಲ್ಲ ಇರ್ಲಿ ನಾವು ಬರ್ರಿ.
ಅವ್ರ ಚೇಂಬರ್ ಇಂದನೇ ಅಂತ ಬರೋದು. $230 list for pronouncement of judgment, seal number 1, S. Srishaila Murthy DL.
The tribunal has already awarded a compensation of 11,05,000 with interest at the rate of 6% per annum. The claimant is entitled for 15,89,522 as against 11,05,000. The enhanced compensation that the claimant is entitled to is 4,84,522. And the points framed for consideration are answered accordingly. Hence the following order. MFA 11,281 of 2012 filed by the insurance company is hereby dismissed. MFA 8,001 of 2014 filed by the claimant is hereby allowed in part. The claimant is entitled for compensation of 15,89,522 as against 11,05,000. The claimant is entitled for enhanced compensation of rupees 4,84,522 with interest at the rate of 6% per annum from the date of petition till the date of realization. The amount in deposit to be transmitted to the tribunal forthwith. The insurance company shall deposit the enhanced compensation amount before the tribunal within a period of 4 weeks from the date of release of this order. In light of the disposal of the appeals, pending IAs, if any would not survive for consideration.
The number 2, Vinay Kumar GS.
The point raised for consideration is answered accordingly against the corporation. Hence the following order. Appeal is hereby dismissed. The impugned order passed by the district judge stands confirmed.
For being spoken to, seal number 3, Ismail Muni Musba, SV Hegde Mulkun.
For the appellant.
Yes, Mr. Counsel.
For the penny for the appellant in this matter. This is on 27th, this leads to order. Subsequently, on contacting the appellant, he undergone further surgery due to medical expenses. And can we just pass on whether the details are.
You have given something here, you know, put it along. Memo
certificate and only one disability certificate, disability ID.
ನಾನು being spoken to memo ಕೊಟ್ಟಿದ್ರಲ್ಲ ಅದೇನಿಲ್ಲ ಅದ್ರ ಜೊತೆ ಕೊಟ್ಟಿದ್ರಲ್ಲ
Using his hospital bills, my lord, which is
correct, Mr. Counsel, ಇಲ್ಲಿ this accident was of the year 2006 and MEC is filed in 2017.
15.
Your own doctor before the tribunal deposed that it was 15%. That was your own evidence. And after 2006 to 2019, how many years? Well, how do we say that this disability, if any, was relatable to that 2005 accident, 2006 accident?
Right. Related to the ankle itself, I've also produced the hospital record.
You should produce it order 41 rule 27. You could have produced it. Now the flight has taken off. Yes, Mr. ಇವ್ರು ಏನ್ ಹೇಳ್ತೀರಾ? ಎರಡು disability certificate. No, judgment is, and this is also of the year 2019. Appeal was pending since 2015.
So far, he had not produced any document. No, he is after the judgment.
ಅದು 2019 ನಲ್ಲಿ ಕೊಟ್ಟದ್ದು ಅಂತ ಹೇಳ್ತಾರೆ. We disposed it off on
February 24.
February. ಅಲ್ಲಿವರೆಗೂ ಆ ಸರ್ಟಿಫಿಕೇಟ್ 19 to 24 ಪ್ರೊಡ್ಯೂಸ್ ಮಾಡೋದಿಲ್ಲ. How can we reopen the case like this?
That is the
The
medical bill.
inpatient detailed medical bills.
I've produced it in the.
What is there to show that this was relatable to that earlier accident, even in this medical bill?
Related to the
These are all of the year 2019 only.
accident.
Then what prevented you from?
All related to the ankle.
Yes, ಏನ್ ಹೇಳ್ತೀರಿ?
Submission in another.
ಮೋಟರ್ ಆಕ್ಸಿಡೆಂಟ್ ಕೇಸಿಗೆ ಏನು ಟ್ರಾಫಿಕ್ ರೂಲ್ಸೇ ಇಲ್ಲ. Yes. Yes.
The party
But
was,
earlier the issue was there.
injuries were there, my lord, subsequent.
In an earlier accident, if I'm right.
Earlier, subsequent.
Yeah, this was the second accident for him.
10-year-old boy, when this accident occurred, his ankle got injured, that malleolus, where you said the ankle bone. His movement was, at that point of time, he said 15% disability. The appeal was filed in 2015. When we got in touch with the appellant, so subsequently, in furtherance of this, he has undergone this operation. He is yet to undergo further operations in future. At least so far as this operation, what he has undergone in 2013, that may be considered.
This matter was disposed of on 27/2024 on hearing both sides. Appellant's counsel has moved this matter.
What is it?
One for-
Was not filed. Any of this.
Now they are fighting.
1/4/2013, saying that here is the date 2023. ಅಲ್ಲ issue ಮಾಡಿದ್ದು 2000. ಯಾವಾಗ 2019
So we moved it, Manoj, so we permitted to file the application.
The-
That should have been done at the time of filing of the appeal, not during the pendency.
The appellant has suffered ಎಷ್ಟು 75%, ಎಷ್ಟು 60%.
60%.
Subsequent to the disposal of this matter on 27/10/2023, the Department of Empowerment of Persons with Disabilities has issued disability certificate to the effect that he has 60% permanent physical disability. So it is further contended that for the accidental injuries, the appellant had to undergo further treatment between 13/6, ಎಲ್ಲ 13/6/2019 ಒಂದೇ ದಿವಸದ
9/6 to 13/6. Page third is, page 3 is seen. Admitted on 9/6.
further treatment in ಯಾವ ಹಾಸ್ಪಿಟಲ್ ಇದು? ಮಣಿಪಾಲ್ ಹಾಸ್ಪಿಟಲ್. ಯಾವ ಹಾಸ್ಪಿಟಲ್ ಇದು?
Manipal Hospital, Bangalore.
Manipal Hospital, Bangalore, between 9/6/2019 and 13/6/2019. And therefore, it is submitted that considering the same, the compensation awarded be enhanced. Since the matter is already disposed, there is no scope for consideration of these matters, these documents. Further, the accident occurred in the year 2006. MFA, claim petition was filed before the tribunal in the year 2007. The claimant's own witness, doctor ಯಾರೋ ಹೇಳಿದ್ರಲ್ಲ, PW ಎಷ್ಟು ಅವರು?
PW2, man.
PW2, ನಮ್ಮ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಇದೆ ಎಷ್ಟು? 15%. Because that the claimant had suffered 15% disability to his lower limb. ಏನೋ ಒಂದು ಹೇಳಿದ್ದಾರೆ, permanent to his left lower limb. He had not even spoken about the permanent disability to the whole body. Appeal was filed in the year 2015. No efforts, nothing was whispered till the disposal of the appeal about the further treatment or higher disability. There is nothing to show that the alleged disability certificate, the alleged disability spoken in the said certificate is relatable to the accident which took place in the year 2006. There is nothing for reconsideration and the memo disposed of accordingly. We should not say about disability certificate, government or
So that
Provide the-
includes your medical expenses, Manoj, for that.
now for everything, because these people are giving allowance on the employment. ಅದಕ್ಕೆ ನಾವೇ ನೋಡ್ತೀವಿ ಬರೋ ಎಂಪ್ಲಾಯರ್ಸ್ ಎಂಪ್ಲಾಯೀಸ್ ಹಿಡ್ಕೊಂಡು ಬರೋದನ್ನ. We have all sympathies for the people who suffer, but sometimes these things are excused.
Still number
You could have done it earlier.
Huh?
You could have done it earlier.
ಅದು ಆಯ್ತು, ಗೊತ್ತಿಲ್ಲ ನಮ್ಗೆ ಇಷ್ಟು ವರ್ಷದ ಮೇಲೆ 23 ಕೊಡ್ತಾರೆ ಆ ಸರ್ಟಿಫಿಕೇಟ್.
The party was not in touch, but then we got to know. at least the-
Sorry, we disposed.
I understood.
Still number 4, SV Hegde Mulkan, HB Rudresh.
But I was filed by him. A related of the amount and some modification.
And it's already paid ಅಂತ ಹೇಳ್ತಾ ಇದ್ರಲ್ಲ ಇವತ್ತು.
He is ಮಾಡಿದ್ದಾರೆ.
ಅದು ನಾವು ಸಬ್ಜೆಕ್ಟ್ ರಿಸಲ್ಟ್ ಆಫ್ ದ ಅಪೀಲ್ ಅಂತ ಹೇಳಿದ್ರೆ ಟ್ರಿಬ್ಯುನಲ್ ನಲ್ಲಿ ಅಮೌಂಟ್ ರಿಲೀಸ್ ಮಾಡ್ತಾ ಇರ್ಲಿಲ್ವಂತೆ ಸಬ್ಜೆಕ್ಟ್ ರಿಸಲ್ಟ್. ಸೊ ಆರ್ ನಾಟ್ ಪ್ರೆಸಿಂಗ್ ಇಟ್ ಏನು? ಮಾಡಿಫಿಕೇಶನ್ ಅಷ್ಟೇ, ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಅಂತ ಮುಗಿಸ್ತೀವಿ ಅಷ್ಟೇ. ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ಅಪೆಲೆಂಟ್ ಅಲ್ಲ ನೀವು? ಒಂದ್ರಲ್ಲಿ ಅವ್ರ ಅಪೆಲೆಂಟ್ ನಂಬರ್ 31. ಇದ್ರಲ್ಲಿ ರೆಸ್ಪಾಂಡ್, ನಾನು ಕೌನ್ಸಿಲ್ ಫಾರ್ ದ ರೆಸ್ಪಾಂಡೆಂಟ್ ಕ್ಲೇಮೆಂಟ್ ಏನು ನಾಟ್ ಪ್ರೆಸ್ಡ್ ಒಂದ್ ಸೆಟ್ ತಗೊಳ್ರಿ, ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಕೊತೀವಿ. Submits that I had filed IA 1/2024 since the tribunal was not releasing the amount in deposit, misinterpreting the order for release. He further submits that now the tribunal has released the amount, therefore he does not press IA 1/2024. IA 1/2024 is disposed of accordingly. Then roster bench ಮುಂದೆ ಹೋಗ್ಬೇಕಾ? List with the roster bench. Yes. List with
Matter may be posted after petitions.
ನಾಳೆ ಡೇಟ್ ನಮ್ಮ ಮುಂದಲ್ಲ ಹೋಗುತ್ತೆ. ಲಿಸ್ಟ್ ಬಿಫೋರ್ roster ಅವ್ರು ಡೇಟ್ ಕೊಟ್ಟಿದ್ರಂತ.
ಹೌದು.
Hearing on IS, still number 5, SG Rajendra Reddy. SVP.
Yeah, who is for the other side? State.
SVP.
ಆಫೀಸರ್ ಮಾಡಿದೀರಾ? ಅದೇನು ಕ್ರಿಮಿನಲ್ ಅಪೀಲ್ ಅಲ್ಲ ಅಂತ ಹೊರಟೋಗ್ಬಿಟ್ರೆ ಹೇಗೆ? ನಮ್ಮ ಮುಂದೆನೆ ಬರ್ಬೇಕು, ಗೊತ್ತಿಲ್ಲ. ಏನ್ ಪಾಸ್ ಓವರ್ ಮಾಡೋಣ ಹೇಗೆ? ಮತ್ತೆ ಇಲ್ಲಾಂದ್ರೆ ಅದಕ್ಕೆ ಮಾಡಿದ್ರ ಪಾಸ್ ಓವರ್ ಮಾಡಿರ್ತೀವಿ, ನೋಡೋಣ ಬರ್ತಾರೆ ಹೇಳ್ತಾರೆ ಅಂತ ಸೇಫಿಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿ.
For further hearing, still number 6. Yes, Kalyan Basuraj.
My lord has heard this matter
Both
at length.
both had completed.
We have already completed. I have also replied to the arguments of the learned counsel for the appellants.
Last time also we expressed that basic principles, you have given so many judgments. Basic principle under the Hindu law is that the eldest member is the manager of the family. Father was alive, plaintiff was the next elder member. So they had to prove, trial court has said they had to prove that he was the manager of the family.
Apart from proving the manager of the family,
Then next will come to. Otherwise, if you say that this property was a joint family property, these properties, they were acquired for the family benefit, then burden was again on you because junior member, acquisition by junior member, there is no presumption,
this is
right? There was some evidence to show that he was doing some other business. But you try to say that on exhibit P20, there is a mention that father had given check for just to the
2 lakh rupees.
2 lakhs, 5,000.
the learned judge also
Yeah.
accepts.
Correct, 1 second. They denied that, they refer to some other document, no?
Sale deed,
But trial court has accepted that there was a mention to that.
some amount.
But even to accept, even if father pays, trial court, correct, trial court, he may recover it, etc. There should be some evidence to show that the father had an animus, that this is being acquired for the joint family. This was for the purpose of enjoying it as a joint family property.
That was pleaded and proved.
Proved in proof ಏನಿದೆ?
Let it show in the.
Because properties were standing in the name of him
But
all
his
along.
father, in his examination sheet, who also in the.
ಆಮೇಲೆ ಅದ್ಯಾವ್ದೋ ಒಂದು ಅಪ್ಲಿಕೇಶನ್ ಹಾಕಿದ
IA number 9.
ಅಲ್ಲ ಇಲ್ಲಿ ಹಾಕಿರೋದಲ್ಲ
Alli. Trial court father himself files and contends that he is the manager and he is
ಟ್ರಯಲ್ ಕೋರ್ಟ್
Affidavit.
ಅಲ್ಲಿ ಇಲ್ಲ ಅದು.
trial court ಅಲ್ಲಿ.
Affidavit.
ನೀವು ಹೇಳಿದ್ರಿ ಮುಂದೆ ಹೇಳ್ತೀವಿ 145 the question of invoking 145 arises only if it deposes contrary to that. Only if he denies the filing of the application. ಎಷ್ಟದೆ
IA number 9.
D20, P20.
And that affidavit is filed subsequent to.
P20 ಎಲ್ಲಿದೆ? P20 ಅಲ್ಲಿ ಒಂದು ರೆಫರೆನ್ಸ್ ಇದೆ ಅಂತ ಹೇಳಿ. ಅಲ್ಲ ಕರೆಕ್ಟ್
That is IA number.
ಅಲ್ಲಿ P20 ಅಂತ ರೆಫರ್ ಮಾಡ್ತಾರೆ. P20 ನ P8 ಅದು.
IA number. IA number.
ಮಾರ್ಕ್ ಆಗಿಲ್ಲ ಅಲ್ಲ ಅಫಿಡವಿಟ್ ಅಲ್ಲ.
IA number 9. It is.
IA number 9. ಒಂದು ಯಾವ್ದೋ ಡಾಕ್ಯುಮೆಂಟ್ ಅಲ್ಲಿ P8 ಅದ್ರಲ್ಲಿ there is a reference to payment of rupees 2,05,000.
Exhibit P8.
P8.
Agreement of sale.
Agreement of sale.
One minute.
Father makes the payment.
P8 is not agreement of sale. ಅದು ನಮ್ಗೂ ಇದನ್ನ ನೋಡುವಾಗ ಅದಕ್ಕದಕ್ಕೂ ಟ್ಯಾಲಿ ಆಗ್ಲಿಲ್ಲ. ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ
I'll
P20 is the agreement.
P20.
P20 ಅಂತ ಡಾಕ್ಯುಮೆಂಟ್ಸ್ ಇಲ್ಲ. P1 to P13 ಅಷ್ಟೇ ಮಾರ್ಕ್ ಆಗಿರೋದು.
D20. D20. Exhibit D20.
P20 ಅಲ್ಲಿ
19 and 20 agreements.
Exhibit D20.
D19 and 20 ಅಂತ ಮಾಡಿ.
ಅದ್ರಲ್ಲಿ
Is the agreement.
ಇಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಜಡ್ಜ್ಮೆಂಟ್ ನಲ್ಲಿ P ಅಂತ
P
ಆಗಿದೆ.
ಅಂತ. Maybe a typographical error.
20 is the receipt for having.
ಕರೆಕ್ಟ್. ಈಗ ಇನ್ನೊಂದು IA ಇತ್ತಲ್ಲ
IA number 9. IA number 9.
ಇದು IA 15.
Dated 10/1/2007.
ಅದೇನು ಇದು ಸ್ಲಿಪ್ ಹಾಕ್ತೇನೆ. ಇದು ಇಂಜಂಕ್ಷನ್ ಕೇಳಿದ್ರು
Okay.
ಡಿಸ್ಟರ್ಬ್ ಅಪ್ಲಿಕಂಟ್ ಹಿರೇಗೌಡ.
This is the date on which he has sworn to that affidavit. After he leaves the,
10/1/2007.
by then he left the joint family.
ಹಿರೇಗೌಡ himself.
affidavit.
Father ಹಾಕಿರೋದು ಸ್ವಾಮಿ.
By then the son who claims to be the member of the joint family, he,
ಇಲ್ಲ.
by then he had left the
What
home.
is that he had pointed out here?
I have pointed out the case of the plaintiffs before the trial court was, I was managing the joint family properties, even though I am the youngest member of the family. I was looking after the joint family, even though my father was alive. Whereas during the course of the trial itself, my father has filed this application contending that he is the manager and he is looking after the family properties. Therefore, the case set up by the plaintiff has
I
been.
got the right of management. So far I am doing the managerial. So far.
He himself admits, my father himself admits that he is
Manager
managing the
of
properties.
myself, plaintiff and defendant number 2 to 4.
So
And
therefore,
he has sought injunction against plaintiff.
plaintiff one. So therefore, the case set up by the plaintiff that I was managing the joint family properties stands disproved by this document
The
itself.
opponent here, opponent is HS Gopala.
HS
He was
Gopal.
the plaintiff. And father says his affidavit, ನನ್ ಮಕ್ಕಳು ಬಾಡಿಸ್ಕೊ ಬಂದಿದ್ದಾರೆ ಅದನ್ನ affidavit.
ಅಂತ ಅದು ಬೇರೆ ಹೇಳ್ತಾರೆ. So therefore, all these contradictions leads to one and the only conclusion that the plaintiff has not.
Fact that whether he was managing and the son was
Okay.
managing. The fact remains that there was a contribution from the joint family.
The initial presumption has not been proved by the plaintiff.
Because payment was made by the father, if unless there is some animus that it is being acquired for the joint family or it was being enjoyed as a joint family property and the.
ಅದೆಲ್ಲ ಏನಿಲ್ಲ.
This is one thing.
My lord, in exhibit D1,
We have to-
there is a specific
What
mention.
is,
In exhibit D1,
Whom
there
do
is
you
a
represent?
specific mention with regards to the payment of money
Hmm.
to buy the property. First page of the exhibit D1.
your father only gave an affidavit before the trial court
My lord,
saying that.
management is different. Have signed on this
ಇದು
document.
ಇನ್ನೊಂದು ಏನು?
Chaudeshwari Temple,
ಈ ಕೋರ್ಟ್ ಅಲ್ಲಿ ಅಪ್ಲಿಕೇಶನ್ಸ್ ಹಾಕೊಂಡಿದ್ದೀರಲ್ಲ.
41, order 41, rule 27.
Filed
I
application.
have not filed.
I have filed, I have filed,
ಯಾರೋ
I have filed.
That is, ಅವೇನು they are not required for the purpose of.
I have
business.
produced those who had sold it.
ಇಲ್ಲ, ಎಲ್ಲಿ exhibit application. ಇದು ನೀವು ಪೇಪರ್ ಬುಕ್ ಕೊಡ್ತಾ ಇದ್ದೀರಾ ಅಲ್ಲ IAS.
41, I have filed. Okay.
ಹೌದು, ಅದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ನಡೀತಿರೋ ಕೊಟ್ರಿ. ಮತ್ತೆ ಇಲ್ಲೇ ಇರ್ಬೇಕು, ಅದ್ರಲ್ಲೇ ಇರ್ಬೇಕು.
This was
Pay for additional.
filed on 18th August 2023.
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋವಾಗ ನಾವು ಕೊಟ್ಟಂಗೆ. ಅಲ್ಲ IAS ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡೋವಾಗ್ಲೇ ಕೊಟ್ಟು.
Day 1 of 2023.
ಇಲ್ಲ, this is paper book.
ಇದೆಯಲ್ಲ?
ನನಗೆ ಬಿಚ್ಚಿದ್ದಾರೆ ಇವರೆಲ್ಲ ಒಟ್ಟಿಗೆ ಕಟ್ತಾರೆ. ಇಲ್ಲಿ ಬರೀ ಅಪ್ಲಿಕೆಂಟ್ ಅಂತ ಬರೀತಾರೆ, ಯಾರಂತ ಬರೆಯೋದಿಲ್ಲ. ಅಪ್ಲಿಕೆಂಟ್ ಇಸ್ ಗೋಪಾಲ್.
So these are the sale deeds executed during the pendency of the suit.
ಅದು ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿದ್ರಿ, ಇವ್ರು ಯಾರಿಗೋ ಮಾಡಿದ್ರು, ತಿರುಗಿ ಅವ್ರ ಹೆಂಡತಿ ಅವೆಲ್ಲ. If whatever alienation is made during the pendency of the appeal, if you succeed, no,
Not during the pendency of the appeal. In the pendency of
sorry,
the.
pending suit or appeal, what litigation, I say, all. They are all subject to the result of the case.
Aye.
If you succeed, how are they required for disposal of the case?
If going to the court that.
The 41 third purpose. The appeal, ಅದಕ್ಕೊಂದು ಕ್ರಾಸ್ ಅಬ್ಜೆಕ್ಷನ್ ಅವ್ರು ಹಾಕ್ತಾರೆ. How is that you can maintain cross objection here? You should file a appeal.
File to claiming the exhibit.
See, trial court had not given, huh?
We filed the cross objection filing claiming R2 properties.
Two property. Correct.
Correspondent.
How, you should have filed an independent appeal. You were the plaintiff. In his appeal, how the cross objection? It is not that unsuccessful.
Appeal.
Huh? But appeal and cross objections. Appeal, cross objections. And IA 1 of 2016, 1 of 2019 and 1 of 2023 are hereby dismissed. Reasons to follow. Dismissed applications, appeal and cross objections are dismissed. Reasons to follow.
Only one submission. Some of the documents which were not marked, which were sought to be considered, that cannot be done under section 60.
Correct. Trial court maybe to some extent that expression was not required. Bekandre recover, father has the right to recover and that was not required. But still the fact remains that it was not to acquire as a joint family property. We are satisfied about this. Yes, it's.
Cell number
Dismissal.
7,
Dismissal.
MR Narayan, Gurraj Joshi.
ಅವತ್ತು ಅವ್ರು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿರ್ಲಿಲ್ಲ, ಬರೀ ಅಪೆಲೆಂಟ್ಸ್ ಕೌನ್ಸಿಲ್ ಮಾಡಿದ್ದು. ಇಲ್ಲ ಇಲ್ಲ ಒಂದ್ ಸ್ವಲ್ಪ ಏನೋ ಬರ್ದಿದ್ದೀನಿ did not demand and realize the our ground principal borrower. No demand before fiction from borrowers. Borrowers for the bar of limitation. Classes in building petition obtain guarantee against 5,000. Fine, none, 3.54 is the bestest from the 126 of the three condition. ನೀವು ರೆಡಿ ಇದೀರಾ?
Senior is on his legs in Kotal 1, madam. Appellant start ಮಾಡ್ಬೋದು.
You are completed or not? You are concluded or not concluded? Conclude ಆಗಿರ್ಲಿಲ್ವಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ. Just I started.
Then he is not there.
He's on his legs in Kotal 1. ಬರ್ತಾರೆ madam.
Roster bench ಮುಂದೆನೆ ಹೋಗ್ರಿ. It's not substantially heard every recorded.
He'll be here in.
See, we are taking up old matter ಅಂತ ತಗೊಳ್ತಾ ಇದ್ವಿ. ನೀವು ಬರ್ಲಿಲ್ಲ, ಒಂದ್ SFC ಮುಗಿಸಿದ್ವಿ ನೋಡಿ.
ಬರ್ತಾರೆ madam. ಅವ್ರು ಸ್ಟಾರ್ಟ್ ಮಾಡ್ಬೋದು, ಬರ್ತಾರೆ ಅಷ್ಟಲ್ಲಿ
ಬರ್ತಾರಾ?
ಡೆಫಿನೆಟ್ಲಿ ಬರ್ತಾರೆ.
ಬಂದ್ ಬಿಫೋರ್ ದಟ್ ಇವ್ರದ್ದು ಇನ್ನೊಂದು ಮುಗಿಸಿ ಹಾಗಾದ್ರೆ ತಗೊಳ್ಳೋಣ. ಅವ್ರದ್ದು ನಾವು ಶುರು ಮಾಡಿರ್ಲಿಲ್ಲ, ನೇಸರ್ಗಿ ಅವ್ರದ್ದು ಅದರ್ ಸೈಡ್ ಬರ್ಲಿಲ್ಲ ಅಂತ ಹೇಳಿ, ಬಂದ್ರೆ ಬರ್ಲಿ ಅಂತ ಹೇಳಿ ಅದನ್ನ ಅವತ್ತು ಪಾಠಡ್ ಅಂತ ಮಾಡಿದ್ವಿ. ಜಸ್ಟ್ ವಿಲ್ ಪಾಸ್ ಇಟ್ ಓವರ್ ಅಂಡ್ ಟೇಕ್ ಅಪ್ ಅದರ್ ಮ್ಯಾಟರ್ಸ್ ಆಫ್ಟರ್ adjourning them we'll take up your matters. Oh, ಮೇಡಮ್ ಬಂದಿದ್ದಾರೆ ಇಲ್ಲಿ. And that day we have not heard you. In fact, they did not appear. Therefore, yes, at least ಪಾಠಡ್ ಅಂದ್ರೆ ಬರ್ತಾರೆ ಅಂತ ಹೇಳಿ.
I apologize.
Mr. Counsel.
No, I'm very well.
Still number 8 for the appellant.
Now we will go before the roster.
I came personally for the reason. ಈ ಆನೇಕಲ್ ಕೋರ್ಟ್ಲಿ ಏನಾಗ್ತಿದೆ ಅಂತ ತಾವು just para 19 you run.
Is it correct that on that day we had not heard you? Actually, they did not appear.
Yes.
At least ಪಾಠಡ್ ಅಂತ ಮಾಡಿದ್ರೆ ಬರ್ತಾರೆ ಅಂತ ಹಾಕಿದ್ವಿ. Want to go before the roster bench or?
Doesn't matter, but assets and liabilities affidavit has been filed. I can't meet it because I haven't the copy.
But you have to take copy unless you come to the court. How do they serve you? In this ex parte judgment alva?
Yes, yes, madam.
Ex parte.
He
wanted to know whether.
Irrespective of the case, I'm not worried about the case. The manner in which the proceedings are going on in Anekal. You just were on my kindly say para 19. Same thing is going on all other cases. Why I'm worried is I came only to institution has to be saved.
Para 19 of judgment.
Para 19 of just only for
Appeal memo.
appeal memo.
Yes. Yes, yes. We have seen, madam.
ಅಲ್ಲ ನಾನು ಯಾಕೆ
Not only
ಹೇಳ್ತೀನಿ
in,
ಅಂದ್ರೆ ಅಲ್ಲ ಈ ಕೇಸ್ ಅಲ್ಲಿ
Not only in Anekal court, we have seen in some other court also. ಈ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಪ್ರಿಪೋನ್ ಮಾಡಿಸ್ಕೊಂಡು ಡೈವರ್ಸ್ ಡಿಗ್ರಿಗಳು ಇವನ್ ಅದ್ಯಾರೋ ನಿರ್ಮಲಾ ಯೂನಿವರ್ಸಿಟಿ ಕೋವಿಡ್ ಪೀರಿಯಡ್ ಅಲ್ಲಿ ಕೇಸ್ಗಳನ್ನ ಪ್ರಿಪೋನ್ ಮಾಡಿಸ್ಕೊಂಡು I mean, judges also, you are right, we have set aside some.
ಇದು ಒಂದೇ ಆದ್ರೆ I don't bother. ನಾನು I came to know that similar practice is going on. ಇವತ್ತು ಕೇಸ್ ಹಾಕೋದು, ಡೇಟ್ ಕೊಡ್ತಾರೆ, then make an application for early hearing, take paper publication and getting a decree. ಅದು why I am worried is, something has to be done with the system. If one day one case I can exception. Similar is going on ಅಲ್ಲಿ ಅದೇ practice ಅದೇ ತರ both the advocates, the understanding. Something must be done in this case. That's why I was not, I said you can go and do it with but I wanted your honor to know about it.
Not make a representation, will issue, will circulate to all the family courts. We too saw in not with the advancement, not only advancement, during COVID period, nobody were able to move outside. During that period, cases were preponed, evidence were recorded, and decree were granted. We have set aside several such judgments. Because they are expert, it will be easy when the disposal can be shown. That is not the purpose of the courts and the law. It is to do justice.
Yes.
Right in this.
Even during COVID, my lord, if I may say, even during COVID, we appeared in, by VC. I myself have appeared in VC on multiple cases. And even during COVID, on one occasion, when I did not appear in VC, I was pulled up saying that you ought to have appeared on that day. An email was sent to your email ID. So when she has received a notice, she would have appeared. It's not that as if something has happened behind her
Fact
back.
remains that it was an ex parte decree.
Yes, sir.
Whether
Whether that is now
whether matter
sustainable
to-
or not is a different matter.
Hmm.
That we'll examine.
No, generally to give one more opportunity, it can be remanded and a time bound manner, it can get this matter
But the
disposed of.
reason I would resist this is because I'm not sure if my party has remarried. That's the only thing. I just need to take some instructions from the council who appeared in Annika.
No, even if suppose he is married, even on merits, even after hearing you, if you feel that it is a case for remand, then even if he has married, what he is going to do?
Then I leave it to your lordship. But I just require a little bit of time. I have received an appeal memo with bereft of a judgment also.
Last time you were not present.
Of course not. But
So you blame the other party, notice served, they did not appear. You had appeared, your name was shown in the costly student, none of you appear.
I'm very
See,
sorry.
these things in the life keep happening, we are not saying anything to you. Many times, maybe some reasons. More particularly, a woman, I know, the issues are there.
I came across 6 cases, same time.
Madam,
No,
make a
no.
note, send it to us, put it across.
Yes.
Please, send a circular. Bringing it to the notice of the chief justice.
Yes.
And these things happen only in family matters, NI Act cases, ejectment suits. And with your all rich experience, you know why these things happen. Now you are going to file your affidavits or what are you going to
Now, the
file?
statement of assets and liabilities has been filed. I'll file mine also, but I'll meet.
But they have filed in 2000, when did they file their?
Not the application is 2021. I have received just this.
You filed, no?
Yes, correct, but.
When did you file?
Our office has not raised any objection saying that you have not received the copy. IA1 of 2020.
IA1 filed along with the appeal memorandum itself, my lord.
One second.
Good.
Idr mele illa, there is no,
IA1 is filed along.
correct, but he says he has not received the copy.
No.
There is no endorsement.
IA is here. The IA is here. The
Assets
assets
and-
and liabilities are not.
One second, they have filed it subsequently. That was filed on 6/3/2023, furnish the copies. to
Okay,
us.
the furnish, IA1 is with him.
Not- Affidavit.
No, I'll give it to you.
Learned counsel for the
Do
respondent submits that he has not received the copies.
I have received the
Assets
copy.
and, learned counsel for the submits that the copies of the affidavit and assets and liabilities are served on him today itself. And seek some accommodation. The matter is released from Pathak. List before the roster bench on. Date here and on the date 14. 15. 15/4.
15/4.
Accommodation.
Next number.
To file the affidavit and affidavit with assets and liability statement of respondent. You file it
I'll
by 15th.
With pleasure.
Till number 9.
In this case, my lord,
Hmm.
petitioner examines not subjects himself to cross-examination. It's not posted for respondent's evidence, decree is granted. Once he does not subject to the cross-examination, there is no material on
Last
on
time
which he can give a
ಅವರು
decree.
theater ಅಂತ they didn't turn up. Last time also they did
John
not come.
Bosco?
No representation for respondent, heard Srimati Kamala necessary.
Petition ought to have been dismissed.
ಅದು records ಕೊಡಿ ನೋಡೋಣ. ಅದು judgment ಅಲ್ಲಿದೆ, he has not turned up. They should have struck down the evidence. Petitioner examined himself and produced exhibit P1. Respondent did not choose to read the evidence of the PW1. Cross examination ನಲ್ಲಿ ಆಗಿದೆ ಅಲ್ಲ ಮೇಡಮ್?
Further evidence that is ಮಾಡಿದೆ, husband
Correct.
had used
Madam
further
was submitting that he did not tender himself for
No,
cross
it was
examination.
posted for further evidence,
and he has
then
said
it does not
Correct.
subject.
His evidence was completed.
Correct, but cross-examination ಇಲ್ಲಲ್ಲ.
Further cross ಆಗಿದೆ ರೀ.
further evidence. no,
Further cross examination by counsel respondent is present.
But,
Counsel
further-
is.
Or
respondent
I'll
is present.
order sheet ಕೊಡು.
Pray time sufficient
Or
apart.
I'll show you.
Your counsel did not cross examine ಮತ್ತೆ ಅದಾದ್ಮೇಲೆ recall ಮಾಡಿದ್ದಾರೆ ಮತ್ತೆ.
ಮಾಡಿದ್ರು, recall
ಮಾಡಿದ್ದಾರೆ. Cross examination PW1.
Subsequent to which petitioner,
No,
respondent has
madam was
said he
submitting that he did not tender himself for cross examination.
further cross examination.
My lord, what has happened is, on 5/3/19, petition is absent.
Several times have.
Absent. Objection to 14 and 15.
Madam, ಇಲ್ಲಿ
Then,
cross.
29/3. Objection to IA 14 and 15 where we have called for. Then again on 9/7/7, no representation.
No,
Here on 14
See,
and 15.
27/2/2018 order sheet ಆಗಿತ್ತು. ನೀವ ಇಲ್ಲ ಅಂತ cross examination ಆಗಿಲ್ಲ.
Appeal memorandum.
27/2/2018.
Here. Para 7.
27/2/2018. ಮುಂದೆ arguments ಬಂತ ಆಯ್ತು. Respondents evidence.
Para 7 of the order we were on.
27/2/2018.
Page 9. That the appellant had finished cross-examining the respondent on 29/9. After which
No,
the
the
respondent
judgment
had
has been
filed.
records. You please look into the records. Don't read the judgment. See, on 27/2/2018, it was listed for further cross-examination of PW1. ಇಲ್ಲಿ ಹೇಳ್ತಾರೆ PW1 is present, respondent is absent. No representation for the respondent. Hence, cross-examination of PW1 taken as nil. Then the matter was petitioner closes his side of the evidence for respondent's evidence. That it was adjourned. Thereafter, there was no representation for the respondent. Respondent's evidence was taken as nil. Then the matter was posted for arguments. Arguments also, both parties are absent. ಆಯ್ತಾ? ಯಾವಾಗ ಲಾಸ್ಟ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಆಗಿದ್ದು? One second, ನೋಡೋಣ. Then you find objections.
Right. All that I am stating is, the
For
advocate for
arguments,
the appellant retired.
She's reading.
both parties response counsel files IA 14 and 15 to recalling for further cross-examination of PW1. What happened on that? Petitioner absent, objections to finally taken as not filed, no representation. What order was passed on those IAs? PW1 is ordered to be
After the
recalled.
IA was
It
allowed
was
to-
allowed.
After the IA was allowed to recall,
For-
thereafter it does not
On
subject
cost of
himself.
rupees 1,000. PW1, any PW1, absent respondent, PW1 absent. Sure. PW1 taken as further cross-examination is taken as nil.
Yes, ma'am.
That was only, ಅದು ಬದಲಿ
I-
ಪೂರ್ತಿ
ಆಮೇಲೆ IA ಹಾಕಿದ್ರು, recall ಆದ್ಮೇಲೆ yes, you're
only two documents were subsequently marked.
2 times I cross-examined, Thereafter,
FIR
not
and
subjected,
transfer.
then she files an application, application was allowed. Thereafter, he does not submit himself to the cross-examination. That's the technical part. Even otherwise, I just want on the, it says, where is the order under 25 maintenance?
That was filed.
No
there.
order is passed.
No order is.
No order is passed. Assuming that they could, all these things could be overcome. Technically, she sent it, something could, final
When did
order,
you
on the
file that,
condition. Final order, he did, just a decrease granted.
No. When did you file that application? 25 application?
Along with the appeal, my lords, one second.
For arguments, no? Respondent files IA
34, my lords.
IA number. ಇದು recall ಮಾಡಕತ್ತಿದ್ದು recall ಆದ್ಮೇಲೆ. No, 25 application, section 25 application.
No,
ಇದೆ.
file madilla. She was objecting for divorce actually.
Huh?
She has not filed any application before trial
Not
court.
necessary, my lord, my Supreme Court has laid down. I may file an application or
See,
not.
if it is
Although I
not
am requesting
necessary,
this honorable-
at least you should have filed your affidavit and assessment.
Now I have filed here also. I
24.
filed number one, last page, I 24 ಹಾಕಿದ್ದೀನಿ. Assuming, madam, the law
24
laid down, no, a law laid down by the Supreme Court is, even assuming that the wife does not file an application under 25 for maintenance, the court is bound to give her maintenance at the, while passing the order.
Correct, how the court grants it. You do not come, you do not enter the witness box, you do not say what is your requirement, what is his income.
24 application has been
24
filed.
Yes, so filed.
ಇಲ್ಲೂ ಹಾಕಿ ಅದಕ್ಕೆ ನಾ ಹೇಳಿದ್ವಿ
Time
law is whether I file or not. Assume for a moment you are,
No, you, all right, even if you do not file.
I have not
court-
filed.
Correct, how does the court comes to know what is
Then
his
they,
income? what is-
the honorable, the courts below will have to call upon both the sides to file application that now in view of the Rajneesh case. Assets and liabilities and past the order, irrespective.
Madam, 24 application has
But
been filed.
24 application is, you are on my kindly see.
And an order of 6,000 per month has been awarded by the trial court.
That was interim maintenance.
Yes, my lords. 24
On
application.
23/11,
Now you want here the order to be passed again.
Because that order was till the suit ends.
Yeah, correct.
Subsequent to which also, that amount also not been paid.
not been paid is one thing. Now I have filed
But even
claiming
is-
25,000 ಕೇಳಿದ್ದೀನಿ.
Execution file ಮಾಡಿದೀರಾ?
6,000 ಕೊಟ್ಟು, ಅದು ಕೊಟ್ಟಿಲ್ಲ.
Execution is pending, my lords.
Correct,
Execution is
recovered
pending,
or-
that's not on the-
Why it's not recovered? Why it is not recovered if EP is filed?
This one is different.
We have filed the order sheet dated 23/11/17.
Demand ಮಾಡ್ಬೋದು.
From date of application,
Madam,
that
see,
is 21/7,
earlier the party was
till
represented
disposal of
by-
the
They
case.
are not turning up. Evidence was not complete. So 6,000 was there being paid. At the most, we can remand this matter to give you fresh opportunity because you had not let in your evidence. And the same 6,000 continues till the disposal of the matter. Or because they are not appearing. What do you say for that?
ಅಲ್ಲ, execution ಅಲ್ಲೂ ಬರ್ತಿಲ್ಲ. We have been trying.
Correct. You want us to.
One more note, even I don't mind taking paper publication, let him come.
No,
He
he
has
has
filed
appeared
ವಕಾಲತ್.
to
He
counsel.
has filed ವಕಾಲತ್.
Correct, ಅದಕ್ಕೆ ನೀವು ಈಗ, now in these circumstances, what we have to do? We have only, now you have not cross-examined, I mean, you have not let in evidence also. We'll send back to decide 25 as well as, I mean, this matter on merits, that is one option. Until then, we can continue that 6,000. All right. Got it, madam, got,
Yes.
you got the point?
I think when you give one more opportunity and see it.
Then go before the roster bench only.
ವಕಾಲತ್ ಹಾಕಿದ್ದಾರೆ, I don't know. He may be.
ಅಲ್ಲ, ಹಾಕಿದ್ದಾರೆ, somebody has filed in these two cases.
ಹಾಕಿದ್ದಾರೆ, ಇಲ್ಲಿ ಹಾಕಿದ್ದಾರೆ.
ಹಾಕಿದ್ದಾರೆ, ಲಾಸ್ಟ್ ಟೈಮ್ ನಿಮ್ದು ಹಿಂದಿನ ಕೇಸ್ ಈ ಕೇಸ್ ಎರಡರಲ್ಲೂ ಅಡ್ವೊಕೇಟ್ಸ್ ಬರ್ಲಿಲ್ಲ. ಯು ಅಪಿಯರ್ಡ್, ರೆಸ್ಪಾನ್ಸ್ ಕೌನ್ಸಿಲ್ ಡಿಡ್ ನಾಟ್ ಅಪಿಯರ್.
ಹೌದು.
ಅಟ್ ಲೀಸ್ಟ್ ಪಾಠಾಡ್ ಅಂದ್ರೆ ಬರ್ತಾರೆ ಅಂತ ನಾವು ಮಾಡಿದ್ವಿ, ಬಟ್ ಬೈ ದಟ್ ಟೈಮ್ ಅವರ್ ರೋಸ್ಟರ್ ಚೇಂಜ್. ಈಗ ಗೋ, ಇಫ್ ಯು ಸೇ ವಿಲ್ ರಿಲೀಸ್ ಇಟ್ ಬೈ ಫ್ರಮ್ ಪಾಠಾಡ್, ಗೋ ಬಿಫೋರ್ ದ ರೋಸ್ಟರ್ ಬೆಂಚ್. ಆರ್ ಯು ವಾಂಟ್ us to dispose it today only? It can
No,
be
no,
disposed.
I am not particular about it. We want justice. That's all. Lady said, this is the circumstance.
Correct.
If it does not come, what is to be done?
No, you are not.
We request the court to decide and give
No.
something.
Thus, justice will be met because you were awarded 6,000 before the trial court. You had not challenged that and quantum kadme agide anta, you had didn't challenge. Now what all you want is an opportunity to read your evidence and when consideration on merits. So we can remand it, continuing that 6,000 rupees maintenance till the disposal of the case. Or we can even reserve liberty to you to seek modification of the same. Alva? Yes, ಏನ್ ಹೇಳ್ತೀರಿ ನೀವೇನ್ ಹೇಳಿದ್ರೆ will continue.
As of today, he is represented by an advocate, not appeared. Then you are on my allow my application and grant whatever.
Application ಒಂದೇ ಮಾಡೋದಿಲ್ಲ, ಮಾಡಿದ್ರೆ ನಾವು ಎಂಟೈರ್ ಕೇಸ್ ಡಿಸ್ಪೋಸ್ ಮಾಡ್ತೀವಿ.
Continue ಮಾಡ್ಬೋದು. ಅದಕ್ಕೆ ಇದು maintenance at least to be granted.
Then, but
I leave it to you, either give an opportunity or take no objections and then
yeah, the 25,
I
6,000
have
ಮಾಡಿ
claimed
order
50,000 expenditure and 25,000
Then
per
continue
month.
ಮಾಡಿ ಏನ್ ಮಾಡ್ತೀನಿ ಹೇಳಿ. But no representation for the respondent. ನಿಮ್ಮ 24 application ಅಲ್ಲಿ 25,000 ಕೇಳಿದೀರಾ? So where is, what was that date of order of the trial court granting 6,000? Can you tell us the date of order of that? 21. Just, we got it. This was order dated 23/11/2017.
From the date of application.
Date of application is 21/7/17.
Response counsel not appearing before that court consistently. ಅದರಿಂದನೂ ಆಗಿದೆ.
His income, I said 1 lakh per month.
Okay.
And he is working in an American company, that's also not denied.
Senior counsel insists for passing orders on I-2/2021, seeking the 24.
Some rule 1/3 salary.
Maintenance of this 25,000 and litigation expenses.
ಬಂದು ಡಿಸೈನ್ ಮಾಡ್ತಿರ್ತಾರೆ, ಇಲ್ಲ ಅಂದ್ರೆ I am entered. Apart from that, he's got immovable properties, leave alone the salary.
Before
He
the
has got
trial
the
court,
properties.
interim maintenance of this 6,000 was granted by the order dated before the trial court. Before the trial court, and the trial court on the similar application by order dated 23/11/2017 was awarded as interim maintenance, and litigation expense of this 15,000 was awarded. The respondent is the appellant had not let in the evidence for the trial court. Considering the opposite facts and circumstances. ಏನೀಗ 2017 ಇಂದ ಸ್ವಲ್ಪ ಹೆಚ್ಚಾಗಿದೆ ಅಂದ್ರೆ 10% ಹೆಚ್ಚು ಮಾಡ್ಕೊಂಡ್ರು ಎಷ್ಟಾಗುತ್ತೆ? 15,000, 16,500 ಆಗುತ್ತೆ. Considering affidavit ಹಾಕಿದಿರಾ ಅಸೆಟ್ಸ್ ಅಂಡ್ ಲಯಬಿಲಿಟೀಸ್? ಇಲ್ಲ ಹಾಕಿಲ್ಲ, ಮತ್ತೆ ಅದನ್ನ ಕನ್ಸಿಡರ್
Ready ಆಗಿದೆ. She couldn't get certain documents.
then you file it, no? Without that we cannot.
We'll file.
We thought of
Immovable
continuing.
property, Bangalore 5 site is there, but she is not the person to get the details. But however, I said, he is getting an income of 50,000 from
We
the
were
properties.
intending to continue that
I have not
6,000
placed any.
with an at the most an escalation of 1,500, 10% ಕೊಟ್ ಮಾಡೋಣ ಅಂತ. But if you want to file affidavit of assets and liabilities, if you can substantiate that, then you go before the rest bench, so that you may get higher amount. We'll release it from the party.
We'll release it
ಈಗ
from the
ಭೂಮಿ ಇದೇನೋ ಮಾಡಿದಾರೆ, ಅದೆಲ್ಲ ಹಾಕಿ ನೋಡಿದ್ರೆ perhaps it is name.
No, no,
I may get.
madam,
ಸಿಗೋದೇ.
ನಮ್ಗೆ ಏನ್ ಮಾಡ್ಬೇಕು ಅಂತೀರಾ? Whether you want us to pass some interim order based on the trial court's order, or you will file the affidavit of assets and liabilities statement, so that he can, if he has properties, he may seek get more
I
amount.
would appeal to your lordship, the practicality. The ladies come. ಎಲ್ಲಮ್ಮ ಏನಿದೆ ಎಲ್ಲಿ ತಗೊಂಬ ಅಂದ್ರೆ ನೀವೇ ತಂದು ಕೊಡಿ ಅಂತಾರೆ. That is why the Supreme Court in Rajesh case said, let him file ಅಂತ. He can't deny.
ಅಲ್ಲದು ಒಂದು ರಾಜೇಶ್ assets and liability statement ತಗೋಬೇಕು ಅಂತ ಇದೆ. ಇದು interim ಮಾಡಿ but And having regard to the escalation.
I'm sure your honor, once the order is passed, he will come back
2000.
and he will file an application, then we can call upon him. Otherwise, they won't come.
2017 and 2024. And the fact that none of the parties had questioned. He also did not challenge that. He also did not challenge that 6,000.
Because thereafter she was appearing party in party.
6,000 per month, awarding interim maintenance of 6,000 per month. It would be just and in the interest of justice to award an interim maintenance of per month and litigation expense of 15,000. So it is 15,000, 10,000 per month till the disposal of the appeal or till further orders in the money. Till further orders. Till the further. 6,000 per, realized 10,000 per month from the date of the appeal till further orders. And litigation expenses of this 15,000. Madam free ಮಾಡ್ತಾರೆ 15,000. Okay. IA number ಎಷ್ಟದು?
2 of 21.
2 of 21. Okay. Is disposed of accordingly. For final hearing, list for the roster. Release from parted. Release for the roster bench. Yes.
Pastor matters. Hearing on IS, seal number 5, SG Rajendra Reddy.
Yes, you are waiting in which matter? Yes. Go, Gurraj Joshi, your colleague, yes.
IA for suspension of sentence number 8.
Oh, ಇದು suspension of sentence,
Suspension.
we confused. ನಿಮ್ದು ಪಾಸ್ ಓವರ್ ಮಾಡಿದ್ವಿ ಕರೆಕ್ಟ್. HCVP ಬಂದಿರ್ಲಿಲ್ಲಲ್ಲ ಅವಾಗ.
Second, successive IA.
You did not press the earlier application.
Eight.
Yes. Case was based on
Withdrawn, my lord.
eyewitnesses version.
Not pressed. Earlier application was not pressed.
They were on bail during the trial, no?
Yes.
They were on bail.
Yes.
But this appeal is filed in 2023. ಅಲ್ಲಿಂದ ಇಲ್ಲಿವರೆಗೂ why did you not?
In all, my lord, in all, 6 persons were tried. 4, since 4 is a juvenile, my lord, he was sent for juvenile court. And sorry, split up case. And accused number 5 is acquitted. A1, A2, A3 was convicted. This summer court, my lord, granted bail to A3 and A6. And my lord, A1 and A2 application, my lord, not argued and dismissed or withdrawn. Sorry, it was withdrawn, not pressed. IA1 dismissed or was not pressed.
Yes.
The facts of the case, my lord, is that
Yes.
there was illegal between the accused and the deceased Mahesh Naika, as he has not supported accused number 5 in the village panchayat elections, and there was a quarrel between them, Mahesh Naika and accused number 1, in which Mahesh Naika assaulted accused number 1, deceased Mahesh Naika assaulted accused number 1, and accused number 1 has given a complaint, and thereafter Mahesh Naika, deceased, was absconding. After obtaining bail, my lord, deceased was nurturing ill will against these persons, my lord, since the accused persons have not supported the accused number, deceased Mahesh Naika. On 5/5/2017, my lords, his alleged my lord is A1, A2, came in a motorbike, restrained the accused, deceased, and assaulted. The allegations, my lord, accused number 1 and accused number 4. Accused number 1 assaulted with machu on the neck, and accused number 2 assaulted with a knife on the stomach. Accused number 3 and 4 also assaulted, my lord, with hands and macho.
Yes.
No, my lord, grounds for bail, my lord. The complaint is, in this case, the complaint is prepared by the police.
Hmm.
Police took the signature of the complainant at the hospital. Original complaint is suppressed.
Hmm.
The law, PW 6 and 7 are the eyewitnesses.
Yes.
Out of them, PW 7 has not supported.
Hmm.
Even though PW 6 is eyewitness, who is a neighbor of the deceased, he has not informed the incident to his wife, deceased wife, or villagers, or the police till next day. Even though your police were present at the spot by 5 p.m. Therefore, my lord, the evidence of, at this stage, my lord, the evidence of PW 6, the sole eyewitness, my lord, cannot be believed. And punch witnesses, my lord, PW 9 and 19, for the spot and seizure of the embossed, my lord, is not supported. The entire case is the rest only of the evidence of PW 6, whose evidence cannot be believed. Because, my lord, even though you are present,
When his statement was recorded,
next day of the incident,
date of,
one subject.
date of offense is 5/5.
Yes, my lord. Date of incident is on 5/5/2017 at 12 p.m.
12 noon.
12 noon.
Okay. Complaint was filed on which date? FIR.
Complaint on the same day.
Credit, illalla. Whether in the complaint his name was shown as eyewitness. What is the name of this PW? 7 alla?
PW 6.
6 Devendra Nayaka. Complaint nalli avರ ಹೆಸರು ತೋರಿಸಿ.
PW 6 Devendra Nayaka.
FIR is exhibit? ಅಥವಾ complaint ಅಲ್ಲೇ ನೋಡೋಣ. Complaint was filed by the wife ಅಲ್ಲ?
Wife. FIR.
Exhibit P35, my lordship, FIR.
ಅಲ್ಲ ಈ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲೇ ಅವ್ರ ಹೆಸರು ಬಂದಿದೆಯಾ ಕಂಪ್ಲೇಂಟ್ ಅಲ್ಲಿ ಅವ್ರು ಐ ವಿಟ್ನೆಸ್ ಅಂತ ಏನಾದ್ರು ತೋರಿಸಿದಾರ?
ಇಲ್ಲ ಯಾರು ಹೇಳಿದ್ರು ಅಂತ ಹೇಳ್ತಾರೆ.
ಗ್ರಾಮದ ಕುಮಾರ ನಾಯಕ ಕಲ್ಪನಾಯಕ ಇತರರು ಸೇರಿಕೊಂಡು
ಹೆಸರು ಬಂದಿಲ್ಲ.
ಯಜಮಾನರ ಬೈಕ್ ನಂಬರ್ ಸೋಯಲ್ಸು ಹರಿತ ಆಯುಧಗಳಿಂದ ಮಾಡಿರುವ ಕುಮಾರ ನಾಯಕ ಇವ್ರು ಹೇಳಿದ್ರು ಅಂತ he has not informed the wife. He has not informed.
No,
His name is not sure.
No, not sure.
No,
He has not
it's
informed the wife.
FIR no. FIR is exhibit?
Exhibit, my lord,
P35, my lordship.
P30,
35.
35.
ಇಲ್ಲ ಅದರಲ್ಲಿಲ್ಲ.
ಅಲ್ಲ ಅದಲ್ಲ ಡಿಲೇ ಇದೆ ಅಂತ ನೋಡೋದು.
There is a delay.
P35 ನಾ?
Please.
According to them, my lord, 17 hours. 17 hours.
P35. 55. According to them, it was between 1:30 and 1:30.
17 hours.
55. 5 ಗಂಟೆ ಕೊಟ್ಟಿದ್ರು.
ಹೌದು.
FIR reached on 5/5/2017 9 p.m. ಅಂದ್ರೆ 5 ಗಂಟೆ ಕೊಟ್ಟರೆ ದಿಸ್ ಇಸ್ ಯಾವುದು ಶಿವಮೊಗ್ಗ ರೂರಲ್ ಪೊಲೀಸ್ ಸ್ಟೇಷನ್ ಮತ್ತೆ ಅಲ್ಲೇ ಇರುತ್ತಲ್ಲ ಸಿಟಿಯಲ್ಲಿ JMFC ಥರ್ಡ್ ಕೋರ್ಟ್ ಶಿವಮೊಗ್ಗ. Earlier bail order ಇದೆಯಾ ನಮ್ದು ಈಗ he was because during the trial they were on bail.
They were on bail, my lord.
Order copy ಇದೆ.
3 and 6 were enlarged on bail by this normal court.
Correct. Yes. Vote act was to these accused number 1 and 2.
There is vote act, my submission, there is vote act, but the entire evidence, my lord, based on the evidence of PW.
Then we are trying to say, ಅವ್ರಿಗೆ ಕೊಟ್ಟಿರೋದು they cannot
No.
claim parity. But during the trial they were granted
Yes.
bail.
Yes.
ಆ ಆರ್ಡರ್ ಕಾಪಿ ಇದೆ ಏನ್ ಕನ್ಸಿಡರ್ ಮಾಡ್ಕೊಟ್ಟಿದ್ರು. Now only the evidences of
ಅಲ್ಲ ಇದೆ
PW 6.
ಅಲ್ಲ NCR ಇದೆ.
NCR ಅಲ್ಲಿ ಇದ್ರೆ
They are on bail.
ಒಂದು bail ಅನ್ನೋದಲ್ಲಿದೆ.
What of sorry.
ಇರ್ಲಿ ಬಿಡಿ. Yes, ನೀವೇನ್ ಹೇಳ್ತೀರಿ?
My lordship, in.
Because his name was not there in FIR. In FIR. Statement next day record ಮಾಡಿದೀವಿ ಅಂತ ಹೇಳ್ತಾರೆ. We do not know whether in remand application they had shown his name or not. He was related or?
My lord, villagers.
No. What was his
Neighbor.
neighbor?
Neighbor.
neighbor of the
Deceased.
deceased.
He has not informed the wife was present in the house, nor villagers, nor the police. First, crucial evidence. My lord, accused number 1 is arrested on
What are
65.
his antecedents?
No, no previous evidence.
ಅವನೇ ಸರಿ ಇರ್ಲಿಲ್ಲ ಅಂತ ಇದೆ.
They are not habitual offenders, my lord.
Accused number 1 to 3 and 6 are
My lord, accused number 1 is enlarged on bail on 14/1/2019.
ಅದ್ರಲ್ಲಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ಅಲ್ಲೆಲ್ಲ
Both are enlarged. My lord, judgment on page 15.
ಅಲ್ಲ ಇಲ್ಲಿ ಕನ್ವಿಕ್ಷನ್
Page 15.
accused number 1, 3, 6 are convicted. Accused number
Judgment alle ide, they are on bail ಅಂತ ಹೇಳಿ.
3 are acquitted for 120B, 120, 140. 1, 2, 3, 6 ಬಿಟ್ರೆ ಮತ್ತೆ ಎಷ್ಟು ಜನ ಇದ್ರು?
5 ಜನ
ಅದರ ಸ್ಪ್ಲಿಟ್ ಅಪ್ ಆಗಿದೆ.
A4 split off, A5 acquitted.
A5 and A6 ಇದ್ರಲ್ಲ.
A5 acquitted,
A6
A3 and A6, A1 and A2.
A1,
A2, A3 and A6.
A1, A2, A3, A6.
Yes, ma'am. And they are on bail, my lord, on page,
Accused number 5 is acquitted. Accused number
Page
5
15.
already.
they are on bail. It is attested in the judgment itself.
ಅಲ್ಲ ಬಂದಿದೆ ಜಡ್ಜ್ಮೆಂಟ್ ಅಲ್ಲಿ.
But
Yes, what do you say, madam?
My lordship, in para number 34 of the judgment, my lordship, page number 32 of the judgment. Ink page number 45,
Yes, 45.
para number 34, my lordship. Further, PW6 is definite in his testimony that accused number 1 and 6 came in one bike and accused number 2 and 3 came in another bike. And he had also seen the accused number 4 coming from the other side of the road and had witnessed the accused number 1 to 3, accused number 4 and accused number 6 chasing, and further had witnessed the assault by the accused number 1, 2 and 4, my lordship. And further in para number 35, my lordship, ಕನ್ನಡದಲ್ಲಿ ಹೇಳಿದ್ದಾರೆ, my lordship. ಮಹೇಶ ನಾಯ್ಕ ನಮ್ಮ ಊರಿನವ ಇನ್ ಡೌನ್ ಅಕ್ಕಪಕ್ಕದ ಮನೆಯವ ಕಣ್ಣ ಮುಂದೆ ಘಟನೆ ನಡೆಯುವಾಗ ನಾನು ನೋಡದೆ ಹೇಗೆ ಇರಲು ಆಗುತ್ತದೆ ಅಂತ stated, my lordship.
Correct. See, this has to be now reappreciated evidence given on bail during the trial.
Yes.
And only one witness has supported, the other witness has not
Not
supported.
supported.
This person's name does not appear in the FIR as a eyewitness. So this has to be examined, re-examined. ಬೇರೆ ಏನಾದ್ರೂ ಅವ್ರಿಗೆ ಕ್ರಿಮಿನಲ್ ಕೇಸ್ ಇದೆಯಾ ಅಂತ ಕೇಳಿದ್ವಿ. ಬೇರೆ
no,
ಯಾವ್ದು ಕನ್ವಿಕ್ಷನ್ ಏನಾರ ಆಗುತ್ತೆ.
not habitual offenders.
We have to reassess the decision. Trial court ಅಲ್ಲಿ ಇರುವಾಗ ಅವ್ರು ಬೇಲ್ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಅವಾಗ ನಾವು ಅವಾಗಲೇ ಕೊಟ್ಟಿರ್ಲಿಲ್ಲ ಅಂತ ಇದೆ. ಇನ್ನು ಅವ್ರಿಗೆ ಬೇಲ್ ರಿಜೆಕ್ಟ್ ಆಗಿದ್ರೆ ನಾವು ಅವಾಗ ನೋಡ್ತೀವಿ ಯಾಕೆ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ರೆ ಮುಖ ಕೊಡಕ್ಕಾಗುತ್ತಾ ಇಲ್ಲ ಅಂತ. ಒಂದ್ಸರಿ ಅವ್ರು ಕೇಳಿದ್ದಾರೆ this is applicable. Six is convicted. We are trying to see that bail order. ಯಾರ ಹತ್ರನೇ ಇರುವಾಗ
Bail order.
No, they are not having
granted by this court or trial court?
trial court.
Trial court ಇರ್ಲಿಕ್ಕಿಲ್ಲ ಟ್ರಯಲ್ ಕೋರ್ಟ್ ನಲ್ಲಿ 302 ನಲ್ಲಿ ಐ ವಿಟ್ನೆಸ್ ಅಂತ ಕೊಟ್ಟಿರೋದು.
To observe, my lord, the trial court, the letter counsel submitted the accused are not habitual offenders, and there is no objection for that.
But we'll impose some conditions.
Please, madam, any conditions?
ಮತ್ತೆ ಅದ but as per this prosecution case, the deceased himself was
Yes.
involved in some other case.
Yes. He's a road element. He has assaulted case number 1.
Death of Mahesh Naik. He was involved in the death of Mahesh Naik.
All assault.
Accused number 1. Alla. Accused number 1 is Kumar Naik.
Kumar.
Name of the deceased was
Mahesh Naik.
Mahesh Naik. ಅಲ್ಲ ಎಲ್ಲೋ ಅವ್ರ ಮೇಲೆ ಏನೋ ಕೇಸ್ ಇತ್ತು ಅಂತ. Accused number 1 in this case had given complaint against Mahesh Naik.
Mahesh Naik.
With regard to the Having vengeance against Mahesh Naik and also having regard to the fact that same Mahesh Naik was nurturing ill-will with those persons who were supported accused number 5 to have plan to eliminate. So main source of this, I mean, the motive of reason was accused number
Election.
5. Enmity of the deceased with accused number 5.
5.
But that's a number.
2 of 20. Still number 5.
Number 5. Right, orders and number 2 of 23. Or the appellants slash accusing 1 and 2. 6 appeal file ಮಾಡಿದಲ್ಲ ಅವರು here he is granted bail.
Yes.
6 accusing 1 and 2. Have preferred the above quick challenge the order of conviction and sentence passed against them for the offences punishable under section 142, 148, 241. Will not to read section 149 IPC. The allegation against the appellants is that they along with accused number 2 to 6. Due to some previous evening, conspired to commit murder of Mahesh Naik and in execution of such conspiracy on 5/5/2017 at 12 noon. Near pump house ಅಂತೇನದು ಇಲ್ಲ pump house ಅಂತ ನೋಡಿದಾಗ ನೆನಪಿಲ್ಲ pump house near pump house on Sanna Tanda Road, Tanda Village Road, forming themselves into an unlawful assembly. The accused restrained Mahesh Naik when he was proceeding on his motorbike. It is further alleged that accused number 1 to 6. ಇವ್ರಿಗೆ ಒಂದು ಸ್ಪೆಸಿಫಿಕ್ ಕೋರ್ಟ್ ಆಕ್ಟ್ ಇದೆ ಅಲ್ಲ ಇವರು
ಹೌದೌದು. A1 assaulted with a long arm macho and yet to stab ಅಂತ ಹೇಳಿ.
Accused number 1, appellant number 1 and 2 assaulted the victim with a long and chopper.
A1 chopper, macho. A2 knife.
Sorry, assaulted him with chopper and Mo's chopper and
More 1.
chopper and knife movement. The other accused were also shared the common object of the appellants. Next, the trial court has convicted appellants. Accused number 1, 2,
3 and 6.
3 and 6. Acquitted accused number 5.
5.
Relying on the evidence of PW 6,
6.
PW 6, the alleged eyewitness. PW 7, the other eyewitness did not support. In PW 6 is said to be the neighbor of the victim. But his name did not appear in the complaint as eyewitness. During the trial, the appellants were on bail. They don't, so it is submitted that they have no other criminal antecedents. Hearing of this matter may take some time. Is admit agide?
Admit ಆಗಿದೆ.
ಪೇಪರ್ ಬುಕ್ ಆಗಿಲ್ಲ, ಪೇಪರ್ ಬುಕ್ ಆಗಿಲ್ಲ.
ಇಲ್ಲ ಇಲ್ಲ.
Under the circumstances. The earlier application, ಅದೊಂದು ಬರೆದು ಬಿಡೋಣ. The earlier application of the appellants for suspension of sentence and grant of appeal was not pressed and that was not disposed on merits. Considering the above facts and circumstances, it's a fit case to exercise discretion to suspend the sentence and grant bail. Hence the following order. The application is allowed. Appellants / accused number 1 are granted. The impugned order of sentence passed against appellants / accused number 1 is hereby suspended and they are granted bail in the above case subject to the following conditions. Fine amount ಎಷ್ಟಿದೆ?
10,000.
Total fine amount.
I will deposit.
They shall deposit
If not-
the fine amount before the trial court. They shall execute personal bond in a sum of rupees 1 lakh each and furnish one surety in the like sum to the satisfaction of the trial court. They shall ಎಲ್ಲ neighbors ಏನಾ ಇವರು accused ಇವರು?
ಒಂದೇ ಊರು.
They shall not indulge in any criminal activities. They shall appear before the court whenever required. Yes, ಏನಾರು ಬೇರೆ ಏನಾರು ಅಪ್ರಹೆನ್ಷನ್ ಇದೆಯಾ? ಪೊಲೀಸರು ಮುಂದೆ ಅಟೆಂಡೆನ್ಸ್ ಮಾರ್ಕ್ ಮಾಡೋದಕ್ಕೆ ಅದಕ್ಕೆ ಅಂದ್ರೆ ಆ ಪಾರ್ಟಿಗೆ ಈ ಪಾರ್ಟಿಗೆ ಮತ್ತೆ ಗಲಾಟೆ
ಸತ್ತವನೇ ಮಿಸ್ಕ್ರಿಯಂಟ್ ರೋಡಿ ಎಲಿಮೆಂಟ್ ಇನ್ ದ ವಿಲೇಜ್. ಇದು ಟ್ರಬಲ್ ಶೂಟರ್.
ಅಲ್ಲ
ಅವನು ಹೋದ್ಮೇಲೆ ಏನ್ ಗಲಾಟೆ ಇಲ್ಲ.
ಈಗ ವೈಫ್ ಅದೆಲ್ಲ ಇದಾರಲ್ಲ ಅವ್ರಿಗೆ ಮತ್ತೆ ಏನಾದ್ರು ಇದಾಗೋ ಚಾನ್ಸ್
ಏನ್ ಮಾಡಕ್ ಆಗ್ತದೆ ಪಾಪ.
ಹಾ ಇವರು ಮತ್ತೆ ಐ ವಿಟ್ನೆಸಸ್ ಇದಾರಲ್ಲ ಇವರೇ ಹೇಳಿದ್ರು ಅಂತ ಹೇಳಿ ಅಂತದ ಏನಾರ ಹೇಳಿ ನೀವೇ ಅಡ್ವೈಸ್ ಮಾಡಿ ಇಲ್ಲಾಂದ್ರೆ ನಿಮ್ ಪಾರ್ಟಿ
ಹೇಳ್ತೀನಿ ಊರಿಗೆ ಹೋಗ್ಲಿ ಬಿಡಿ.
ಮಾರ್ಕ್ ದ ಅಟೆಂಡೆನ್ಸ್ ಅಂತ ಹಾಕ್ತಿವಲ್ಲ ಅದ್ರ ಒನ್ಸ್ ಇನ್ ಎ ಮಂತ್. ಬೇಡ ಸುಮ್ನೆ ನೀವೇ ಇವ ಅಡ್ವೈಸ್.
ಐ ವಿಲ್ ಅಡ್ವೈಸ್.
ಅಷ್ಟೇ ಅಷ್ಟೇ ಸಾಕು ಅವರೇ ರೋಸ್ಟರ್ ಬಿಲ್ ಮೆನ್ಷನ್ ಮಾಡ್ತಾರೆ.
ಪ್ಲೀಸ್.
ಈಗ ಇವ್ರದ್ದು ಏನು ತಗೊಳ್ಳೋದು ಎಸ್ ಜೋಶಿ ಅವರು ಈಗ ಅವ್ರು ಹೋದ್ರ ಇವ್ರ ಪರ್ದ ಅಪೆಲೆಂಟ್
ನಂಬರ್ 7.
ಎಷ್ಟೊತ್ತಾಗತ್ತೆ ಇಬ್ಬರದು ಕೂಡ್ಸಿ?
ಅವ್ರದ್ದು ನಾನು ಸೇರ್ಸಲ್ಲ ಬಿಕಾಸ್ ಇಲ್ಲಿವರೆಗೆ
ಅಲ್ಲ ಅವ್ರದ್ದು ಇನ್ನು
ಬೇರೆ
ನಿಮ್ದು
ಬೇರೆ
ಎಷ್ಟಾಗುತ್ತೆ
ಬೆಂಚ್ ಬೇರೆ ಬೇರೆ ಬೆಂಚ್ ಮುಂದೆ ಒಂದೊಂದು ತಾಸಾಗಿದೆ ಇಲ್ಲಿವರೆಗೆ.
ನಿಮ್ದು ಎಷ್ಟಾಗುತ್ತೆ ಹೇಳಿ, ನಾವು ಅವ್ರಿಗೆ ಕೇಳ್ತಾ ಇಲ್ಲ.
ನಮ್ಮ 1 hour ಆಗುತ್ತೆ.
ನಿಮ್ದು ಹೌ ಮಚ್ ಟೈಮ್ ಯು ಮೇ ರಿಕ್ವೈರ್?
45 minutes.
Then go before the roster bench. ಆದ್ರೆ ಇದೀಗ ಆಗ್ತಾ ಇದ್ರೆ ನಿಮ್ಗೆ 2012 ಮ್ಯಾಟರ್.
This bench is very convenient.
Correct, we were about to hear now.
Again, we have to start
Now it is
again.
3:53. Both of you say
No,
that each of you
One
require
more day.
1 hour. So now 5.
One more day, my lord. Only one more day. Any day your lordship says convenient, I will.
We have to sit for this
Yeah.
only.
I don't think my friend has got any objection.
It's
I have no
already
objection because
2012 matter.
off started. Everywhere it is stop started. That's the only problem.
ಈಗ ಮಾಡಿದ್ರೆ ಏನಾಗುತ್ತೆ ಅಂದ್ರೆ ವರ್ಚುವಲಿ 1 week there are no ಅಂದ್ರೆ ವರ್ಕಿಂಗ್ ಡೇ ಯಾರೋ ಒಂದು ಏನಾರ ಆದ್ರೆ 1 ವಾರ ಹೋಗ್ಬಿಡುತ್ತೆ. ಯಾವ್ದಾದ್ರು ಡೇಟು 6th ಇರ್ಬೇಕಲ್ಲ. ಅದೇನು ಏಪ್ರಿಲ್ ಎಲ್ಲಿ ಅಲ್ಲಿ ದೊಡ್ಡದು ಹಾಕಂತ ಹೇಳಿರ್ತೀವ ಅದು ಅಲ್ಲಿರೋದು ಏಪ್ರಿಲ್ ಈ ಕಡೆ ಲೆಫ್ಟ್ ಸೈಡ್ ಅದು ಏಪ್ರಿಲ್. ನೋಡಿ ಈಗ 8th onwards ಅಲ್ಲಿ ಡೇಟ್ಸ್ ಇಲ್ಲ. ಈಗ ಇವತ್ತು ಆಲ್ರೆಡಿ ಫಸ್ಟ್ ಈ ವೀಕ್ ಅಲ್ಲಿ ಮತ್ತೆ 5th ಕುತ್ಕೊಂಡ್ರೆ ಆಗೋದಿಲ್ಲ. ಅದ್ರ ಮುಂದೆ ಸ್ವಲ್ಪ ದಿವಸದಲ್ಲಿ ಮತ್ತೆ ವೆಕೇಶನ್ ಬರುತ್ತೆ. ಗೋ ಬಿಫೋರ್ ದ ರೋಸ್ಟರ್ ಬೆಂಚ್. Both counsel submit that they may require 2 hours. Further 2 hours. 2 hours for hearing. Matter is released from parted list before the roster bench. ಮತ್ತೆ ಬರ್ಲಿಲ್ಲ ಈಗ ಅಂದ್ರೆ ವೆಕೇಶನ್ ಬೇರೆ ಬರ್ತದೆ.